protocols observed, allow me to share my reflections on my paper entitled Adopting Contextual Approaches and Strengthening the Capacity of States to Implement the Decisions of the African Commission, starting from the premise that implementation remains problematic. Implementation of decisions of the African Commission remains problematic within African Union member states. I take note of the gains that the Commission has made as a way of my introduction, over the years, since its establishment, the Commission has made numerous gains in encouraging states to implement its decisions. But however, in the past decade or two, we see that although the Commission has been trying to help states to comprehend their obligations, promoting consistency in human rights implementation, interpretation, policy development, and legislative reform, normative and institutional advances made by the Commission, we see that our continent is going through numerous governance and human rights challenges, which persists and are significantly impeding the enjoyment of human and people's rights. We see various governance and democracy indicators, particularly the Afrobarometer, we see the World Bank, we see the Freedom House, among others, noting democracy decline within the African Union. So it is against this backdrop that I propose, or I argue, that at this stage in history, the African Commission need to adopt contextual approaches, particularly in less democratic and struggling states, so that these states could be strengthened in terms of their capacity and also their understanding of the decisions of the African Commission. So tapping into context is our key approach, as I argue in this paper. So what's the problem that we are addressing? The problem is democracy and human rights decline. Africa is experiencing serious governance issues, particularly the resurgence of coups, conflict, violent extremism. There are a lot of issues raised in terms of environment, particularly those that are harmful to African peoples, the African populations, particularly caused by extractive industries and multinational corporations. Government development-induced displacement in local communities, migration, forced migration, among others, and accountability of governments, to mention a few. These are all challenges faced within African Union member states that are causing much challenges in terms of the relationship between the states and the Commission. Recently, we see a resurgence of contested elections, which are at the core of governance, which then impede various human rights enjoyment within member states. So I am arguing that at this stage, the AU it is doubtful whether the AU at this stage, given all this, it's doubtful whether the AU's advancement of human rights is on track, given that it's facing complex and multifaceted problems in terms of governance and human rights. So this leads us to a thinking of a different approach, which I propose, that a contextual approach in helping the African Commission help states comply with these provisions. So how can the Commission do things differently? That's the person, the research person of this, in terms of its mandate, which is stipulated under Article 45 of the Charter. And how can the Commission adopt a different attitude in terms of encouraging, or a different approach in terms of encouraging states to implement its decisions? That's a follow-up question to the main question. So we see that the Commission, since establishment, has been using special mechanisms, particularly special rapporteurs and working groups to conduct various promotional work, particularly various missions, country visits, among others, that are aimed to encourage states to adopt these decisions and implement these decisions. So in my view, I think at this stage of the Commission, for the Commission to be more effective, they need to revisit the way the country visits have been made in the past. How frequent has this been, country visits, particularly in less democratic states? The delegation, the size, the duration of these missions, and also whether a localized approach has been adopted in the past, particularly working with local stakeholders who have influence in this part, in this mission, in this country visits, particularly traditional leaders, religious leaders, among others, and we need to interrogate to what extent if they contributed to the success of the African Commission's work, particularly in encouraging states to comply with its decisions. One thing we note at this stage is that within the African Union, several authoritarian or less democratic states, they are using the idea of state sovereignty to exercise control in terms of the decisions of the Commission, and also in terms of its relationship with the regional economic committees in the African Union. So you see that the less democratic states often has been hostile to missions like this, missions that particularly working groups or special rapporteurs. We see also surveillance by host states to these missions. So there's been states that are very authoritarian or less democratic states have been so over-obsessed with the idea of sovereignty. And it has been problematic to such an extent that it often affects the state's relationship with the African Commission or with the AU in general. So there is need to engage states in terms of the nuances around the notion of sovereignty, not only sovereignty to be understood as the traditional sense of protection of states having its part, also to have this idea of human rights philosophy, which is deeply embedded in the notion of sovereignty. It seems that many African states, they have stuck and been very stagnant in this idea of traditional in the traditional sense of sovereignty. So the Commission also needs to then engage with helping states to understand the idea of sovereignty, new approaches to sovereignty that has emerged with the human rights discourse. We see that the Commission interacts at a deeper level with NHRIS. So the question is, how can the Commission work differently with NHRIS and CSOs, particularly in less democratic states, and how can the Commission adopt a contextual approach? So the Commission, in my view, needs to look at case-by-case basis of states, particularly less democratic states. What are the challenges they are facing? What kind of stakeholders could be engaged in terms of the NHRIS or civil society? Because most civil society in NHRIS, they are facing severe restrictions within less democratic states. Severe restrictions, lack of operational, you say that they are under-resourced, particularly in NHRIS, so that they cannot fully exercise their mandate. And whereas the CSOs, they're facing so much hostility. Giving an example of Zimbabwe recently, with the adoption of the patriotic Act and the PVO Bill, Private Voluntary Act Bill, which Private Voluntary Organization Bill, which aim to restrict and shrink the civil society. So how can a country facing such in terms of the operation of the NHRIs and CSOs receive maximum help from the Commission? I propose that the Commission needs to look at this situation's unique and tapping into a strategic advocacy where there is targeted people of influence, particularly traditional leaders. They can be used, they can be trained and coached to have human rights philosophy in their work, so that they have a contribution, a meaningful contribution to help the states implement the decisions of the Commission. So I propose that in strategic advocacy, the Commission, while engaging hostile and less democratic states, strategic advocacy is a deliberate and planned approach to promote a specific cause and advocating for particular issues. I believe that the Commission at this stage needs to perhaps have selected issues that instead of encouraging states to implement a number of pending, perhaps having a smart approach where the goals are specific, measurable, attainable, relevant, which are called smart goals, whereby it's better to have small gains than to have no gains at all. So perhaps maybe the Commission should focus its efforts on those goals that perhaps they have potential for gains, and more resources and more energy and more time must be perhaps concentrated on those possible gains or those more. This is not to say that over the general overall promotional activity must be put at hold or must be minimized. So coordinated and research analysis between the Commission, NHRI, CSOs, traditional leaders, and religious religious groups within states could help. Finally, I would like to propose use of local languages, use of local symbols, use of customary acceptable messaging to help, that can be adopted by the Commission to help states to understand the obligation, and also to help states. I think this kind of messaging and this kind of approach, a localized approach, could yield some gain, in my view. And I think using these could, I think I have a minute to go, could also be used by the Commission to communicate human rights philosophy or human rights concerns using the local language, the symbols that are acceptable within states. So context by context, studying symbols, studying targeted type of messaging that could work, studying customs using these, and also using the traditional leaders could be a one way among other ways that could be used to help states understand human rights in their own vernacular, in their own custom, in their own tradition, and also to help them then respond favorably, particularly the less democratic states, to the concerns and advocacy done by the African Commission. I submit.
Thank you. Thank you so much, Mr. Tandai. Really, he deserves a round of applause. That's exactly 50 minutes. We really appreciate for the time management. Mr. Tandai is based in Zimbabwe, as he indicated, and he's currently working as an assistant election analyst to the European Union Election Observation Mission. in Zimbabwe, but also he's also working on his PhD studies. We have other panelists here present. As you can see from the program, Mr. Jonathan is a legal associate at the Office of the Legal Counsel of the African Union Commission. We have Professor Clara from University of Ghent, Belgium. I will not try to introduce her. As you can see from her bio, she's well-established human rights professor. So we will also hear from her. We have Dr. Jafet, an alumni of the center, as he indicated yesterday. He's currently working at Amnesty International. He's been working with the African human rights system in different capacities for a long time, I would say, assisting the mandate of the Commission, but also the mandate of the African Committee of Experts on the Right and Welfare of the Child. So I think Ms. Abiola, as a respondent for this panel, I'm sure Mr. Tandai has raised a number of interesting points and interesting issues for you to reflect on. And maybe we can also go back and somehow challenge some of the assumptions, if there are assumptions in his paper, that whether the Commission has been using already a contextual approach to his activities or not is something that we need to question, after all. If there are any experiences from the Commission in undertaking its activities, how it contextualizes and how it responds to different contexts and different governance systems in less democratic countries. I'm sure particularly during the experience that the Commission is having during the AU summit, during the activity report, when the activity reports are presented, and the way these less democratic countries are actually responding to the activity reports and draft decisions of the Commission would be of very much interesting to share to the group. So I will not try to summarize in the interest of time, but I'm sure you have picked up some of the issues that Mr. Tandai has raised. Thank you very much, Mr. Tandai. Now, Jonathan, you have, I see you have set your timer on, so you have 15 minutes. The good thing is you are here, so we can just tell you to, we can just wave our hands for you to stop if you're going to go beyond the time. So you have the floor, sir. All right.
Thank you very much. Good morning. My name is Jonathan Obogi, as you've been told. I think I should also mention from the onset that I am also an alumnus of the center. And today I wanted to talk about, the topic is decoding the impact, more like trying to link the implementation of the Commission's decisions to the national human rights progress. Particularly, I want to look at the democratic index of some selected countries and whether their positions or standings in terms of human rights, respect, democracy, in a way translates to their implementation of decisions by the African Commission. As the earlier presenter has mentioned, the Freedom House, for instance, ranks African countries on their democratic index. And I cherry-picked some countries because it ranked these countries into their countries that are perceived to be free in terms of democracy. There are those that are partially free, and there are those that are not free. Interestingly, these countries, some of them have had communications presented before the Commission, and the Commission has rendered recommendations. I particularly picked 3 countries, that is Botswana, Kenya, and Ethiopia, because these 3 countries fall in the 3 respective categories. There is the free, the partially free, and the not free. So the question this morning that I want to pose is whether actually the implementation or failure to implement the Commission's recommendations mirror the national human rights standing in those countries. So to start off, I will use the cases that have been cited by the Commission to, in a way, position these countries' progress in terms of implementing the recommendations, and as well to, in a way, link, the human rights progress and those recommendations implementation. Botswana is ranked by the Freedom House as one of the free countries, and Kenya is ranked as a partially free country, whereas Ethiopia is a not so free country. So for Botswana, I picked a case known as the John K. Modise case, which essentially involves the issue of enforced statelessness or citizenship erasure, where the applicant in that case, which is Modise, had been deported to South Africa because the Botswana government had claimed that he was not a Botswana citizen. And this is after he had founded an opposition party. The facts are that he was born of a Botswana father to a South African mother. The father was working in South Africa, but soon after the mother gave birth to him, they moved back to Botswana. There was no problem up to until when he formed the opposition party, when the Botswana government realized that actually this is not a Botswana citizen, and then was deported back. And South Africa also deported him again back to Botswana because he was not a Botswana, he was not a South African citizen, which eventually then meant that the Botswana government took him to a no man's land, subsequently prompting him to move the African Commission. The African Commission then made recommendations. And probably Japhet will also deal with that issue. It's important to note that as we even talk about implementation, we must be mindful of the difference between implementation as a broader term and compliance. Because implementation is the process, which I think goes in line with Article 1 of the African Charter that calls upon the states, the member states, to come up with legislative and other measures to give effect to the rights in the Charter. So the African Commission, as you would see, they would give some recommendation that require a one-off step, that is a one-off implementation. You're required to pay reparations, pay this amount of money, or realize this particular person. But there are other recommendations that actually call upon the member states to put up measures, which would mean that the effect to this particular recommendation would be both to that victim and the general populace. In the Modise case, it was more of the commission required the Botswana government to first recognize Modise as a Botswana citizen by descent, and two, to also compensate him. And in all those, in those two recommendations, the Botswana government, which is a free country as per the Freedom House, has never implemented. Now, moving on to the next country, which is Kenya. Yesterday, somebody mentioned that Zimbabwe has been a very good client of or visitor of the Commission. I think Kenya has also been an interesting visitor to the Commission and the court, and interestingly so, on very decisive cases that have got some far-reaching consequences. For example, the issue of recognition of the indigenous people. And I picked that case, the Endoroy case, which the African Commission, for the first time, made very important pronouncements recognizing the indigenous people, the Endoroy people as indigenous people, and their right to land, which when the Endoroy people had been forcefully evicted from their ancestral land, but when they sought local redress, the High Court stated that the Kenyan laws cannot, in a way, give them the redress as a community. And scholars have also argued that there is that notion that all Africans believe they are indigenous by dint of being an African. But then the African Commission was emphatic in noting that, in giving out descriptions of who is an indigenous person. But most importantly, it actually went ahead to give 7 recommendations. And in those recommendations, it required the Kenyan government to recognize, first, of course, there is that recognition of them as indigenous persons and allow their society to be registered, but also to involve them in the decision making, because they were displaced from their place because the Kenyan government claimed they wanted to make that a conservation place and, tourism and whatnot. But in those 7 recommendations, the Kenyan state, which is a not so free state, has, in a way, implemented some of the recommendations. Whether or not actually they have done it because they were asked to do so by the Commission is another question. The Kenyan government adopted a constitution that for the longest time has been called a new constitution, but I think 13 years down the line it's no longer new. So it adopted a constitution that has been termed as progressive. And because of that, the government has allowed the registration of the Endoroy Welfare Council. It has also allowed the council to be partially involved in the management of the Lake Bogoria National Reserve. The Lake Bogoria is where it's a water resource. It's an area whereby the Endoroy people would use for their own cultural activities or even to feed their animals. And since they had been pushed out, the council has been partially involved in the management. One scholar who is going to take the next stage calls it a tokenism compliance, whereby you're given a partial, access, or even in terms of the royalties that have been given to the Endoroy people. My paper, I try to take a different approach and say that without necessarily being too harsh to this dialogue of the African Commission recommendations and how they have not been implemented, I go forth and state that without the African Commission's recommendations, probably most of these issues that were not addressed domestically would not be addressed had it not been the African Commission's recommendation, the presence, the continental presence and pronouncements. However, it is also important to note that much is yet to be done by the Kenyan government with regards to the implementation of the 7 recommendations, because the Kenyan government did form a task force to look into the issues that were raised by the commission, which includes involving the enrolled people in the management and the process of actually dealing with the Lake Bogoria area. But interestingly, that task force vanished into thin air. Its report has never been made public, and nothing much has been done about it. Lastly, in the interest of time, I will look at a very interesting case that emanates from a very interesting country. So Ethiopia is ranked as a not-free country. There was a case that involved a young lady. It's a long citation, but it's, I will say, EWLA versus Ethiopia, where a young lady, a 13-year-old, was abducted and repeatedly raped. The perpetrator was then arrested and released on bail, after which then he abducted the young lady and raped her, subsequently forcing her to sign a marriage certificate. Now, after the matter went to court, the courts, of course, in a way validated that marriage certificate because of what they call marriage by abduction. When the matter went to the commission made specific recommendations and general recommendation, in my own bifurcation or rather distinction, to say that the specific recommendations were particularly geared towards giving redress to the victim, Zebena, which was the payment of a particular amount of money, I think 150,000 US dollars, and also requested, or rather made recommendation to the Ethiopian government to repeal the laws that allowed marriage by abduction. But by the time that recommendation was being made, I think the Ethiopian parliament had already repealed that. My argument is that the African Commission, or rather that case, played an important role even to that repeal, because then it generated the discussion, you know, whether or not the discussion had been generated right after it went to the African Commission, or by the time this case was being had in the domestic courts. But as to whether the young lady was actually compensated, I tried looking on the available material. There is nothing as to whether she was actually compensated. However, the Ethiopian government has stated that they have done right by it by building a house for her and also giving her a job, which is clearly not what was required of them. But as you can see, countries also have a particular way of saying this is what we've done in advancement of what is required of us by the African Commission. As to the repealing of the laws, as I mentioned, those laws were actually repealed way before the Commission rendered its decision. But as we speak, there are cases or issues that have been reported of marriage by abduction, which still continue to ravage through the country. And again, which poses the question of, as to whether these recommendations have been fully implemented or not. In conclusion, I state that the African Commission's decisions and recommendations are important. And you can see their importance, especially in countries that have been ranked as not so free or partially free. And ironically, those that have been ranked free have failed to implement those recommendations. So the conclusion I'm making is that there is no, it's not more of, you know, a direct link between the country's ability or the country's willingness to implement the African Commission's decisions and their ranking. Because there are so many other factors that are used to rank a country in terms of their democratic index. And lastly, also to state that in as much as, and I've listened to presenters since yesterday, on how the African Commission need to do more in terms of ensuring that there is implementation of their decisions and recommendations. But also it's important to appreciate the positive impact that the African Commission has had on respective countries. Because some of the things that have actually, laws that have been changed, have been as a result of these recommendations. I think that is all from me.
Thank you very much. Thank you so much, Jonathan. That was a very clear presentation. Was you know the project, right?
Yes.
You're projecting?
Yes.
From that. Okay, but okay. So yeah, that was very interesting. Was a very interesting conclusion as well. Something that we may need to reflect on. Whether there is, you've said that there is not necessarily, there is no direct link between that kind of democratic ranking and implementation of decisions. I think this is something that we need to interrogate and reflect on as part of our discussions. Whether there are other evidences and premises which could actually help us to build on to reach at this kind of conclusion. That's very interesting. But for me particularly, it's very interesting to chair a session where Ethiopia is regarded as so not free country. Yeah, that's very well noted as well. That's on a lighter note. Dr. Nkata, we acknowledge your presence. Welcome. We missed you yesterday. Yeah, so Professor Clara Burbano, right? Yeah. You have 15 minutes. We set. Maybe you may direct it towards that, Prof. Listen.
Good morning, everyone. First of all, I would like to thank the organizers of this international conference, and especially my colleague Foluso Adehalu for having invited me to this academic event. I feel truly honored to be here next to so many renowned scholars, members of the African Commission and the African Court of Human Rights, and other practitioners. As it was already mentioned, my name is Clara Burbano Herrera. I am originally from Colombia, and I am a professor of human rights and director of the program for studies on human rights context at Ghent University in Belgium. And before I start, I would like to make 3 remarks. The first one, as you can already see from the title of my PowerPoint presentation, my presentation will not focus on Africa. With my presentation, I would like that you travel with me to Latin America to see our differences, but also similarities as to human rights issues, and especially on the issue that brings us today to this academic event, the implementation and impact of human rights decisions. The second remark, today I will talk about Impactum. This is a research project that aims to assess the impact of urgent measures in protecting at-risk detainees in Latin America. This research project is funded by the European Research Council. I am currently working on this project with a team of 6 researchers, including myself. The project started in December 2022 and will end in December 2027. The latter means, and this is my third remark, I will not be able to talk about findings because I don't have yet them. I will talk about the design behind this project. And here I would also like to mention that the concern about low rates of compliance of human rights is global, as someone yesterday mentioned. Within the Inter-American human rights system, we are concerned about this issue too. In this context, and in a very general terms, I will hold that when we analyze human rights decisions, the so-called compliance approach is limited in its analysis. And that's why we need to look at impact. Two, in this way, perhaps we will be able to explain, for instance, why despite of the fact of low rates of compliance of human rights decisions, the number of requests, for example, of urgent measures, what you call here provisional measures, within the African human rights system, increase every year in Latin America. Therefore, my objective today is to show you how I intend to analyze impact beyond compliance of a specific legal tool called urgent measures in the Americas. As mentioned, I will present to you Impactum. This is a research project that aims to assess the impact of urgent measures in protecting at-risk detainees in Latin America. Let's look at these people, for example. They are currently in prison in El Salvador in overcrowded conditions. Even during the Corona period, most of the time they didn't have access to clean water, soap, or medical attention. Similar situations can be found in various prisons across Latin America. When detainees are kept in dangerous conditions, international human rights organs, such as the Comité Against Torture, the Inter-American Commission of Human Rights, the Inter-American Court of Human Rights, and the Human Rights Committee can protect them by ordering urgent measures. In practical terms, this means that the human rights organs request the state in question to provide the detainee with clean water, soap, medical attention, or better safety. In short, urgent measures aim to protect individuals in danger and thus prevent further human rights violations. Despite their importance, urgent measures have received little academic attention. All legal scholars, including myself, have examined urgent measures following the doctrinal approach to assess compliance. This approach examines legal aspects, focuses only on the beneficiary, is based on desk research, and usually relies on the information provided by the human rights bodies. Although important, this approach in my opinion, is limited in its analysis because urgent measures often face practical, political, and financial constraints. For this reason, I propose to study the impact of urgent measures. In my view, to truly assess urgent measures, we need to look beyond the compliance approach to a broader interdisciplinary examination of urgent measures. This deeper analysis, which I proposed, informed by legal constructivism and transformative constitutionalism, would examine how urgent measures are applied in practice, would consider the legal, institutional, and political context in which they are implemented, assess the impact of urgent measures on detainees and beyond, discuss their strengths and limitations, and analyze any wider learning effects for the states and the human rights bodies themselves. The project will apply a qualitative approach and desk research involving documentary review, interviews, and empirical case studies. The documentary review will include analysis of newspapers, national policies, judicial decisions, and laws. We will interview at the national level stakeholders such as the persons deprived of liberty, their representatives, their relatives, judges, politicians, legislators, journalists, members of NGOs, and scholars. At the international level, we will interview judges and commissioners of those human rights bodies and the staff of the secretariat of those human rights organs. This qualitative approach will allow us to get an in-depth understanding of how key actors perceive urgent measures and identify the factors that affect their implementation. The project will comprise 3 phases. The first one includes an examination at the international level, which allow us to collect, select, and analyze urgent measures adopted by 4 human rights bodies, namely the Inter-American Court of Human Rights, the Inter-American Commission, the Human Rights Committee, and the Committee Against Torture. This means 2 human rights bodies of the United Nations system and 2 of the Inter-American Human Rights System. And we will look at 6 countries. They are Peru, Colombia, Ecuador, El Salvador, Guatemala, and Nicaragua. Substantive and practical criteria were taken into account to select these countries. They are most similar in type. These states have ratified the relevant regional and international human rights treaties. When human rights bodies supervising these treaties have competence to adopt urgent measures, and they have done so, these countries kept persons deprived of liberty in poor or deplorable conditions. Moreover, from a political, historical, and institutional perspective, these 6 countries share common intrinsic characteristics. They are all members of the United Nations and the Organization of American States. The countries all have recent constitutions that give a special primacy to international human rights treaties. And they also share extrinsic characteristics, such as recent stories of history of violence in the form of civil war and military dictatorships. Since the late of the 80s, they all have been in democratic transitions, but they are not yet fully consolidated democracies. The second criteria is the practical one. I took into account the need for physical safety of my research team. The language was also a criteria. And finally, I took into consideration my local and international contacts. In each country, I have experts who have accepted to support the project in the field and the field research in particular. The second phase includes empirical case studies involving field work. This will allow us to get a contextual understanding of how urgent measures are both enforced and understood at the domestic level. The aim is to get to know what actually really happens when the urgent measure is adopted, how political bodies and other actors respond to them, for instance, by encouraging the development of new laws, judicial decisions, policies, or even the publications of opinions in newspapers. The team will analyze the arguments behind those responses and examine the extent to which they have changed over the time. The team will integrate how responses to urgent measures are influenced by the social and political context. Furthermore, we will examine whether urgent measures have created an opportunity to critically discuss the rights of detainees. The aim of this scientific approach is to gain an in-depth understanding of the impact of urgent measures in a context-specific manner, rather than by using a model that affirms absolute universality. In the third phase, we will conduct a cross-contextual analysis to examine similarities and differences in the implementation of cases within states and between states. We will examine how domestic actors react depending on which human rights body issue the urgent measure. We will analyze if there are similarities and or differences in the implementation of cases at the national level. For instance, by examining how this varies according to whether the detainee is a migrant or a national citizen or a woman as opposed to a man or someone from the LGBTQI+ community. Additionally, we will analyze if the state responds in the same way to all human rights bodies, or if there are differences depending on which human rights body grants the urgent measure. My project is carried out by 6 researchers, including myself, trained in law, political science, and criminology. We are supported by local experts and by an international advisory board. In total, 12 renowned professors and members of this international advisory board. Some of them are also members of human rights bodies. For example, the professor that you see on the top, the first one, Professor Yulisa Mantilla. She is professor at the University Catholic in Peru, and she's also commissioner of the Inter-American Commission of Human Rights. Professor Ferrer MacGregor he is professor in the university in Mexico, and he is also judge of the Inter-American Court of Human Rights. Professor Paulo Pinto Albuquerque is also a professor in Portugal and former judge of the European Court of Human Rights. Prominent professors such as Professor Franz Billon, the director of the Center for Human Rights here at Ghent University, and Professor Ifhab, just to mention some of them. Also important to mention that some of them have a background in law, others in criminology, and others in political science. We are also supported by an ethics advisor, Dr. Ipo Fen, who has an extensive experience on ethical issues and guiding European projects. Impactum is important for 2 reasons. Firstly, as the prevention of human rights violations remains a generally under-examined topic within the human rights scholarship, further study of this unique mechanism can teach us a great deal about prevention in general. Secondly, human rights bodies currently adopt urgent measures in a mechanical fashion without analyzing whether they effectively protect detainees. This project can help reduce that the limited time and resources of these human rights bodies are wasted. With this project, I hope we will be able to produce the first interdisciplinary study on urgent measures, which will provide new insights into the relevance of assessing the impact of urgent measures. My project will open up a new research direction of how to analyze this important tool. At the same time, I will contribute to a better understanding of the problems related to the application of the human rights guarantees. I strongly believe that this project is not only academically important, but we will have real practical applications. Thank you very much. And I am also happy to introduce my Impactum team.
Thank you so much, Professor Clara, for presenting that very interesting initiative. This would also, of course, help us to draw inspiration from other jurisdictions, and of course, the academia to also see and adopt a contextualized but also similar approach to assess impact of the decisions and of course provisional measures or urgent measures of the African Commission on Human and People's Rights. Thank you very much for taking us through the justification, the rationale behind the methodology that you're using would be very much of relevance to the discussion that we're having. And it's very interesting to hear the distinction that you've made between compliance and impact. And this is also something for us to reflect on as part of our discussions and reflections immediately after the presenters, but also our respondent. Dr. Jafet, you have the floor. As you have seen, you know, there is no way that you're going to be rewarded with the bribe that you've given me yesterday. So you have 15 minutes to take us through your presentation. You have the floor, sir.
Now that I'm on this side of the table, I can confidently say that 15 minutes is not enough to make a substantive presentation. But I want to speak on the impact of country-specific resolutions of the African Commission. I have my PhD focused on the impact of the resolutions of the African Commission. I have written and published separately on the impact of the thematic resolutions of the African Commission. So today I want to focus on the country-specific resolutions. And my presentation basically is about telling you some two stories that may try to demonstrate the impact that the African Commission may have when it puts its recommendations into action. Just to remind us some of the basic things is that the Commission adopts three types of resolutions: thematic, country-specific, and administrative resolutions. I'll not go into the specific details of each of them. For the country-specific resolutions, really is targeting specific countries to highlight and spotlight the human rights situation in that country. So it may play a naming and shaming role to name the country that is violating human rights and where abuses are taking place. It may also serve as an early warning or a preventive tool. In 2010, the African Commission adopted a resolution ahead of the 2010 World Cup here in South Africa. And it said that the World Cup presented a backdrop for possibility of trafficking in women and children. So the violations and abuses had not yet taken place, but the African Commission was warning of the possibility of that context providing a conducive environment for human rights violations. But it may also use country-specific resolutions as a follow-up tool, actually what we've been discussing here. It has adopted a resolution on Kenya, for instance, on implementation of the Endoro's decision, asking the Kenyan government to implement that decision, or resolution on the situation in Eritrea, asking the Eritrean government to implement its decision in Zegveld versus Eritrea. So these three broad functions of country-specific resolutions. Here is a quantitative analysis that tries to show the number of resolutions that have been adopted over the years. I did this analysis for a 20-year period between 1994 to 2014. I'll not go into these details. I've also done an analysis of the countries which have been the target of country-specific resolutions. You will see that in this 20-year period, Nigeria, I was leading with 7 resolutions, followed by DRC, 6 resolutions. Somalia, 6, also 6 resolutions, and several other countries, including Sudan and Mali, also on top of the list. But I'll not go deep into this discussion. subject matter of these country-specific resolutions, you'll see that resolutions in countries where there is conflict and violence, predominantly the African Commission has adopted 39 out of the 82 country-specific resolutions that I analyzed for this 20-year period, focused on conflict and violence, representing 47.5% of resolutions. This is not surprising if you consider the origin of country-specific resolutions. Commission started to adopt country-specific resolutions in reaction to the Rwanda genocide in 1994, a conflict situation. And that can explain why over the years, actually now, resolutions have been used predominantly for conflict and violence situations. And there are other subject areas that I focused on that can show you coups, economic, social, and cultural rights, non-compliance, repression, and women rights. Now, this is where my story comes in terms of explaining the impact of the resolutions of the African Commission. One of the, of course, I could not be able to analyze the impact of all the 82 resolutions. So I had to narrow down and use a methodology and criteria of choosing the resolutions that I will focus on. And for the study, I focused on 7 resolutions that have very specific recommendations, which you are able to trace and track the resolution to its eventual outcome or impact. So I focused on 3 broad categories: resolutions that ask for the release of political detainees. So for instance, resolution 16 on Nigeria that asked for the Ogoni 19 to be released in 1995 from detention. Or resolution 91 on the situation of human rights situation in Eritrea, which asked the Eritrean government to release 11 former government officials that had been detained. Our resolution 134 situation in the Gambia that asked for the release of Chief Ebrima Mane from detention. I also focused on resolutions that ask the countries to focus on implementation of specific decisions. So resolution 91, for instance, on the situation in Eritrea, which focuses on the decision in Zegveld versus Eritrea, or resolution 216 on the human rights situation in the Kingdom of Swaziland, which focuses on the Swaziland human rights lawyers versus Swaziland, a decision that concerned the proclamation decree of 1973 in Swatini, or resolution 257 on Kenya that focuses on the implementation of the Endores decision. Then fourthly, I focus on resolutions that focus on repeal or reform of specific laws. So for instance, resolution 218 on the human rights in Ethiopia that focuses on reform or repeal of the Charities Proclamation of Civil Society of 2008. Or resolution 89 on the situation of human rights in Zimbabwe, which focuses on reform or repeal of 3 laws in Zimbabwe, including the Access to Information and Privacy Act. Now, if you analyze the impact of these 7 resolutions, it is easy to say that the African Commission has adopted this resolution to almost no apparent impact or to very limited impact. Consider, for instance, resolution 91 on the situation of human rights in Eritrea, adopted in 2005. The 11 government opposition leaders that were arrested in 2005 have not been released, have not been seen up to date, 18 years later. So if you look at that resolution alone, it's possible to say, wow, the resolution has not had any effect. Consider, for instance, the resolution 216 of the human rights situation in the Kingdom of Swaziland. It asked that proclamation of 1963 that puts all authority of the state on the king to be repealed, and that the country goes into a constitutional democracy. Of course, in 2000 late after the adoption of this resolution, the Kingdom of Swaziland adopted a new constitution, but it operates side by side with the proclamation of 1973. The powers of the state still are rested on the person of the king. So you may say that that resolution has not been implemented in any way or has not had any impact. Resolution 257, Jonathan Obogi has spoken about it. Only one aspect of that decision has been implemented, and that relates to registration of the Endores situation. So you can go into each of these and say that the African Commission has had little effect. But to my two stories that may try to nuance and create a better picture of the impact of country-specific resolution. First is Nigeria, where I say it's a pleasant surprise. And here I focus on two resolutions, Resolution 11 and Resolution 16 that were adopted by the African Commission in 1994 and two of these resolutions adopted, Resolution 11 and Resolution 16. But for you to understand the impact of this resolution, you have to go back to June 1993 when presidential elections were held in Nigeria and Moshood Abiola was declared a winner. But Military General Babangida nullified the results of that election and declared himself president after pressure from international community. In August 1993, there was an interim government. But soon after, in November, Sani Abacha, a military general, took over and ruled the country for a period of 5 years, an autocratic period of 5 years. One of the things that Sani Abacha did when he entered into power, he removed the jurisdiction of the courts to deal with human rights situations. He removed the powers of habeas corpus, for instance. He suspended media houses, detained opposition and critics of government, leading to the height in May 1994 when Ken Saro-Wiwa and other Ogoni activists, for instance, were arrested and detained. The reaction of the African Commission was the adoption in November 1994 of Resolution 11. In this resolution, the African Commission asked the government of Sani Abacha to return to the state powers to a civilian government, to the duly elected civilian government of the day. But things did not change. And in that resolution, the African Commission asked that they would like to visit the country to be able to analyze the situation of human rights. But things did not change. In March 1995, another resolution was adopted by the African Commission, asking again the release now of Ken Saro-Wiwa and the others. But again, nothing did not happen. But after the adoption of Resolution 16, now we see a reaction, a chain of events taking place. One, in October 1995, the African Commission, the military government sent a delegation to the 18th ordinary session of the African Commission. What they did in that session was to object to the adoption of those resolutions, saying that those resolutions did not were not adopted according to the mandate of the African Commission. They should have been confidential in accordance with Article 59, an argument that the African Commission dismissed. But at the end of that session, the situation in Nigeria even further deteriorated. Because why? Ken Saro-Wiwa and 8 others were actually executed. So the situation became even worse after the adoption of these 2 resolutions. Now, when the African Commission met with the Nigerian government promised that they will allow a fact-finding mission to Nigeria. And the military government, even though it then executed Ken Saro-Wiwa, a special ordinary session of the African Commission specifically focusing on Nigeria and nothing else took place in Kampala. And these resolutions and what had happened in Nigeria was the subject of discussion. And the Nigerian military government sent a high delegation to that session where the questions of visiting the country was discussed. And eventually, in 1997, the visit took place in accordance to those 2 resolutions that the African Commission had adopted. And we know Sani Abacha died, the Ogoni 19 were released. But the importance of these 2 resolutions is that it managed, out of the special mechanisms that are available at the UN, at the AU, it was only the African Commission that managed to visit the African Commission during this time, leading eventually, of course, to the release of the Ogoni 19. I'll discuss perhaps during question and answers the effect of this resolution. Now, in Gambia, again, a country that has a very close relationship with the African Commission, understand the impact of resolution in this country, you have to go back to July 1994 when Jammeh Yahya took power. Immediately after he took power, the African Commission adopted a resolution 134, asking the African Commission, asking the Jammeh government to return again the state power to military civilian and to ensure that there is constitutional democracy. Another resolution followed in March 1995, again asking now, because many people had been arrested during that period of time, to release those individuals and to allow for constitutional democracy. But nothing happened. And actually for a long period of time, it's like the commission and everyone else now came to the acceptance that Yahya Jammeh was there to stay and there's nothing that they could possibly do. But things significantly escalated in September of 2009, ahead of the 46th ordinary session of the African Commission, when Yahya Jammeh, in a publicly broadcast statement, threatened to kill human rights defenders, including those who will be attending the 46th ordinary session of the African Commission. The result is that in perhaps the most strongly worded resolution of the African Commission, a resolution was adopted. And what did this resolution say? One, it asked the African Union to ask President Jammeh to withdraw that statement. And that if he does not withdraw that statement, the African Union should provide the funds for that session to be held in Addis Ababa. And that if the situation of human rights situation does not improve in the Gambia, then the headquarters of the African Commission should be removed from the Gambia to another country. This is perhaps the boldest resolution ever adopted by the African Commission. Of course, the Gambian government reacted. First, they said, no, we are still committed to human rights. And in any event, this resolution was championed by an NGO, the African Center for Democracy and Human Rights, Hannah Foster. So they went against African Center for Democracy and Human Rights. But the African Commission did even something more than just the resolution. They published a press release. They also sent an urgent appeal to the Gambian government, and then also sent communication to the African Union. The pressure of that resolution resulted in a meeting between the African Commission, the chairperson of the African Union Commission at the time, Jean Ping, and 3 ministers of the government of Gambia, the Minister of Foreign Affairs, the Minister of Interior, and the Minister of Justice, in which they privately backtracked on the threat that had given against human rights defenders and promised that there will be security and safety of the African Commission staff who are based at Banjul, but also all delegates who are going to attend the African Commission on Human and People's Rights at 46th Ordinary Session. I can confidently say that the 46th Ordinary Session took place in Banjul, the Gambia, because I was there. So we were safe, we were secure. But this series of events tells you how the resolutions that was adopted with very strong, very specific recommendations to the AU had an effect on the government of the Gambia. In conclusion, 2 things that one can say about these 2 scenarios. That there is a paradox when it comes to the impact of country-specific resolutions. One is that countries that are repressive, autocratic, appear to be more sensitive to the resolutions, country-specific of the resolutions, compared to relatively democratic states. If you see the countries that react and actually engage the African Commission when they have adopted country-specific resolutions, it is Ethiopia, I'm sorry, Getachew, Gambia, Nigeria in the 1990s, Eritrea. So at any point in time, the most repressive, the most autocratic states seem to be the ones that are actually very sensitive and engage on country-specific resolutions. 2, one of these 2 case studies tells us that the African Commission country-specific resolutions are more likely to trigger impact, trigger reaction and response when they are combined with other avenues and methods and ways of working of the African Commission. So when they are combined with urgent appeals, press releases, diplomacy, and even engagement with African Union institutions. So these two resolutions really show us what can really happen when the African Commission puts its mind on a specific country situation, deploys all the methods that it has in its avenues or toolbox to be able to affect the situation of human rights in a particular country. Thank you, Chair. I think I've extended only by 2 minutes. I've done well.
No, you've done excellent. You've done excellent. Thank you very much, Dr. Japhet. As I have indicated during the introduction, Japhet has been around the system now for a long time, but also assisting us in different aspects. And you can see the institutional memory in his presentation. But also we can see a professor located somewhere in Amnesty International. I don't know what you are doing there. I don't know why you're not coming back to the academia. Thank you very much for the very interesting and engaging presentation, Japhet. Now, you've got a lot of information, Ms. Abiola, but the chair is not very gracious to give you a lot of time. I'm going to give you 10 minutes for you to, okay, I will make it 12 for you, for you to reflect on and address some of the issues. You can just, of course, give you, it's not necessarily an answer, but you can share your views on some of the issues raised by the presenters. You have the floor, Abiola.
Thank you so much, my dear brother Ayaliu. Good morning, distinguished ladies and gentlemen. Again, all protocols duly observed. Let me start by saying that the presentations that I've just listened to were not just packed with a lot of information, but they were presentations that gave me a lot of hope. At some point, I was asking myself, is this our commission that has had all these impacts? It reminds me of why we are where we are and why we're doing what we're doing. It reminds me of the analogy of the half full glass that we keep filling and hoping that someday we will be able to fill to the brim. It also reminds me of a saying by one of the prominent human rights thought leaders who actually contributed to the gathering that we're having today, Professor Christoph Hens, of blessed memory, who used to say to us, I was a student of the LLM program 20 years ago, and he would say, it's a struggle approach to human rights. I never forgot that. I earned my human rights lenses from the center, and that perspective of Professor Hens has stayed with me. And I continue to view what we do through those lenses. Thank you very much for all that has been said and the goodwill that I was able to also pick up from these presentations, as well as the goodwill that the Commission has enjoyed over the years from the diverse stakeholders that engage with it, including your very good selves and someone like Dr. Japhet, who's really been around the system. As I said yesterday, my responses are not necessarily to answer or speak to everything that has been said, but basically to take in these ideas that are on the table and maybe to just give some information that might better enrich and help us to get the best out of the conversation that we're having. My gratitude to Tindai, who made the first presentation. Tindai was also with us at the Commission and added value to the work that we do. I appreciate the perspective that you brought in about the need for the Commission to take a contextual approach to promoting human rights implementation at domestic levels, especially in countries that are less democratic. We've taken this on board. And the issue of contextualization of engagement is also something that the Commission is really taking into consideration. As I mentioned yesterday, the Commission is currently reviewing, clarifying, and seeking to standardize and document its reparations regime. And context is really one of the elements that we're taking a very critical look at, because we believe that it is important. As much as we want to standardize and apply the normative standards at regional level, and of course infuse best practices from other systems, we are also mindful of context and they need to get results. So the idea is to have a results-oriented reparations regime, which takes into account context as necessary. You also mentioned the issue of state sovereignty and the current trend and how this impacts the relationship with the Commission and the wider AU. These are very salient points that you've made. Maybe just to add from where the Commission sits, the first, the African Charter in itself marked a major departure from the pre-charter era, where states did not even want any intervention in their domestic affairs. We moved on to the Charter, where states agreed to start reporting to a supranational body made up of elected officials and to answer to communications that are filed against them, up to the point of the African Court now that now takes binding decisions explicitly on the face of the protocol, as well as what is now envisaged also under the Malabo Protocol, where the court will have criminal jurisdiction. So we're evolving, and we believe that state sovereignty vis-a-vis the protection of human rights is giving way. And with our collective efforts, we will continue to improve upon this. But of course, there is the need to go beyond the text, to engage with live issues. And this is where the issue of context, dialogue, as was mentioned yesterday, especially by Dr. Ayeni, and adaptation as needed in getting results comes in. And the Commission is also taking a lot of efforts in this regard. The Commission is beginning now to engage with member states through the PRC. We had an initial retreat in 2018. It was unprecedented. It's planning another one. It's engaging more specifically now with the PRC Subcommittee on Human Rights, Democracy, and Governance. Just about 2 weeks ago, we made a presentation on the status of ratification of one of the protocols that the Commission is responsible for overseeing. So identifying champions, basically ensuring that we are adapting and evolving in our strategies in engaging states. So, but a lot has been said today, and we've taken all this on board as well. They need to be smarter in goal setting and to revisit working methods. This is important, and this, of course, is going into our strategic planning, which we now engage in. We plan every 5 years now, and we do constant evaluation of the strategic plans of the Commission and to see how things are going. We just concluded the midterm evaluation, and so we're constantly reflecting now on our working methods. What is working? What is not working? Where do we need to make adjustments? Both at technical level as well as at the level of our policymakers. On better engaging traditional leaders and NHRIs, this is very important because this is a constituency, especially the traditional leaders. I believe this is a constituency that has not really been given enough attention. Some things have been done, but there's room for more. And I would just like to say that in particular, the African Center, which was alluded to by Dr. Japheth, is organizing an event relating to the role of traditional leaders in deepening democracy in Africa, and we're partnering with the African Center on this. Strategy for more effective engagement with NHRIs also is something that we've just worked on. Over the years, the relationship of the Commission with NHRIs has improved. We have more with affiliate status. We have a pre-session forum now of NHRIs and deeper and better engagements. And very recently, we developed a strategy with the expert support of Dr. Japheth, and which has now been developed into a plan of action. And you will see a number of those strategies evolving into reality and practice over the next couple of years. To Jonathan, thank you so much for your presentation. Let me first appreciate and agree with your postulation that Article 1 of the Charter is the threshold for compliance with decisions of the Commission. This is the position of the Commission, and we continue to stand by this and the international law principle of pacta sunt servanda. We also welcome the distinction that you made between compliance and implementation, because this has actually it's also at the heart of how we perceive compliance. And it could, if we're not careful with this distinction, which is a very important distinction which you have made, it could create frustration where really there is hope. I'll give an example. For instance, implementation would necessarily be a process if the decision of the Commission is seeking to address a historical, and perpetuated, violations of human rights. For instance, in the Endores case, it started from the 70s. So the Commission's recommendations were also meant to address structural and underlying causes of human rights violations. So this cannot be a one-off instance. So I really appreciate that distinction that you made, because it's very important for those who are looking at the issue of compliance and implementation to understand that implementation is a process and compliance is the ultimate result. So I appreciate that, and it also gives us a better perspective also at the African Commission, and helps us to put things in proper context. I also and I agree with you that, as was said yesterday, that the challenge here is basically, there are impacts that can be, seen in bits and pieces in different contexts, but the challenge here is having a standardized and clearly mapped out and consistent, follow-up mechanism for tracking implementation from the start up until the time that compliance is fully achieved. And we've taken note of the very good practice by the Committee on the Rights and Welfare of the Child, especially in the case of IHRD versus Malawi, as was mentioned yesterday, where there was a clear plan of action from the outset up until the time that ultimate compliance in addressing the underlying cause of the human rights violations recorded in that case was addressed through a constitutional amendment in Malawi. So we think that this is the path now that we should be setting on. And this is possible with the right approach. And our 2020 rules of procedure offers a lot of opportunities to do this. We can now develop practice directions, as I mentioned yesterday. And we also have the possibility of having separate hearings on reparations, which can help to formulate clear roadmaps for implementation of decisions that are taken by the Commission. So this is an aspect that we will be really looking at carefully. Professor Herrera, thank you so much for the presentation of Impactum, which is a very interesting initiative. I followed very closely your presentation. I find the methodology very useful, and I believe that it can be adapted for mapping the current state of affairs at a more modest, ACHPR focus level, but for us to even understand where we are at in terms of the status of compliance, so that we can then carry on forward in monitoring the implementation of the decisions of the Commission. So I believe that my colleague Zelalem was monitoring carefully, was listening carefully, and it also helps us to have a better appreciation of the diversity of expertise needed to be able to carry out this kind of initiative. And the fact that we only shouldn't just track implementation or impact, but we need to understand the trend, the whys, and also be able to develop disaggregated data as maybe applicable in the context. So we really appreciate that. And I think we will be coming back to you to get more information on this initiative, which we really appreciate. Thank you so much. Dr. Jaffes, what more can I say? Thank you very much for the analysis of the country-specific resolutions. And again, it takes me back to the point that was made by Jonathan on the need not to just keep your eyes on a one-off result, but to be able to understand the trend. And this is a perspective that the Commission really also needs to fully understand, as well as to be fully appreciated also by the stakeholders who engage with the work of the African Commission, so that together we can have a more contextual and comprehensive approach to understanding the issue of implementation. Thank you all very much. And we've taken all the wonderful ideas on board. And thank you for continuously enriching the work of the African Commission. I will stop here.
Thank you very much, my dear sister Abiola, for that reflection. Now, we have 20 minutes to close this session, so we can accept few questions or any input or reflection, any intervention from the floor. So someone will help me to see if there are any questions from participants online as well. You will let me know. But in the meantime, anyone from here, from the room, any question, reflection, any intervention? Yes, Lilot.
Thank you very much, Chair. My question is directed to Japhet. Thank you so much for your very fascinating presentation on compliance with the resolutions of the Commission. I wondered why you avoided Zimbabwe, because Zimbabwe is one of those countries that they are always at the Commission. And every time a resolution is passed, they want to respond and to say something and to deny everything, you know. And I just wanted to find out from you whether in your analysis, you looked at all in your nuanced sort of analysis, whether you looked at any even partial compliance by Zimbabwe with the resolutions of the Commission. Thank you.
Thank you. Thank you. Another question? Yes, Sid.
Thank you so much. My question is also directed to Dr. Biagon. I understand that the decisions of the East African Court of Justice have the same standing as decisions of the High Court when it comes to Kenya, at least. So following from this, I also understand that what this does is that when it comes to the execution of the decisions, it sort of clears the path and makes it a bit easier for victims themselves or people who are representing victims. We do not have the same when it comes to the African Commission, whether the resolutions, the decisions, or recommendations. And I was just wondering, would such a move or such a standing have value when it comes to implementation and how the resolutions and decisions are executed? Thank you.
Thank you. One more question from the room here. Do we have anyone from online? No one. There is no one. All right. Yes, Honorable Chair.
Oui, merci pour les questions et surtout pour la manière dont vous conduisez les débats ce matin. Je vais aussi être bref, mais je pose la question à notre ami Japhet. Dans quelle mesure vous mesurez cet impact sur le terrain? Parce que l'un des points faibles de ce séminaire, c'est qu'il n'y a pas les représentants des États. Ceux pour qui nous prenons les décisions, les destinataires de nos décisions, il n'y a pas un échantillon d'État ici pour qu'ils nous disent, qu'ils répondent également à ce genre de questions. Mais alors la question que je vous pose à Japhet, lorsqu'on regarde les deux études de cas que vous avez faites par rapport aux situations de conflit dans les deux pays, donc la Gambie et le Nigeria, est-ce que c'est par supposition que vous arrivez à dire que cette résolution a impacté ce pays sur telle ou telle chose, ou bien vous avez d'autres critères que vous mobilisez pour arriver à dire ça, c'est le résultat de l'impact de telle résolution? Parce que scientifiquement, il est très difficile d'accepter ce pas-là, que voilà, c'est parce qu'il y a eu telle résolution qu'il y a telle décision. Sauf s'il s'agit d'un acte de droit qui a été voté, un règlement, une loi qui a été votée, d'un acte juridique qui a été pris, et qu'on regarde par exemple dans le préambule, dans les motivations pour savoir, il se réfère à la résolution telle de la commission prise au cours de cette période. À ce moment-là, scientifiquement, on a une base, on a un texte qui existe, on sait qu'ils se sont référés à la résolution. Mais s'il s'agit de l'analyse d'une observation des faits, une résolution précède un changement dans un pays, comment vous faites le lien scientifiquement pour savoir que c'est cette résolution qui a produit ce résultat-là?
Thank you, Chair. Clement, I think you wanted to intervene. You have the floor.
Yes, thank you, Honorable Chair. Yeah, I'm used to honorable, but I think you are honorable indeed.
Thank you so much.
Honorable members of Parliament. So I really thank all the presenters, but I'm a bit disillusioned by this conclusion, particularly the paradox between countries with, countries which are very democratic and implementation or non-implementation of decisions. Because I was about to share my own experience as a litigant at the African Commission in Communication 408 11. It involved a number of judges from the DRC who were illegally dismissed in 2009. I think the case was submitted in 2011. A decision, and indeed a very progressive decision, was secured in 2016. And because of the nature of the regime in place, and particularly the regime under which the contested decision was, or the violations were committed, was still in place, it was difficult, if not impossible, to get the decision of the Commission implemented. It took, and for me, the decisive factor was the regime change, not unconstitutional, but a constitutional change of government that took place in 2018. And it opened new opportunities for us and the victims to be able to engage with the new government. In 2022, so last year, those judges, about 98 judges who were dismissed, they were reinstated. And I think it's, I always held the view that probably democratic developments or advances could lay fertile ground for effective implementation of decisions. But I seemed to be disillusioned, and maybe I don't know if it's a view that can be relativized, or I don't know which response or further comment we can get from the presenters. Thank you.
Thank you so much, Clement, for raising that question. I'm sure Jonathan will reflect on that. Martin, you have the floor.
Yes, thank you. My name is Martin Kioko Munyoto. I am joining you from Nairobi, and I have a question to Dr. Biegon with respect to his presentation. And my question is actually specific to Resolution 275 of the African Commission, which was specific to Uganda. And the fact that this resolution, which was adopted after a law that was passed in Uganda in 2014, now led to an even stricter law being passed in 2023, this year by Uganda. And I want to ask in implementing these decisions such that we don't find such harsh backlash from states, maybe taking into consideration the promotional mandate of the African Commission. Thank you.
Did you get the question, Dr. Jaffe? Martin, you were breaking a bit. And Dr. Jaffe did not really get your question. So can you please just say that again in less than a minute?
Yeah, my apologies. I think I will just try to speak without my video. I hope
that would be better. Yeah.
Thank you.
Yeah.
Apologies for that. So
No
my question is specific to his presentation, and I direct him specifically to Resolution 275 by the African Commission, which was specifically against Uganda and which came after a law was passed in Uganda in 2014. And I'm saying that less than 10 years later, we see that Uganda passed an even harsher law in 2023. So my question is, what solutions are available to the African Commission in such cases where after a decision or rather a resolution has been made, there is now even more harsher backlash from the states? And maybe whether there's something we can do based on the Commission's promotional mandate to see to it that we have a better way of approaching such issues. Thank you.
Thank you. That's clear now. Yes. So, Clément, I think that's an old hand, right? That I saw on the screen. He's not asking question again. All right. So, we don't have any more questions. Tanya, you have the floor. 1 minute, please. Your mic is muted. All right, so we proceed. So I'll give you the floor to reflect on the questions. I think most of the questions are directed to you, Dr. Jaffe. So I'll give you 2 minutes. And for the rest of the panelists, I'll give 1 minute each to say a few words if you want to just thank the organizers. So, yeah, so Dr. Jaffe, you have the floor.
Thank you. I've received a barrage of questions. First, Zimbabwe. I focus on only those 2 case studies, but Zimbabwe was also part of the analysis, and Zimbabwe actually responded to resolution the resolution 89 that was adopted against Zimbabwe, and it responded in a state party report that it filed with the African Commission. And its response is perhaps, again, one of the most categorical that the African Commission has received. Zimbabwe specifically said that it's not going to adopt, to review or reform the laws that the African Commission wanted it to do. And actually, in justifying its position, let me just read to you what it says. It says, these pieces of legislations, besides, are not peculiar to Zimbabwe. In this era of transnational terrorism and cyber subversion, they are progressive and appropriate laws. Suffice to highlight that they drew extensively from and are similar to laws from other countries, particularly the security and gag laws in other democracies like Britain, USA, Australia, and Canada. Essentially, it went on and on to justify its position and says it's not going to respect the resolution of the African Commission. Sydney, yes, East African Court of Justice, the East African Community Treaty provides that when it comes especially to monetary judgments, then the civil law procedure of the respective member states of the EAC will apply. So that means if you get a monetary decision from the East African Court of Justice, then you can do the execution procedure as it applies to your respective countries. The African human rights system more generally and the African Charter does not provide for a similar provision. And I think in African context, I think it's only Seychelles in whose constitution says that the laws, the international law shall form part of the law, but also it provides a duty on the state to implement decisions of international and regional human rights bodies. That's in the constitution of Seychelles. For the rest of the countries across the continent, unfortunately, there is no explicit law that provides for execution of decisions of international bodies in the domestic order. In the defunct SADC tribunal, there was a provision in the SADC treaty that provided that the reciprocal judgment procedures of the SADC member states could be used at the domestic level to execute judgments. And that's why Mike Campbell, for instance, executed his judgment here in South Africa. Unfortunately for the African human rights system, there's no similar provision. If such provisions would have existed, then there will be perhaps a higher chance of implementation. To the Honorable Chair about the methodology, unfortunately, time could not allow me to go deep into the methodology of the research, but I begin the research by mentioning exactly what, Honorable Chair, you are mentioning. The methodological difficulty in drawing a causal link between the resolution of the African Commission, or more broadly, a decision of the African Commission and the eventual outcome. Primarily because it's usually very difficult to know the exact motivation that inspires a country to do a certain thing. So you'll find that it has released a political detainee, but it's not necessarily, you cannot, 100% link it to the resolution of the African Commission that said, release this political detainee. And I make those concessions in the study. For instance, the Ogoni 19 were eventually released according to the resolution of the African Commission, but they were released after a civilian government was, after actually Sani Abacha died and a military general took over for a transitional period before Olusegun Obasanjo took over. So this is what scholars have called situational compliance, where there is a compliance with the decision of the African Commission or any other body, but it's because of change in circumstances. Again, in the study, in each of these countries, I make it very clear that there were other forces that played a part in leading to the outcome or the impact. So in Nigeria, for instance, there was pressure even domestically from civil society in Nigeria, for instance, that filed cases even at the African Commission challenging the decrees of Sani Abacha. There was pressure from the United States, from the United Kingdom, from the European Union, from the African Union that really put pressure on Sani Abacha. So there was the African Commission resolution acted within a broader ecosystem of actors. Finally, Klimoja said is dissolution. Brother will encourage you later in the evening. Martin said, wanted to know what can be done about Resolution 275 in Uganda. First, I must clarify that Resolution 275 is not a country-specific resolution. The events and developments that led to its adoption might have been closely tied to Uganda because of the events of the initial Anti-Homosexuality Act adopted in Uganda in 2013 and thereupon. But Resolution 275 does not relate to Uganda exclusively. Actually, Uganda does not appear in Resolution 2, or any other country is not mentioned in Resolution 275. So it's a thematic resolution. The Anti-Homosexuality Act adopted recently in Uganda shows, deterioration of the situation or an escalation of the situation. I think the Commission, as I already said, has many tools that it can deploy in its disposal, promotional vision, fact-finding mission, an urgent appeal. Individuals in Uganda may file communications if they have exhausted local remedies at the domestic level. So there is really a range of activities that can be done to try and address the situation in Uganda.
Thank you so much. Thank you, Dr. Jaffet. Jonathan, you have one minute, please. As you have one question, if I'm not mistaken, to reflect on.
Thank you very much. Mine is to Clement, and to say that it is right to assume that once you have a democratically free country, it is easy to have these countries implement the African Commission's recommendations. However, as we have mentioned, we would have situations whereby the Commission requires a state to take particular measures, which is then requiring these countries to invoke resources in implementing those decisions. And we've had scenarios where countries like Kenya, for instance, in the Ndoroi case, they've gone for the easiest recommendation, which is allowing the registration of the Ndoroi Welfare Council. But these other recommendations that calls upon the country to actually either compensate or even employ, or rather deploy resources, the country has been very reluctant. It is partially free country. Botswana, which is a very free country as per the ranking, has not been able to pay a particular amount of money. What I'm trying to say is what Abiola said yesterday, which is very important, that when you talk about implementation, there are things that you look at: the political goodwill, the legal structure that is in place. And once we have a regime change, there is a presumption that with the regime change comes with the good political will. Sometimes that is a false distinction, but there are times where it could be actually the case. So it would be from case to case basis. And as we go on, you can be able to cherry pick and see that there are countries that have actually implemented, and there are those that have not been implemented, regardless of their rankings.
Thank you so much. Tandai, do you have any reflection to make? Are you still online?
Yes, thank you, Chair, and thank you. And thank you to Madam Abiola and for responding, and to all the participants for the comments. I do not have any comments, but to thank Madam Abiola for such an rich input. I believe that my contribution will make a difference to the discussion.
Thank you. Thank you so much, sir. Prof, do you want to say a few words, please?
I would also like to thank Mrs. Abiola Idowu Ojo for your comments, and maybe I would like to make two remarks. One is that I feel that it's really, really important if we take seriously impact. We need to look at from interdisciplinary perspective. Now I will work with people or researchers who have a background in criminology and political science. But ideally, I would like to include in the team also people with a background in public health, because most of the cases related to persons deprived of liberty, there are many issues related to the right to health, and psychologists. And the last remark, when we do this kind of studies, I think it's also important not only to look at the beneficiaries of human rights violations, or the beneficiaries of urgent measures, but also I think that it's important to look at the family, the impact on their families and communities, that sometimes they are not really visible, but they have also a lot of impact when those violations occurred. And finally, maybe I know that it's a huge project. I received €2 million, but although it seems that it's a lot of money, that's not that much. So I was not able to recruit more researchers. But thank you very much for your comments.
Yeah, thank you so much. Well, that's a good budget. Well, yes, in less than a minute, Ms. Abiola, please.
Thank you very much to all the panelists again. I think in the course of the conversation that followed, there's a very interesting issue that has come up, and perhaps I'm throwing this now to Folusho and Lloyd. Maybe this is the subject matter of a next, conference. And it is the issue of the factors that influence societal changes. And the conversation has underscored first the fact that human rights is a cross-cutting issue. There are diverse stakeholders and players, and that the Commission, as well as the other relevant human rights actors, don't operate in a silo. It also underscores the importance of linking up and collaborating effectively, and the importance also of monitoring trends and the underlying what are the things that both the macro and the micro elements that trigger changes in societies. I think it's very important, because a lot of times we tend to focus on what we do, and we don't link up with the bigger processes. The African Commission on Human and People's Rights is a specific treaty mechanism within the framework of the wider AU. Within the wider AU, there's a whole program on political affairs. There's a whole program on peace and security, which for a very long time were operating in silos. Now they are linking up. Now the Peace and Security Council is to link up with the Commission. The Commission is to report to the Peace and Security Council. Now we have a department that fuses political affairs and peace and security because of interconnectedness. So these are issues that we need to continue to reflect on, to understand that bringing about democratic and governance changes in societies is not we cannot take a myopic approach to it. It requires multi-stakeholders effort and the necessity of linking up the processes and the efforts that we all deploy. Thank you.
Yeah, thank you so much, Debbie. Okay, he's a coordinator, so I cannot say no to him. I don't know what. Okay, please go ahead.
No. I just wanted to respond to Madam Abiola's just to say that, I mean, we've also been thinking about some of these issues, and even in the course of this conference, one of our papers will definitely be looking at the role of the Peace and Security Council in implementing the decision of the African Commission. It's also the reason why, for example, we try to bring in the Pan-African Parliament as well, because we understand the fact that beyond the body that make these decisions, there are cumulative factors that actually affect some of this implementation. And I think you will hopefully Timileyin will do justice to that paper.
Thank you so much. There was one question which we're not going to reflect on it now at this stage from Shania on what initiatives that we have at the international community level, but also within the African Commission on Human and People's Rights, Center for Human Rights, to assess the situation in the Sudan in the context of the current conflict. So I think the next session, there is a presentation on the role of Peace and Security Council and implementation of the human rights decisions. And I'm sure it's going to be a very engaging session. And I think as part of that presentation, if the Commission can reflect on the measures that it has taken to, intervene on the situation in the Sudan, that would be really great. And of course, as part of that discussion, particularly from the organ side, there were initiatives, particularly from 2014, on how we have enhanced our engagement with the Peace and Security Council through the open sessions, the special briefings to the Peace and Security Council, and the role of the AGAS platform as well. So we will reflect on that as part of the discussion that we're going to have during the next session, Shania. Please stay online, and we promise that we'll reflect on that very relevant question in the context of the discussion we're going to have within the Peace and Security initiatives. Thank you very much. Sorry for going beyond the time, like about 5 or 6 minutes beyond the allocated time, but the presenters have done a great job. It was a very interesting session with a lot of information, so they really deserve a round of applause. I hand over to you, the organizers.
Meeting.
Yes.
In the background. I said I'm in a virtual meeting. I'm at the office.
Is that background? Anyway, thank you very much, Session Chair, Madam Abiola, and the panelists. I won't ask for another round of applause. I think we've already done that. So I should have asked for a round of applause. But anyway, thank you very much also for the round of applause. I think we already only have 5 minutes to get into the tea break. So if we could quickly just have a 5-minute break for tea, perhaps we could just get our teas and maybe get back into the room, so that we do not put into so much of the afternoon, and then we can start the next session for the day. Thank you very much. We have tea for like 5 minutes. Yeah, you know, and second terms are allowed, only the third is not. Let me just. Yeah, we can go in with our tea. I'm going. I think we can start.
Yes, that's it. Yeah, just taking over.
Oh, okay. I don't understand why they.
Approach. Because if I had a separate file, and this person has a separate, and you can have a separate, you
Yes.
don't have the capacity.
Yes.
So they are combined entry. That's what we combine entry for everyone, and then whichever group manages to get there first gets all of the best.
That's
things.
like
And then
what
when
happened
like what
yesterday
happened
for
yesterday with lunch.
No, something needs to be. You sent me out.
Yeah. Let me just announce. I think we can start. Closure agent, but we start. Yes, for this session again. Yeah. May we take our seats, please, so that we can start the next session? Yes. Disconnected. Welcome back, colleagues, and sorry for the delay. We're already eating into the time, so we'll just get right straight into the next session, which also looks at the general analysis of implementation and domestic impact of decisions of the African Court. The chair for this session is Mr. Lloyd Couvert, who is our very own Assistant Director at the Center for Human Rights. We have Tamlayeni and Professor Rachel Miro, who join us online, and we also have Neil Palmer, and the respondent will be Madam Eunice Malotha from the Commission. I think that I'll just hand over to you, Lloyd, so that we could start and save on time. Thank you so much.
Thank you so much, Landelani. And welcome to this second session of the day. And thank you so much for your kind attention. I would like to assure the audience, that although I've been awarded a second term in office as chair, I'm not going to seek a third term because it's unconstitutional. Anyway, so thank you so much and welcome. I think this is one session that especially lawyers have been waiting for, because I think lawyers realize that, when they've secured a decision in a court or a quasi-judicial body, the biggest task is implementing that decision. And usually lawyers realize that when the law is no longer on their side, they are pretty much useless and they need assistance from elsewhere. So I think the panelists for this session are going to assist us to explore other methods of ensuring implementation of decisions emanating from the African Commission on Human and People's Rights. I'll just introduce the speakers now, and then so that when they start, we just call upon them to take the floor. The first speaker is Timilean Gabriel Olajuwon. He's a Nigerian national. He's a multi-award winning writer and a development practitioner, and also a peace advocate. And I think he has done a lot of research around the work of the Peace and Security Council. And currently he's the executive director of Muse Peace Foundation. So I think, he says he will really endeavor to really explore the role of the Peace and Security Council in terms of implementation of the decisions of the Commission. Thank you so much and welcome, Timilean. The second speaker is Professor Rachel Murray. Unfortunately, she could not be with us in person, but thanks to technology, she will present virtually. Professor Rachel Murray, she's at the University of Bristol. We have worked at the center with her very closely on the subject of implementation of decisions of international bodies. So she's an expert in this area. She has edited a book titled Research Handbook on Implementation of Human Rights in Practice. Hopefully she can just say a bit about that book as well in a presentation where she's focusing on how the national mechanisms can assist the African Commission on Human and People's Rights in implementation, reporting, and follow-up of its decisions. Then last but not least, on my right, I have Mr. Neil Perma. He's an expert on the rights of persons with disabilities. And he's also currently a lecturer at Middlesex University in Mauritius. And he's going to look at the diplomatic mechanisms as a springboard to enhance implementation of decisions. And I think this is a nice sequel to the presentation by Victor, where he was looking at the usefulness of dialogue in ensuring implementation of decisions of the African Commission. So welcome, Neil. So thank you so much. I think we've got a very good team of experts, and our respondent will be Ms. Eunice Malota. She's a national of Botswana, and she was seconded to the African Commission on Human and People's Rights as a member state legal expert and assisting with aspects of implementation. So I think we have a very good team that are going to assist us in looking at aspects of implementation from different perspectives. So I'll now call upon my colleague, Timilean, to now take the floor. You have 15 minutes to make your presentation. Thank you so much. A round of applause for him.
All right, good morning, everyone. It's a pleasure to be here, and I would like to stand on the existing protocols. And in between, I would like to thank the organizers of this program for the opportunity to be here and to share our ideas with you. Unfortunately, my colleague Lucia Samoa is unable to be here today. And in Assumption, I will be presenting our ideas, the topic exploring the role of Peace and Security Council in implementing decisions of the African Commission on Human and People's Rights, engaging stakeholders for effective implementation. I would like to start by saying Lucy and I, we have background in development, and we would like to welcome as much as contribution that we can actually have to improve on this paper after the presentation. Thank you. So moving forward, I would like to also say that the paper is an exploration of the role of Peace and Security Council as an organ of the AU. And in this regard, we argue that the ACHPR primarily focus on women's rights, but however, its decisions have significant implications for peace and security within member states. And of course, through the proactive involvement of PSC, it contributes to the realization of peace, security, and protection of human rights in Africa. Also, the study also tried to posit that the ACHPR cannot, however, perform its duties without effective collaboration, particularly when it comes to ensuring the recommendation and findings are implemented by member states. Moving forward, the presentation will go into introduction, PSC, and overview, giving an overview of what PSC is. And then we'll try to also look at the interplay between ACHPR, PSC, and then we move forward to the research question, which is, what is the role of PSC in implementing the decision of the African Commission? Since yesterday, there has been interesting presentation on African Union, the role, implementation, and also Justice also made reference to technology as a tool that is needed to be used. And without any gainsaying, I would like to say that despite the African continent's efforts in advancing human rights, ongoing conflicts and war, of course, has continued to infringe upon the rights of its people. And AU has made contributions to this continent's establishment of a human rights system by conducting missions to investigate human rights violations within member states and what have you. But then, one key thing that has been a major challenge is the non-binding nature of decisions. State sovereignty issues and implementation difficulties are the main challenges the AU face implementing its decisions and recommendations. This was also stated by Mrs. Ojo Idowu Abiola yesterday. So let's take a look at PSC. PSC was established by AU through the protocol after that in 2002, and which entered into force in 2003. And it has 15 elected members, which range from 2 years to 3 years, but then there are no permanent members. And its mandate is specifically to ensure conflict avoidance, to say conflict prevention, management of conflict and resolution, especially as clearly stated in Article 3, which states that facilitation and implementation of peace building and post-conflict structuring initiative, the coordination of harmonization of continental efforts to counter the multiple threats posed by international terrorism, the formulation of a unified defense policy for the Union, and the promotion of democratic practice, good governance, the rule of law, as well as the protection of human rights and fundamental freedoms. It would also be nice to state that based on its functionality, the PSC acts as the cornerstone of all peace and security initiatives in Africa as of today. Moving forward, the question is, what is the interplay between PSC and the ACHPR? It has been argued that the relationship between the ACHPR and PSC is viewed as an interdependent partnership to elevate the status of human rights as a vital tool for achieving global security, enduring peace, and sustainable development. However, how does Peace and Security Council functions to keep this human rights focus of the ACHPR? And they do this in through mediation, to say PSC serve as a mediator for further action in enacting decision and declaration when the ACHPR advise human rights violations that unintentionally escalate into conflict or a risk to regional security. Moving forward, another is maintaining international security. It is legitimate for states to protect their populations from human rights abuses, and PSC intervention supports this feat through cross-border security intervention. For example, the peace mission that has actually been done in so many countries, for example, in Sudan and many other countries like that. And also through dialogues and intervention. Someone mentioned yesterday that dialogue is very important. And he also mentioned documentations. And I think Chairman mentioned also diplomacy as part of the view to which the decision or recommendation of African Union can actually be implemented. And also, we like to say that PSC, the interplay between the ACHPR and the PSC is a sense of giving dialogue and intervention. PSC's involvement in member states sparks discussions and intervention that result in the adoption of policies that support human rights and equally promote human security. With this, we also like to state that the interplay we are able to discover is that PSC and ACR, PSC functions in the implementation of the ACPR decisions by advocacy and awareness. The ACPR can work together to raise awareness of important issues that are under the PSC's purview. Vis-a-vis, more so, PSC works to raise the awareness of ACHPR decisions and policies among member states. And with this, we try to answer the question specifically, having understudied the interplay between the ACHPR and the PSC. We look at specifically our question, the first question is, what then is the role of PSC in implementing the findings of a recommendation of ACHPR? And to do this, we try to do, like I said earlier, exploration of papers, and we did a desktop review, method, case study assessments, looking into some specific countries. And then we came across some very interesting view. The role of PSC in implementing and the recommendation and decision of ACPR involves a variety of activities. And then we would like to state just three. The first is follow-up mechanism. The mechanism takes on a role in overseeing and assessing the execution of PSC decisions and resolutions. By doing this, it helps the African Commission to carry out missions, examine the current situations, and offer recommendations. And a case that we try to look into is, example, is a fact-finding missions in Burundi in 2015. And let me quickly delve into a brief history of this. I'm watching my time. In 2015, there was a demonstration against former President Pierre, bid for a third time in office. And the case of human rights violations was brought onto the governing bodies' attentions. And the ACPR put up some reports and recommendations and advise state and non-state actors to resolve the issues through negotiation. For PSC to play this role, PSC, in response to the fact-finding missions, took actions to ensure that the parties settled on an open inter-Burundian peace dialogue, which influenced the political development of the nation and contributed to the holding of successful election in 2020. moving forward, another point we were able to identify is that PSC also plays a role in safeguarding human rights by the use of sanctions and enforcement. Although sanction and enforcement has been seen as what has always been used, but then many people have argued that aside sanctions and enforcement, there is need for dialogue, more dialogue, and there is need for more dialogue. However, to buttress this, we look at the case of Lawrence Gbagbo in Ivory Coast in 2010 and the military diplomatic intervention in Sudan. Because of the time, I might not be able to delve into that, but then the provision of Article 7 of the Protocol of its establishment gave the PSC authority to exercise its jurisdiction. Even though Article 7.1 of the protocol gives the Peace and Security Council the power to impose sanctions on member states in the event of an unconditional change of government. This power is limited in cases where non-compliance issues do not involve a change of government. So this brought us to the case of non-compliance by member states as well. So moving forward, another role PSC plays in safeguarding human rights is conflict prevention strategy. And based on its mandates, the mandate is to prevent conflicts, manage it, and also do a kind of post-conflict analysis. And in this sense, before human rights violations turn into full-fledged conflicts, it is the role of the PSC to step in through efforts to mediate disputes, encourage communication between parties, and promote respect for human rights. An instance is the use of panel of the wise to aid in preventive diplomacy. The protocol fortunately established the panel of the wise to aid in preventive diplomacy. Personality of the panel is essential as a conflict prevention strategy because it will affect how parties see and undo conflicts even before it arises, after it has started, and when issues are actually come up. Then, while we are also trying to do this exploration, we found out that the same way there has been several challenges confronting the African Union, African Commission, the ACHPR, there has also been challenges confronting the PSC. And one of the challenges is lack of finances, which was also raised by Mr. Dewu Abiola yesterday. And also the second one we are able to identify is member state differences in interest, which state that members have different interests. And they only comply to recommendations and decisions based on their own interest. So if the recommendations of African Union or African Commission is not in tandem with the interests of the state, it's obvious that the states might not comply to this decision. Another is political limitations and will. And moving forward quickly is PSC protocol and policy ambiguity. We were able to realize that there is a sense of ambiguity in the framework protocol of the ACHPR, or protocol of the PSC, starting with the establishment of council and continuing through the development of this protocol. It has been argued that institution protocol lacks sound legal foundation. The observation that the wording and clauses of the protocol are subject to different interpretation, which could result in inconsistency in their actual application, give rise to several worries. For instance, the protocol states in Article 16.1 that the AU has the primary responsibility for promoting peace, security, and stability in Africa, while Article 17.1 states that the UN Security Council has the primary responsibility for the maintenance of international peace and security. It's to us, the two articles appear to somehow have different positions on the subject, which perhaps can be a little problem. With this, having examined the interplay, the challenges they face and their roles, we came up with some specific recommendations, which one, we proposed that there should be prioritization of finance, especially contributions by member states. In this sense, we mean that the PSC work and activities, in particular the AFS and CEWS, require both technical and financial strength to be completed. Therefore, in this case, member states must increase their payments to the Peace Fund. And also, furthermore, the Peace Fund funding should be heavily dependent on its member states, each of which has its financial issues. But then we also view it that international funding should actually be, or perhaps to say international contribution, so actually be a must source for funding of the PSC activities, other than a could-be source. That's our proposition. And then secondly, we are of the opinion that use of sanction, incentive, and rewards for compliance and non-compliance. This in a sense means that we know that states, there is avoidance of states to comply to decisions of the ACHPR. And then the PSC also find it difficult to implement these recommendations by ACHPR. And then our view is that there should be a sense of sanction for states that are not complying, and there should be a sense of incentive and reward for states that complies. And with this, we are of the opinion that states that complies, when they are being rewarded, probably we are hopeful that states that are not complying will also possibly learn from this and thereby complying to the recommendations and decisions that are being raised. Moving forward, improvement of personal technology know-how and provision of adequate training. Justice in our paper made reference to this, that there is need for the improvement of technology, and as well, there is the technology that can be used to complete the tasks is just as important as the skill development. So the personnel that are also working in PSC should also be trained on specific technology know-how in which they can also improve themselves, and the use of technology can actually also improve the work of the PSC. Restructuring of PSC policy framework, like earlier said, there is a need for restructuring because it is obvious that the PSC framework from inception, from its establishment to present, has actually not been given a strong legal backings. And then the last but not the least is the promotion of member states for political commitment. Our view is that there is need for PSC to find a way to get the reassurance of member states political commitment, which is not only the work of PSC, but also the African Commission, the ACHPR in its entirety, and it is essential in ensuring compliance with institutions and recommendations. For conclusion, several sections of the African Commission has implication for peace and security, and the PSC ensures that these decisions are enforced and implemented. More so, as a primary organ of the AU's support to ACHPR by the PSC boosts the political monitoring of decisions of the Commission. Therefore, we are of the opinion that in the spirit of working together, the ACHPR needs the support of the AU organs, including the PSC. However, as earlier stated, promoting political commitments, increasing and diversifying PSC funding sources, utilizing technological advancements, and reorganizing the PSC operational framework would be recommended to improve the effectiveness of the PSC. And on this note, I will say thank you for listening.
Thank you so much for your insightful paper there. I think we are looking forward to hearing from the Commission in terms of their thinking on how effective the PSC has been, especially utilization of sanctions, follow-up mechanisms, as well as using the panel of the wise. It will be interesting to hear your reactions, African Commission. We're now moving on very fast because we want to ensure that we don't delay for the lunch break. So I think Professor Rachel Murray is here on.
Yes, I'm here. Can you hear me?
Okay. Thank you so much, Prof. We can hear you loud and clear. Looking forward to your presentation. We have already introduced you. So you've got 15 minutes to make your presentation, and a very special welcome to you. Thank you very much.
Thank you. And thank you so much for facilitating my attendance this way. And I'm really sorry I can't be at this, very important and wonderful event. So I'm going to try and share my screen with you. Please just let me know if this works. I hope you can all see that.
Yes, clearly.
Okay, perfect.
May I proceed?
So we did a big research project which started in 2015, where we looked at a range of decisions from the regional and UN treaty bodies, and we tried to track the extent to which they've been implemented, including decisions from the African Commission. And one of the clear findings from that research was that there are lots of challenges of what happens logistically and practically after the decision is adopted. And I know often the term political will is used, but I don't find that particularly helpful, because I think it doesn't really assist us in getting to the heart of what happens in response to these decisions. So one of the things that's clear is that there are very technical bureaucratic procedures and processes that need to happen at the national level for all of these different recommendations and reparations to be implemented. Things like, where does the budget come from to implement various aspects of the decision? Who do the victims approach to find out how they're paid compensation or receive other reparations? How do the lines of communication work between the various ministries or others who might be responsible for the implementation of the decision? I'm going to move this down here and hopefully you can see that. And so these reparations, these decisions from the Commission and others can involve a whole range of things. So amendment of legislation, training of police or law enforcement officials, payment of compensation, and so on. And the more complex the reparations, the greater the need is for coordination of that at the national level. So what I'm going to focus on is a little known but emerging entity, which are these national mechanisms for implementation, reporting and follow-up, NMIRF. It's a bit of a mouthful. And I want to argue that they're a really useful resource. They're not without their challenges, but they potentially provide a holistic and quite cohesive approach to linking up reporting, communications, follow-up, and so on at the regional and the UN and the national level. So what are they? Dr. Ayeni touched on these in his recommendations yesterday. They were first proposed in 2012, and they've been followed up with 2 studies by the Office for the High Commissioner for Human Rights at the UN in 2016. And they call on all states to establish a national mechanism for implementation, reporting and follow-up. So they're government entities, they're not independent. In theory, you want them to have a broad mandate to look at UN recommendations, whether that's from UPR, from the treaty bodies, from the special procedures, but also the regional decisions, concluding observations and decisions of the African Commission and all of the other African human rights bodies, and potentially also national recommendations and decisions. And the ideal being that they should be permanent, not ad hoc. They should have a high level of political support, cross-ministerial representation, and inclusion of the judiciary, parliament, statistics office, and representation of national human rights institutions and civil society on their composition. They should be able to engage with a wide range of stakeholders coordinate, so share information and collect information from across different ministries, consult, again with a wide range of stakeholders, and then information management, so track recommendations, identify who's responsible, and develop plans for action. Now, it's been well noted by others yesterday, the Commission's work that it did in holding 2 events in Dakar and Zanzibar on implementation. And the Commission has acknowledged in the recommendations from Zanzibar the potential of these national mechanisms. So just a couple of references there. The Commission said there was a lack of implementation and monitoring plan of decisions by state parties at the national level, a lack of focal points in designated government ministries, lack of coordination among government ministries, and lack of adequate financial resources and staff to implement Commission's decisions. And then for its own part, a lack of an effective and sustained communication, interaction, engagement with state parties and other relevant stakeholders. And then making recommendations that states should set up these mechanisms responsible for coordinating issues around implementation, ensure that they're adequately funded and represented, and institutionalize focal points at the national level and capacitate them to execute their functions effectively. So there are quite a lot of these national mechanisms for implementation, reporting, and follow-up in Africa. They're a little scattered and information is quite difficult to get hold of. But drawing on research that the Office for the High Commissioner for Human Rights has done, they published a report last year in June 2022, which gathered together a sort of snapshot of all of these mechanisms, not only in Africa, but across the globe. And then work that's been done by the Danish Institute, Universal Rights Group, Bingham Centre, Bristol, and others. So just to give you a little flavour of what's already out there. Of those that exist, most of them have a mandate to report and potentially implement not only UPR recommendations, but also those of treaty bodies, including the UN, and therefore also the African Commission and African Committee of Experts on the Rights and Welfare of the Child. So Niger has a national mechanism, and it encompasses, has a mandate that covers all of those. Some also look at the special procedures from the UN, so Mauritius and Rwanda are example of those. Some are much more limited. So I think Comoros has only the mandate to look at the UPR. But please, if there's anybody there that is out of date, then please say. They are composed generally of representatives, some of them from all ministerial departments, plus maybe national human rights institutions, civil society as well, maybe just in a sort of consultative capacity or as observers. Some of them also include statistics offices, for example, and representatives of parliament, so the Gambia and Mauritius, and the judiciary. So again, Mauritius is an example of that. Some are under the Prime Minister's office, so very high level, but a lot of them fall under the Ministry of Justice. So for example, Burkina Faso, Senegal, Namibia, or the Ministry of Foreign Affairs. So I think Botswana is an example of that. Some have their own or shared secretariat, so they share these staff with the Ministry of Justice or the Ministry of Foreign Affairs. And interestingly, some not only are they about coordinating the activities at the international level, but they also coordinate national action plans. And that's quite important in terms of integrating all of these recommendations, so whether they're recommendations from the African Commission or the UN, into recommendations at the national level and into a national action plan on human rights. So I acknowledge there are some challenges with these mechanisms. They're not without their flaws. Some of them are relatively new, so they're in a process of development. Many still focus on reporting, So they're national mechanisms for implementation, reporting, and follow-up. But they started principally out as a way of gathering and coordinating on drafting reports to the African Commission or to the UN. And so that means that they've started on that and they have maybe developed less on the implementation and follow-up side. Some of them don't have sufficient resources. As I said, they may share their staffing with the secretariats of the Ministry of Justice, and so have very few staff or staff who are not allocated specific just to do this work. And they may have a limited mandate, as I mentioned. They may not all cover all of the sort of UN or the regional bodies. However, I still think there is sufficient merit in them and that it is important for the African Commission to consider them and to engage with them. Firstly, they provide a direct link with the state authorities who are gathering this information for reporting and implementation. And they're a useful starting point for getting hold of a variety of different ministries and others. Secondly, visibility and tracking. This came up a number of times yesterday about the need for visibility of data on what states have done to implement decisions of the Commission. And Justice Aminu also yesterday noted in a very insightful presentation the use of technology. So some of these NMIRFs have developed their own databases and tracking tools where they gather all of the recommendations from the UN, from UPR, from the treaty bodies, and from the African Commission and other African human rights bodies into some form of database. And it can be as simple as a Google Sheet. I think that's Burkina Faso, certainly their mechanism did that. The Office for the High Commissioner for Human Rights recommends the establishment of a national recommendations tracking database. And Mauritius was the first country, I think, to utilize that. It's not yet public, but that is a tool for gathering all of these recommendations in one place, clustering them around certain themes, providing indicators, prioritizing them, but also identifying which ministry is responsible for implementing various aspects of those. And they can combine, as I said, for some of them, both national and international commitments. Lastly, why is this important for the Commission? Why are these mechanisms important? Because of the victims. It is very difficult, we found from our research, post-decision for the victims, litigants and complainants of cases before the Commission to know what to do next. How do they get paid compensation? How do they find out what measures have been taken to repair the harm that has been done? And an NMIRF can provide a useful vehicle to engage with the victim by providing information to them. They may be a face or a stop somewhere in government that the victims or the litigants can approach. And if they're keeping track on the progress of implementation and the measures taken, then that again can be shared with them. Clearly, it should not be left to the victim to initiate action, but that is sometimes what's happening at the domestic level. And if you've got a well-coordinated NMIRF, they will be doing that. They will be initiating things. They will be identifying who is responsible in government for implementing specific aspects of the decision. So my recommendations, just remove that at the top so you can see that. I think they are not without their challenges, but national mechanisms for implementation, reporting and follow-up are a potential one-stop shop for engagement with government on implementation. They enable communication between the Commission and government, which can be both formal and informal. And I would recommend that the Commission should ensure continuous engagement with them, using a whole range of opportunities to involve the NMIRF in the Commission's work, whether it's attending the sessions, being part of its activities, and so on. The Commission has already encouraged the establishment and strengthening of these bodies, and I think it should continue to do so, and also to ensure that its own decisions are included in the mandates of these NMIRFs. I would also recommend that in the reparations section, in the recommendations at the end of each decision, that the Commission either state that the NMIRF should be responsible for reporting back, providing action plans or so on, or that the state should identify within a very short period of time who in government is going to be responsible for engaging with the Commission and coordinating on these activities. The Commission can call on the NMIRF or if it doesn't exist, any other key focal point to provide regular updates on the implementation of the decision, even after the 180 days that is usually put in the decision has passed. What we saw from the research is that almost once the 180 days is gone, the pressure is off. And if there isn't continuous and regular requests, then it can just slip off government authorities' radar. So being constantly questioned in a courteous and polite way for information from these bodies can facilitate responses and potential implementation. We'd encourage the NMIRFs to include in their databases the African Commission's concluding observations and recommendations from these decisions, and to make those visible. Some of them are. There's a very interesting example. I tried to find it. Unfortunately, it's not working at the moment, from Moldova, where they publish their database, but they also give civil society and NHRIs the ability to post comments on what the government has said that is done, and therefore sort of heighten the accountability of that. And that's a useful place for the Commission to look where these are available for what the state has done to implement its international and regional obligations. And lastly, I would encourage the Commission to ensure that its recommendations and reparations in concluding observations and its decisions are specific and implementable. We know that some NMIRFs and governments will distinguish between those decisions that may be adopted by treaty bodies, which are clear and are measurable and are implementable and specific in what they're requiring the government authorities to do, compared with others that are much more vague, including among those some recommendations from ACHPR and so on, which can be difficult to identify precisely what it is that is required to be implemented without a clear time frame and so on. So ensuring that reparations and recommendations and decisions are specific and the state is clear of what it needs to do to implement can also help and will assist these NMIRFs in their work. So I will stop there. Thank you very much for listening.
Thank you so much, Prof, for your very informative presentation and the excellent recommendations you've given. We'll look forward then to hearing from the Commission and also colleagues in the room in terms of what they think about these national mechanisms. I think between yourself and Olujuana, I think we have a bit of hope. I think these mechanisms that we have spoken about give us hope that implementation can be possible. Thank you so much. I'll now hand over to my brother, Mr. Perma from Middlesex University, Mauritius. Thank you so much. You have 15 minutes for your presentation. And you're looking at diplomatic mechanisms in the context of persons with disabilities.
Hello, everyone. My name is Neil Perma, and as the chair just mentioned, my presentation is going to be on diplomatic mechanisms as a springboard to enhance implementation of the decisions of the African Commission. I will be looking at diplomatic mechanisms in the context of persons with disabilities. And Chair, I will stick to the 15 minutes because I know everyone is waiting for lunch. So while my presentation will be a bit narrow in focus, and I should say also academic in nature, I will endeavor to provide some recommendations, concrete recommendations by the end. I will start by providing some definitions, but first let me explain why I chose the disability angle. I want to look specifically at one of the special mechanisms of the Commission, which is the working group on the rights of older persons and persons with disabilities in Africa. This is in view of how diplomatic mechanisms can enhance the implementation of the decisions relating to persons with disabilities. But please note that my recommendations regarding the use of diplomatic mechanisms can be applied to other areas as well. I will start with the definition of compliance and implementation that was mentioned by Jonathan and also Abiola earlier today. I borrow the term, the definition from Dr. Jaffet, who distinguishes compliance as being outcome-based in the sense that the state has already complied with the decisions of a treaty body, while implementation, on the other hand, is process-based in the sense that there are measures that are put in place, not only by the state, but also by other stakeholders in implementing the decision of a treaty body. I prefer the term implementation as the African Commission itself can and actually does play a critical role in the implementation of its recommendations and decisions. In terms of the decisions that I focus on in my paper, I focus on the intersession activity reports of the working group and also the state reporting procedure resulting in concluding observations. As to diplomatic mechanisms, I am using it broadly to incorporate political and diplomatic means such as dialogue, negotiation, and cooperation between all stakeholders, and principally between the Commission and states. Now that I have been able to set the scene, let me just note that while states are not actually playing their role in implementing the decisions of the Commission, I believe that the Commission itself has more leeway and wiggle room to use soft or diplomatic approaches as opposed to forceful measures in order to ensure that it can cajole or influence states in implementing its decisions. And I ascribe completely to the discursive model of Dr. Ayeni, on which he elaborated on yesterday. Let me now come to the select tools that I have chosen in my paper. The first one being the working group, on the rights of older persons and persons with disabilities in Africa. It is a special mechanism which has been established by the African Commission in 2007 as a focal point. It started as a focal point on the rights of the elderly people in Africa. The purpose of setting up this unique mechanism was to work with the Commission in convening a group of experts and taking the lead to formulating a protocol on the rights of older persons. The focal point then eventually became a working group which had the additional responsibility of looking at disability rights in conjunction with the African Commission. Now, with this added responsibility, came new tasks for the working group, including, among others, doing research on various groups of people's rights, in convening meetings, establishing best practices, and others. The working group was originally tasked with the duties to draft legal instruments on the rights of older and disabled people in Africa. Now, my contention is that it can safely be assumed that the working group can play a vital role in enhancing the implementation of the decisions of the African Commission relating to persons with disabilities in the African context. This is because the working group has the expertise, and I will elaborate on this in a moment. They have the expertise, advocacy, and collaboration. And I should also mention that the composition of the current working group, with the chairperson being Commissioner Marie-Louise Abomo, the vice chair and Commissioner Mwandenga, and Commissioner Idrissa Sow, and 5 other experts being on the working group. I will come back to that in a moment. Let me just briefly touch upon the state reporting process. Through this process, the Commission itself has already been using promotional missions. We heard about this at length yesterday, in order to enhance the effectiveness of this procedure, which I would submit is a very proactive approach, serving to supplement the information provided in state reports, identifying issues that may require further attention, and engage in a constructive dialogue with the state authorities and relevant stakeholders. Let me now move to my recommendations. Firstly, regarding the working group. Now, with their specialized knowledge, I believe that the working group can provide valuable insights. They have organized webinars, awareness campaigns, and engagement with other member states. As such, they can play a critical role in raising awareness and advocating for the ratification and domestic implementation of the disabilities protocol. At the moment, there are only 8 states which have signed and ratified the disabilities protocol, and we need actually 15 states to ratify this protocol for it to enter into force. Further, the working group's technical assistance and capacity building support can actually help member states align their national frameworks with international standards. So by collaborating with stakeholders such as member states, CSOs, and other international partners, the working group can actually foster knowledge sharing and coordinated actions. Additionally, their reporting and engagement in dialogue can stimulate ongoing discussions, accountability, and transparency. So overall, the working group's involvement in diplomatic mechanisms can actually strengthen the implementation of the decisions of the African Commission, all the while promoting the rights and well-being of persons with disabilities across Africa. So I would venture to suggest that the collaboration between the African Commission and the working group, it offers a potential springboard for increasing compliance with the Commission's decisions in various ways, some of which I will be elaborating. The first one, the working group can engage in research and formulate recommendations for all persons and persons with disabilities, which can actually catalyze and enhance awareness of their rights among states. These recommendations, when incorporated into the concluding observations of the emanating from the African Commission or other thematic reports, can serve as a touchstone for states to align their policies with international human rights standards. For instance, if the working group highlights, let's say, gaps in the right to accessibility of persons with disabilities, and the Commission subsequently incorporates these concerns in its recommendations to states, this sort of interconnected approach can stimulate targeted policy changes and thereby foster compliance. Second, I highlighted this earlier, the commissioners of the African Commission are also, some of them are also members of the working group. So they can use their different mandates to foster collaboration between the Commission and other stakeholders such as CSOs, which advocate for the rights of persons with disabilities. This will engender a more holistic approach to human rights promotion. CSOs, as we know, often play a pivotal role in monitoring state compliance and advocating for rights fulfillment. So my contention is that the working group's emphasis on involving these stakeholders can actually facilitate the dissemination of the decision of the Commission and recommendations at a grassroots level, which in turn can create more pressure at the local level for compliance. For example, if the working group collaborates with disabled people's organizations in view of promoting the implementation of the decision of the Commission in the context of, let's say, inclusive education for children with disabilities, this joint advocacy can augment the visibility of the Commission's decisions and therefore, hasten compliance efforts. This idea, I'm coming back to this idea of visibility that was mentioned by Professor Murray and also in the writings of Professor Franz Wilczek. Now, moving to the state reporting procedure, I mentioned earlier that promotional missions organized by the African Commission are characterized by their multifaceted nature. In this sense, incorporating both informational gathering and interactive engagement. So these missions typically entail a visit to member states by representatives of the Commission, including both commissioners or expert rapporteurs, who, in a sense, possess the specialized knowledge in various human rights domains. So the missions actually afford the commissioners and experts the opportunity to engage directly with state officials and other stakeholders like CSOs to foster a more open and comprehensive dialogue on the human rights situation within the country under review. So it is my contention that through face-to-face dialogue, stakeholders are afforded the opportunity to express their concern, share their perspectives, and propose solutions to the challenges they face. Such engagement is instrumental in establishing a collaborative framework for addressing human rights issues and promoting positive change. So in conclusion, I would say that diplomatic efforts offer an avenue for sustained engagement and dialogue. At the end of the day, dialogue can and has to a large extent become a swift and mighty sword in the hands of the Commission to cajole and induce member states into complying with its decisions. So this dialogue should remain as the first port of call before considering other means of implementation. Thank you very much.
Thank you so much, Neil, for your very informative presentation. I must also just add that the Center is running a campaign for the ratification of the Africa Disability Protocol. Now 10 states have now ratified, and we need 5 states. So calling upon colleagues in the room, if your state has not ratified, I'm looking at my brother Pacharo. If your state has not ratified, please, when you go back to your station, call upon your state. We need 5 more ratifications so that the protocol enters into force. So thank you so much, my brother, for giving us this perspective on diplomacy, particularly using the working group on the rights of older persons and persons with disabilities. So we have 3 mechanisms to interrogate. I'll now give the floor to Ms. Eunice Malota. You have 10 minutes, and I've limited to 10 minutes because we don't want to miss out on the lunch. But we want people to have a good lunch today. So you've got 10 minutes to give us your responses and reactions. And Madam Abiola, I think will also give you an opportunity, not 10 minutes, just 5, so that we don't eat into the time for lunch. Thank you very much. To you, Eunice.
Thank you, moderator, for giving me the floor. Good afternoon, ladies and gentlemen. Let me start by appreciating the presenters for the brilliant and insightful approach to the issue of the implementation of the decisions of the Commission. The presentations were indeed of excellent quality and accuracy, and the Commission appreciates the various recommendations put forward by the panelists. And a special thank you to Professor Rachel Moray, as I understand her language very well, based on my background as a state attorney who has been very much involved in state reporting and appreciating very well the challenges faced by states when it comes to implementation of the decisions of the Commission and other treaty bodies. I will therefore respond mostly from the perspective of state parties, given my background and experience, and now working with the Commission and being responsible for the portfolio of implementation of the decisions of the Commission. I will start by responding to Prof. Rachel Moray's paper, as it resonates very well with my experience. Now, the main challenge at state level is structural. There is no committee responsible for implementation of the decisions of the Commission to deal with, among others, technical bureaucratic procedures, as mentioned by Professor Moray. Most states, like Botswana, for example, have interministerial committees that coordinate the preparation of periodic reports for submission before treaty bodies. The focus of these interministerial committees is on submission of reports, as Prof. Moray properly alluded. After submission of the report, for example, after submission of the report, for example, before the Commission, there is no structure set up to go through the decisions and ensure their implementation. The Interministerial Committee is supposed to do that, but it does not actually get to do that, maybe because of many competing priorities. Now, if at a ministry level, there is no officer who's pushing the implementation of the decisions of the Commission by bringing them to the attention of the accounting officers, there may be nothing done about those decisions until is the next cycle for the state to submit a report, or when a state has accepted a promotion mission. That would be when, at a technical level, officials get to check if any of the decisions of the Commission, for instance, have been implemented. And if implemented, it will be largely by default and least through intentionality. Now, let me also mention that, of course, certain decisions scream for attention, and they get that attention depending on their profile. Otherwise, the bulk of decisions fall in the cracks, as we say in government, and only get attention during the next reporting cycle. The point I'm emphasizing is that there is no systematic follow-up by states on decisions emanating from the Commission. It is not enough to require them to report back on implementation without developing a tool to aid them to report back on implementation. If a follow-up tool is developed, then the Commission can work with that tool to follow up on states. Decisions from the UN system get better attention from states than those from the African human rights system. This is so because the UN system has a follow-up mechanism, as indicated by Professor Murray. And the UN Human Rights Office of the High Commissioner, at least for the Southern African region, has taken time to capacitate states on its follow-up tool or to cascade that tool to states. This helps with follow-up and implementation of the decisions from the UN treaty bodies. In view thereof, the Commission could help the situation by requiring states to set up implementation subcommittees within the existing interministerial committee or independently or on an ad hoc basis for that matter, and equip such implementation committees with tools that assist them to follow up on the decisions of the Commission and implement them as it obtains within the UN system. These implementation committees will then work closely with the Commission and report on a regular and bilateral basis, such that by the time the reporting cycle comes around, the state is well prepared to report on the effort it has taken to implement the decisions of the Commission. Most importantly, states need to feel that they are friends and partners of the Commission. So there has to be a lot of diplomatic engagement with the states, a lot of dialogue, and most importantly, the creation of a safe space for states, such that they are free to open up on their challenges. I therefore fully agree with Mr. Neil Pumar that diplomatic mechanisms are a powerful tool in the hands of the Commission to enhance the implementation of the decisions of the Commission. And this is where financial resources would be needed to facilitate intense diplomatic engagements, to get to know the faces that have the responsibility to push the agenda of the implementation of the decisions of the Commission, to have a personal relationship with them, which in turn facilitates quick responses from them as necessary. Now, diplomatic engagements with a state assures that state that the Commission is not attacking it for non-implementation, but wants to hold the state by the hand and assist it to meet its treaty obligations. This is most important. If this atmosphere or environment is cultivated, the state will be ready and willing to implement the Commission's decisions. For instance, the Commission could engage states diplomatically before issuing a press release, for instance, so that states do not feel attacked and would be most likely to cooperate with the Commission. Now, let me touch a bit on political will. With regard to political will, it's either you have an administration that is human rights inclined and would aggressively move the human rights agenda, resulting in the implementation of the decisions of the Commission, or not. In which case, the political administration of the day will not pay so much focus on human rights unless they are triggered by the technical people who can only do so if they are well coordinated themselves and have a systematic way of following up on the decision of treaty bodies. If indeed the perception is that there is no political will, then the Commission will have to raise its profile to get the attention of political decision makers. The UN does not have to do much. Its profile speaks for itself. States take it seriously because there are serious repercussions for non-compliance with these decisions in the context of human rights. Loan facilities are at stake, as you know. So states also worry about their ranking on human rights indices and the implications thereof. So if states stand to be compromised by non-implementation, they will give more attention to the decisions of those treaty bodies. On the other hand, states don't feel that much threatened by the Commission and other treaty bodies within the African human rights system because they will not experience any serious repercussions. It may be now necessary to design sanction systems for non-implementation modeled along those of the UN system so that states feel the consequences of disregarding the decisions of the Commission, since naming and shaming alone is not sufficient. I have said all that I have said to make the point that a comprehensive and a holistic approach to implementation of the decisions of the Commission is therefore critical to ensure full enjoyment of human rights by Africans pursuant to the Charter or any other human rights instruments. With regard to Mr. Tim Lyon, Olojourn's paper, I would like to make a brief comment on Article 19 of the protocol relating to the establishment of the Peace and Security Council. Madam STC will reflect more on it. Now, while Article 19 provides a legal framework for collaboration with the Peace and Security Council and the Commission, there is no implementation framework. For instance, when the Peace and Security Council requests the Commission to undertake a mission, for example, the 2015 mission to Burundi, there were no financial resources provided, presenting logistical challenges for the Commission. This assignment put financial burden on the Commission, and the execution of the mission was delayed as a result thereof. Now, to answer your question, can the Commission utilize the institutional support of the PSC? Can the PSC and the Commission work together to raise awareness on important issues that are under the PSC's purview? The answer is a resounding yes. But the two organs need to engage further and come up with operating procedures for their for the implementation framework, which should clearly articulate their responsibilities whenever they collaborate on important issues. On this note, I conclude my intervention and thank you very much for your attention. Thank you.
Thank you so much, Ms. Malota, for your very honest, comprehensive reaction and insights. Thank you very much. I'll now hand over to Madam Abiola. I think I'll give you 3 minutes to add. I'm worried the coordinator is just hovering around me here, so 3 minutes or so. Yeah, thank you.
Now I'm being shortchanged. I'll try my very best. I think my colleague has already addressed many of the issues. But again, because we are all partners in progress, I think as much as possible, I should also provide updates so that as we continue to move forward in our reflections on how to better improve the implementation framework of the Commission, we can have some of this information at hand. Let me start with Timileyin. I'll just build on what my colleague has said about the potentials for engagement between the Commission and the PSC, and just to give some concrete update in that regard. First to say that the Commission has reflected on its role in relation to peace and security issues and its engagement with the Peace and Security Council in view of Article 19 of the protocol establishing the Peace and Security Council, which mandates the Commission to bring information related that have a potential of peace and security to the Peace and Security Council. And in relation to this, the Commission undertook a study titled Addressing Human Rights in Conflict Situations, in which it reflected on the interrelationship between human rights and peace and security, human rights being both a cause and as well as a consequence of peace and security situations, conflict situations. I would implore us to have a look at this because it really interrogates the mandate of the Commission vis-a-vis peace and security on the continent, and the Commission makes a very strong case for an approach that is focused on having a human rights-based approach to engaging with peace and security issues from conflict prevention through the entire chain up to post-conflict reconstruction. So I think this is something that I would like to say. And on this basis, the Commission then put itself forward and started to brief the Peace and Security Council since 2019. The Commission has had made three presentations to the Peace and Security Council in 2019, 2020, and 2021. And particularly in 2019, the framework for the engagement between Peace and Security Council and the Commission was further defined in the final communique that was issued by the Peace and Security Council. I think it was the 899th communique. And among others, and I have to say this because we are talking about implementation specifically, there wasn't a lot of focus on using that platform or using the engagement for purposes of implementation, but basically it's a platform for interaction, exchange of information, and mutually using the both platforms to promote the work of the other. But of course, there exist a lot of opportunities in narrowing down to the issue of implementation in that context. And we need to see what opportunities are there more concretely. So I think that's also a call to action for the African Commission to look in there and see what exactly are those opportunities. If I can just cite, for example, the communique of 2021 indicated, among other things, that the Peace and Security Council will develop with the ACHPR a constructive dialogue comprising, among others, the response to the various queries of the ACHPR like urgent appeals. It's very open-ended, but there's room there for the Commission to jump on that and see what opportunities are there for the Peace and Security Council to be able to help it enforce its findings or recommendations in relation to urgent appeals, which are issued from time to time, and press statements. I would also like to highlight the engagement that the Commission has also had with the wider AU Department of Political Affairs and Peace and Security in the context of early warning, because there's an ongoing initiative to mainstream human rights into the early warning mechanism of the AU. So there are lots of engagements in that regard. There are briefings also in the context of AGA. So there's a whole lot that is going on there, but taking advantage and trying to see how to then narrow down and address specifically in that context the issue of implementation is something that we need to take a better look at. Responding to Professor Murray, I think my colleague has already, she has the background, she's wearing two hats. So she has exhaustively dealt with that issue. Perhaps maybe just to add, and I'm glad that we have her handling this portfolio now, because she's able to then advise the Commission from an informed viewpoint. So we're really grateful to have Madam Eunice on board. Maybe just to add, a few things from my experience at the Commission in relation to implementation mechanisms, national implementation mechanisms, that at the moment, for over the years, the Commission has made calls for focal points, and this became particularly important, and I want to underscore this context. Because of the diplomatic channels that the Commission is required to use as an AU organ in practice for communicating its various, both its outcomes, every correspondence that goes to states. Our official diplomatic channel are the embassies in Sababa, the ones accredited to the AU. And then you copy the Ministries of Foreign Affairs, which is your entry point at national level. And it's only when you are dealing with cases, communications, that then you copy the Ministry of Justice. And we've had some states that have approached us to say our preferred embassy is the embassy in Dakar because it's closest to Gambia. So we have all of those things. And of course, there's a lot of potential for information to be delayed, for feedback to be delayed and all of that. And this in the past had caused the Commission to make calls for focal points. But indeed, having national implementation mechanisms has been one of the key outcomes, as mentioned by Professor Murray, of the previous conversations that have taken place, particularly in Zanzibar and in Dakar. And now the practical implementation and some of the things that I picked from Professor Murray that we should be taking home with us, colleagues, is the need for us to develop a strategy for promoting the establishment of these mechanisms and to standardize their terms of reference and composition. I think there are a couple of best practices that Professor Murray alluded to that I think that we need to take a look at. And one other thing that came to mind as I listened to her was perhaps the need for us to have a joint initiative, for this to be a joint initiative by the three human rights bodies, because we also there's a potential for states to have a fatigue, of multiple requests, because all of us need to have these implementation mechanisms, because implementation is a common problem. So we should perhaps look at this as a joint initiative at the level of the levels of the court, the Commission, and the committee. And lastly, addressing the very insightful presentation by Mr. Neil Puma on the use of diplomatic mechanisms as a springboard with a focus on the work of the working group on older persons. Just to indicate first and foremost that this special mechanism in particular has a fantastic record when it comes to advocacy for ratifications. Just last week, we made a presentation to the PRC on what it's done in this regard, and it was able to move the ratification of the two instruments that it oversees from 0 to almost 15 within a span of about 4 years. So the lesson learned from that is that when we have, micro engagements, instead of a wider ACHPR engagement, where we have targeted micro engagements at the level of special mechanisms, you could get more results and you're able to engage better in dialogue with states and diverse other stakeholders. And this is replicated in a number of other special mechanisms of the Commission that focus on different thematic issues. For instance, the Special Rapporteur on Refugees, Migrants, and IDPs also, there's a lot that has been achieved in terms of enforcement, seeking enforcement of decisions of the Commission and the provisions of the African Charter, including through promoting protocols and all of that. And another good example would be the Special Rapporteur on the rights of women, who has developed guidelines for reporting under the Maputo Protocol. This was a mechanism for promoting the enforcement of the Maputo Protocol within the framework of the work of the African Commission. So thank you all so much, and I will stop here.
Thank you so much, Madam, for this. Thank you very much. I think there's a lot to digest, a lot of information we have received, and I think we can, interrogate this further after lunch when questions may be posed. But I will now just hand over to the speakers just for 1 minute each to just give your closing remarks to the reactions. Please, just 1 minute, because it's now 1 p.m. and I'm told lunch is ready. So I'll start with my brother Olajuwon, just for your 1 minute concluding remarks. Thank you.
All right, thank you. So my concluding remark will be, I will employ just like Madam Idowu just said now, that the commission should please try as much as possible to see how best they can actually work with PSC in order to ensure that there is peace and stability, and in the real sense, ensuring that there is protection and promotion of human rights. Because the truth of the matter is, like I always advocate for, where there is lack of peace, there's definitely lack of development. And in its real sense, where there is absence of peace, there will be a great violation of human rights. Thank you.
Thank you very much for the concluding remarks. I'll hand over to my brother, Neil.
Thank you, Chair. I just wanted to make a brief comment about 2 points about what Mrs. Malota has mentioned earlier. The first is about political will, and the second about the sanction system that maybe should be implemented. But the first point about political will, we're all aware that we actually need the political will in order for there to be implementation of the decisions of the African Commission. But my contention is that the Commission itself should take the center stage in order to ensure that we can engage in more constructive dialogue with the states which are not actually implementing the decisions and various recommendations made by the Commission. The second point I wanted to make is about the sanction system. Ms. Malota mentioned about maybe there's a need to come up with a sanction system such as we have at the UN level. But the point I would make is it really effective in practice? I will leave it at this question here. Thank you very much.
Thank you so much. I will now hand over to Prof. Murray for your 1 minute of concluding remarks. Thank you.
Thank you so much, and for the really helpful and insightful comments from Eunice and Abiola. Just a couple of things. I think it's crucial for the Commission to know who is responsible, if it's clear, at the domestic level, and to continually and regularly have a dialogue with them to find out what's being done, that sort of consistent attempt to engage. And I would recommend, and this has been recommended before, that the section of the decision, the recommendations, is used as a vehicle to keep that discussion going. So rather than just have 180 days, use deadlines in a sort of creative way, have 1 month by which the state needs to tell the Commission who is going to be responsible for coordinating, have 6 months where that body should inform them about some sort of action plan to implement the decision, rather than it be a sort of set 180 days and then very little after that. Eunice also mentioned about the need for sort of guidance for states on how to implement. We produced, as part of our project, a reparations guide for states, which attempted to sort of go through different types of reparations and the sorts of things that might entail. And I'll put that on the chat, the link there. And just lastly, Abiola's points about the standards of best practice, I think, is really, really needed. The OHCHR is looking at this, looking at NMIRFs very, very carefully, and this is ongoing work, and so interaction with that process as well And finally, Mr. Pacharo, I know, will probably speak more to NMIRFs tomorrow. I've been in touch with him around these, and he has a significant experience of this. So thank you very much.
In terms of implementation of decisions, maybe a pre-engagement session at the session with states would also be quite useful. Thank you very much. Landilani.
Thank you very much, panelists, Lloyd, the session chair, and Commissioner Molatha for that very engaging session. I think that now will be appropriate to ask for a round of applause. As you can see the time, we are now 6 minutes past lunch. So if we can break off for lunch right now. But just an announcement for those that did not sign the register this morning, please may you sign the register before we break off for lunch, and may we still come back at 1. Thank you. So for those that didn't sign the register, please do so before we go out for lunch. Today's lunch will be outside, so if we could just proceed directly on the right, the door that is directly facing us on the right as we go out for lunch. And may we please come back at 13:55. That's 5 minutes before 1. Thank you very much and enjoy the lunch. Before 2. Oh, sorry. Before 2. Yeah. So the register is just there before the banner of the center. Welcome back, everyone. I hope we enjoyed our lunch. I think it was quite delicious. At least I enjoyed it. And hopefully it has energized us for yet another fruitful, engaging and exciting afternoon. We have 2 panel sessions this afternoon. And may I kindly call upon the chair for the first session, Pedro Rosa, and the panelists. We have the chair for this session actually is Justice Fadima. I don't know if you are here, but we welcome you to take your place on the panel. And may I also call upon the panelists, Deborah, Patricia, and Mr. Juma, as well as Pachero. If we could just be seated as we sort out the slides. Oh, okay. I'm being corrected that it's Barry that is presenting. Juma is not around, so please do take your place on the panel. Also, we have drinks at the back. If you feel like you are thirsty and you'd like to take a drink, I've been told that we need to empty that can before we leave. So we are welcome to take the drinks as many as we want. Some of them are actually leftovers from last night's party. So we're welcome to take on the drinks at any point as we deliberate. Chair, I think we can start even as we sort out in the interest of time. Thank you so much.
Good afternoon, everybody. And this is panel session 4. And we have our panelists, Ms. Deborah Nyokabi, Ms. Patricia Juguna, Ms. Beryl Oriel, and Mr. Paul Juma, and Mr. Pacharo Kaira. I hope I pronounced your names correctly. And you all have 15 minutes to present your articles. We're starting with Ms. Deborah Nyokabi. Is she here? Yes, okay. Ms. Deborah holds a master's degree of laws, LLM, in human rights. And her professional and academic interests are in constitutional law, regional and international human rights mechanisms. So, Ms. Deborah, you can go ahead. 15 minutes, please. 208.
Thank you very much for the floor, Chair. As introduced, my name is Deborah Nyokabi, currently working as a program officer at the Network of African National Human Rights Institutions. Yeah, but I'd like to make a disclaimer that these are not the views of the network, but rather my personal views based also on my experience coordinating the engagement of African national human rights with the African Commission on Human and People's Rights. So the outline of the presentation is that I'll start with the background of the relationship and introduction to the status of the affiliate status cooperation between African National Human Rights Institutions and the African Commission. highlight some key effective strategies that NHRIs can play in following up on implementation, look at practical examples by the NHRIs of Kenya, Gambia, and Nigeria, look at how NHRIs and the Commission could potentially engage African Union policy organs, look at some challenges, and then end with the way forward. So in terms of background, this relationship is created by Article 26 of the Charter, which mandates state parties to establish and improve national human rights institutions, right together with Article 45, which mandates cooperation between the African Commission and other African institutions. And with regard to this, the African Commission has adopted 2 resolutions, one in 1998 and another in 2017, mandating the Commission and NHRIs to cooperate through what is called an affiliate status. As you see, this cooperation is important because, like we know, national human rights institutions are established by the Paris Principles, which were adopted by the UN General Assembly in 1993, and this gives NHRIs a wide mandate relating to advisories, legislative recommendations, investigations, and promotion of ratification of instruments, as well as reporting on implementation. 2023 is a milestone year because we are marking the 30th anniversary of the Paris Principles. In terms of the actual numbers, there are 46 NHRIs that are members of the network of African national human rights institutions, out of which 28 are rated as A-status institutions by the global network that does accreditation of NHRIs, and out of which 36 hold affiliate status with the African Commission, together with 2 specialized institutions. So I'm trying to slow down because the interpreters have told me so, but also manage my 10 minutes that are now remaining, so please bear with me. So in terms of a definition of the affiliate status, it's really not available, but in my paper, I try to contextualize it based on the 1998 resolution that refers to the affiliate status as a special observer status, and also a plain English definition that refers to it as causing a group to become part or form a close relationship with another, usually larger group or organization. And in this context, then NHRIs are affiliates of the African Commission at the national level, meaning they are the ears and eyes of the Commission at the national level, and they can play a key role in implementation. To contextualize this, the first NHRIs gained affiliate status in 2000 at the 27th ordinary session of the African Commission. 10 years later, there was a paper written by Dr. Dino Kopila, who called that relationship paper-based affiliate status because it was not yet as robust and effective as the one between the Commission and NGOs. That criticism has continued, but we've seen some improvement in the latter decade that can be based on the African Commission 2020 rules of procedure, the strategic framework of the Commission, as well as the institutionalization of what we call the NHRIs Forum on the margins of the sessions of the Commission. And a key document delineating this role is the one developed by the Network of African National Human Rights Institutions that clearly spells out the role of NHRIs in monitoring the implementation of recommendations of the African Commission and the African Court. The role will be shared when I share the PowerPoint because it's there, but I want to focus on what I believe can be strategic and effective avenues. One is, of course, state reporting. NHRIs have the opportunity sometimes to participate. All advice on state reporting, and they can raise the issue of the status of implementation. The other most effective strategies is the alternative reporting. NHRIs can submit alternative reports to the state report as stipulated in the rules of the Commission, as well as the shadow reporting guidelines. The other one is when it comes to transmission of concluding observations, the guidelines, the rules of the Commission now mandated to transmit these observations directed to NHRIs, and this is also the same for decisions and adopted activity reports, because there was an assumption previously that once the Commission uploads this on the website, then the relevant stakeholders, including NHRIs, would be able to access it, but that was found not to be effective. So maybe to hear from the Commission if it's now able to directly transmit these documents to NHRIs and what the impact has been. Also, NHRIs submit with affiliate status are required to submit biennial activity reports and this should essentially include a section on implementation. Similarly, for annual reports that NHRI submit to Parliament, and another effective strategy could be the filing of amicus curiae briefs, because implementation is continuous, and if these briefs are filed, then NHRIs can be engaged from inception to the very end. And we've seen a good practice from the African Court, whereby it actually invited the Commission for Human Rights and Good Governance of Tanzania to submit an amicus curiae brief in the case of TK Mwabipile versus Equality Now that is highlighted on the left. And that actually was a historical moment because it became the first moment that an NHRI submitted an amicus curiae brief to an organ of the African human rights system. So this could be a key avenue, and also the briefs could also be submitted by the network that brings the NHRIs together, as happened in the advisory opinion on compatibility of vagrancy laws in Africa with the African human rights system, where NANRI submitted an advisory opinion that was actually able to demonstrate to court the levels of detention in Africa arising from petty offenses, and that was a turning moment for the court. And NANRI has taken forward monitoring this implementation and is in the process of working with partners to develop a scorecard of the implementation of the advisory opinion, as well as the principles on decriminalization of petty offenses in Africa. So also in my paper, I do evaluate some three practical examples emanating from Kenya, Gambia, Nigeria. In Kenya, it relates to the EDRICE and OGEC decisions. The Kenya National Commission on Human Rights has been involved in the task forces that were formed by the government. And this brings before one issue that has been raised by Dr. Mare about NRM, national mechanisms for reporting, monitoring, and follow-up. Because we see in this case, the KNCHR was involved, but for instance, the DROIS task force didn't operate because of lack of funds, so it went nowhere. The OGEC task force operated, but its final report has never been published, and KNCHR has reported that its role as an independent observer was never really clear. So if establishment of NRMFs will be one of the key outputs of this workshop, then it would be very important to define the roles of each actors, ranging from NHRIs, line ministries, CSOs, and all other active agents, including, for instance, local governments. Another critical tool that NHRIs can use to appraise Parliament of implementation is the annual report. If you look at the recent, I limited myself to 2020 to 2022 annual reports. They do not mention really the status of implementation of these two decisions, although they reference the establishment of the task forces, neither do they speak about the role or limitations that KNCHR faced. The alternative reports that KNCHR as an affiliate NHRI is required to submit, it's actually one of the few NHRIs that have submitted an alternative report to the African Commission during the review of the 2021 State Report of Kenya. But indeed, we find a shortcoming since this report does not mention the OGEC or EDROIS cases. This can be contrasted to the shadow report, for instance, filed by the Forest People's Association, that, you know, in the state report, the government of Kenya said it had implemented 4 out of 7 recommendations, but the CSO report points only 2 recommendations have been implemented, and in fact, the situation of the OGEC people the EDROIS people has deteriorated. So there was a missed opportunity there for KNCHR to play its role as a bridge between the Kenyan government and Kenyan civil societies, and we need indeed look forward to reading the concluding observations from the African Commission. Similarly, with the biennial activity report, again, KNCHR is a good example since it actually submits its reports. It is not the case of many NHRIs, but then again, a missed opportunity in that report does not reference the status of the implementation of those two decisions. The second consideration is the National Human Rights Commission for the Gambia. This is the decision in the Eurohit communication. As part of the strategies that the Commission has reported during one of the forums on implementation is that it has conducted monitoring visits to the facility in contention in that case, as well as advocating for legislative reform. If you review its recent annual reports, there's actually no reference to the Purohit decision, its implementation, or even the African Commission. But interestingly, the report does call for one of the recommendations, which is to repeal the Lunatic Detention Act, and also calls for the country to implement UN treaties. But it's a critical gap that this does not speak about the African human rights system and the decision that has actually mandated this reform. So there is a significant gap. As for the alternative report and the annual activity reports, the Gambia Commission just gained its affiliate status in 2021, so it's yet to submit its reports. But it will be important for the Commission and NANRI to work together to ensure that those aspects of implementation are captured. For the National Human Rights Commission of Nigeria, the case considered is the Serra case, and it reported strategies that included integrating the decision in its complaint handling system, creating awareness, and forming a human rights investigation panel on oil pollution and environmental degradation. But again, if you look at the annual report, missed opportunity, there is no reference to that decision, to the African Commission or implementation of that case. I'm not sure that the Commission has submitted its alternative reports or biennial reports, something that the African Commission can advise on in its response since they are not available. So the other final avenue for collaboration in implementation will be the policy organs of the African Union. As we know, the AU Assembly is the ultimate body that has the political responsibility for implementation according to Article 23(2) of the Constitutive Act. There's an article from 2006 by George Washira Mukudi and Abiola Ayinla that talks about this strategy that I feel has potential to take this one.
You have 2 more minutes, please.
Yeah, but I come in with the aspect of involving NHRIs, which happens in the European human rights system, where there's a guiding note and a lot of engagement between the Committee of Ministers. And as you can see from the picture on the left, NANRI and the AU convene what is called an annual policy dialogue, where the African Commission is a standing invitee. And this could be a potential avenue for involving and activating the latent implementation powers of the AU policy organs. So to challenges, they speak for themselves. I won't dwell very much since I have 1 minute. Yeah, but way forward, I think there's been calls to establish an NHRI unit within the African Commission, first made by Dr. Dino Kopila in 2010. And we see a similar system actually with the Office of the High Commissioner for Human Rights, which has established the national institutions and regional mechanism section that has actually really improved the engagement of NHRIs with UN mechanisms. Of course, now for this to work effectively, it calls back to the recommendation of the Zanzibar workshop for the African Commission to establish the implementation unit so that these 2 units could work together. I know there are currently 2 focal points on NHRIs and the NGOs, but if all NGOs with observer status and all NHRIs with affiliate status were to comply with the obligations, these 2 people would be very overwhelmed, and that's a unit would be the way to go forward. Referencing Professor Mare's presentation, we need to advocate for establishment of studying NRMFs. For instance, in the Kenyan case, those ad hoc NRMFs proved inadequate. So for us to have impact, we need to advocate for studying NRMFs, and we need to develop guidelines that delineate the role of each actor, including NHRIs, who are supposed to be independent observers. Then we need a strategy on involving AU policy organs in execution, and working with NHRIs could be an avenue for diplomacy and dialogue, as Dr. Ayani recommended yesterday. Also, we do need to audit the non-implementation guidelines developed in 2016. It's 7 years down the line, and as those practical evaluations reveal, there hasn't really been much application of those guidelines. So there's a gap, as well as the 2020 African Commission Rules of Procedure provide a very transformative framework. So maybe 5 years down the line, we'll need to investigate whether there has been any impact through those 2020 rules. And again, the African Commission would need to reconsider the permanent and unconditional affiliate status it grants to NHRIs. At the global level, status NHRIs that are no longer independent or compliant lose their status. Similarly, maybe if the African Commission has done follow-ups for NHRIs to submit alternative reports, activity reports, and so on, and they're not responding, maybe sanctions could be implemented. So thank you very much. It's been wonderful. Those are my contacts, because I know there won't be sufficient time in plenary, so please feel free to share your feedback. Thank you.
Thank you so much, Ms. Deborah, for your presentation. And moving on to the next presenter, Ms. Patricia Juguna. Sorry. You have 15 minutes. Ms. Patricia is Muthoni is a seasoned advocate of the Federal High Court of Kenya, and she participated in the conference on the decriminalization of same-sex law and the eradication of conversion practices in Africa, demonstrating her dedication to driving transformative change on a broader scale. Ms. Patricia, go ahead. Thank you.
Sorry. So I'll do a brief introduction on the CSOs. Then I will use illustrative examples to show how CSOs have contributed to the implementation efforts. I will also seek to show why the Commission should leverage on CSOs as implementation partners. And then I will look at challenges CSOs face in their efforts to engage with the Commission. And finally, I will just conclude. So civil societies are integral to the development agenda as they fill the space left untouched by government, as they are able to monitor the actions of the government while holding them accountable. Rule 125.6 of the rules of the procedure of the Commission, and I will paraphrase, allows the rapporteur to make such contacts and take such actions as may be appropriate to fulfill his or her assignment. This involves taking into account information from interested parties regarding the extent to which states have complied with the Commission's decisions. Following these provisions, we can confirm that the Commission continues to recognize the important role that CSOs play in the promotion and protection of human and collective rights, as well as interpretation of the Charter. Just for comparison purposes, and bearing in mind the general assumption that compliance levels under the European human rights system is assumed to be higher when compared to the African human rights system, and in particular to the decisions of the Commission, studies have continued to show the success of this body can be partly contributed to its continued engagement with CSOs to improve and promote human rights. So the illustrative examples I will use 4 cases, 4 decisions given by the Commission. The first one will be on the Malawi case, that is Malawi African Association, and another versus Mauritania, where Malawian government was found to have violated the rights of prisoners when they refused to grant amnesty to political prisoners. The government was ordered to grant amnesty. CSOs working together with the national human rights institutions helped in the implementation efforts by raising awareness through medical outreach and public education campaigns. The Malawian Law Society and the Center for Human Rights and Rehabilitation did advocacy work related to that case. There was also monitoring and evaluation by CSOs, where the Malawian Law Society and the Malawian Human Rights Commission submitted shadow reports pursuant to Rule 79.3, read together with 78.1, which allows institution, organizations, or any interested party wishing to contribute to the examination of reports on human rights situations in the country concerned to send contributions, including shadow reports, as long as these reports comply with the Commission guidelines. Secondly, I will look at the Endoroi case, which was a Kenyan case. This communication was brought to the Commission by 2 CSOs, that is the Center for Minority Rights Development Kenya and the minority right groups on behalf of the Endoroi's people. The application was further supported by an amicus curiae submitted by the Center of Housing, Rights and Eviction, Kenya was found to have violated quite a number of the Endore people's rights, importantly, the rights to property and culture. Implementation of this decision has been slow. However, thanks to advocacy domestically and at international level, the Endore have been able to now access their land around Lake Bogoria, where they are now able to carry out their religious and cultural rights. They have also been able to receive royalties from the economic activities carried out within the National Reserve. They have been able to get into an agreement with the Baringo County, which is able to give them compensation from activities carried out around their land. Third, the Endore Welfare Committee, which was registered before the Commission's judgment was issued, collaborated with NGOs in the Global South and beyond to put pressure on the government to implement the Commission's recommendation. And when it was found that the government was not complying or was not giving a report on the implementation process within the stipulated 3 months, there were efforts by the Commission to salvage the situation, which included convening an implementation hearing, which has been the only implementation hearing that has been conducted to date. Later, the ACHPR net, which is an organization that brings together over 280 NGOs and advocates from over 75 countries, joined the implementation efforts and even questioned the application of Rule 112.8 of the Commission's Rules of Procedure. And it also created guidelines and identified expertise and procedures necessary to fill the gaps. Still on the Endore case, in 2013, a working group on indigenous population was also held in Nairobi, bringing together delegates from all over except the government. And in 2014, a task force was created by the Kenyan government for the implementation of the ruling. However, the task force had its issues as it did not comply with some of the recommendations of the Commission, but we do see it as a step towards implementation. So while the government efforts undertaken to implement the Commission's recommendations are laudable, they cannot be directly attributed to the government, but to political mobilization of the community with the support of CSOs to demand compliance. The Ogiek case is another example where the CSO played a major contribution to implementation efforts. As we see, CSOs like the Minority Rights Development, Haki Jamii, continue to monitor compliance by government and develop strategies to build networks. The Ogoni case, the Nigerian case, is another case where CSOs have continued to monitor government implementation, progress, and even provide support to victims, such as free legal assistance to the victims of violation. We cannot fail to acknowledge the efforts of institutions such as IHRDA, which has continued to foster implementations of decisions of African human rights mechanisms, and especially in their efforts to seeing the decisions of the Kenya-Nubian cases implemented. They have even gone further to develop internal guidelines to follow up on implementation efforts. Just recently, in March 2003, they concluded a public dialogue with key stakeholders in DRC on the implementation of decisions passed in June 2016, declaring DRC responsible for the massacre in 2004. This event sought to assess the level of implementation of this decision and to advocate and craft strategies for the engagement of all stakeholders towards its full implementation. So why should the Commission leverage on CSOs as implementation partners? One, CSOs are able to build like-minded partnerships at national level in order to engage various stakeholders and the broader community in follow-up and implementation. It has been shown severally that where partnership already exists across sections and communities, there has been a likelihood of states to follow up on decisions as they are able to, as their pressure points, and these groups are able to assist with the sustainability of any implementation efforts. CSOs can also supplement the Commission's monitoring role. As earlier shown, they are able to submit shadow reports to the Commission highlighting the government's failure to implement. Through their social capital, CSOs can lobby for integration of enforcement mechanisms into national human rights plans of action to ensure that these issues are just not considered locally, but get a wider perspective. CSOs with legal expertise can consider utilizing litigation as a tool to enforce decision, careful though not to relitigate issues already decided by the Commission. We all know the importance of strategic litigation. And finally, CSOs can supplement the Commission's structural challenges of implementation. Through member states, they can help tap resources, pool funds from their donors for implementation purposes. So a few challenges faced by CSOs in their efforts to engage with the Commission. The major one has been registration and recognition of CSOs by the Commission, which has proven to be difficult and or problematic. There has been a lack of transparency and information, as most times CSOs are kept in the dark when states make submissions regarding implementation of decisions. And this is the reason why there has been a push for implementation proceedings to be adopted, reference being made to the implementation proceedings conducted by the Committee of Experts on the Rights and Welfare of the Child. Cost of in-person attendance, this locks out small and financially constrained organizations. So finally, I will just emphasize that the implementation of Commission's decision stands as a testament of the Commission's role as a guardian of human rights, and therefore proactive engagement of all stakeholders, including CSOs in this process, is very indispensable. So acknowledging this symbiotic relationship between the Commission and CSOs will definitely move the continent closer to the full realization and encapsulated within the Charter. Thank you.
Please just to say that, can you, I know we're pressed for time, but just to slow down a bit for our interpreters so that they can follow the interpretation. Thank you.
Thank you so much for keeping to time. Although the negative aspect is you have no choice but to speak quickly. And that is what is the challenge the interpreters are having. So the next speaker can go ahead, Ms. Beryl O'Reilly, who is a human rights lawyer working with the Kenya National Commission on Human Rights as an Assistant Director of Legal Services. And she's also a doctoral student at the University of Pretoria Institute of International and Comparative Law. Her research focuses on the right of peaceful assembly and the use of force by law enforcement officials in the context of assemblies. You can go ahead, 15 minutes, but please slow down for the interpreters.
All right, thank you very much, Chair. Good afternoon, everyone. This afternoon, I'm going to talk to you about the role of the Kenyan judiciary in the implementation of the decisions of the African Commission. And while my focus is purely on the Kenyan judiciary, I could say that I would have similar reflections in respect to other judiciaries across the continent. So first, I'll start with how the judiciary can play that role and in what instances. And then I will look at the approaches that Kenyan courts have used in dealing with decisions, not just of the African Commission, but of all international human rights mechanisms. But my main focus will be on how they have utilized or not utilized the decisions of the Commission in cases that were adjudicated before them. And then while discussing those approaches, I will illustrate using a few cases where courts placed a lot of reliance on outputs from the African Commission, and that led to better protection of human rights within Kenya. And then I will finish by looking at some of the challenges that courts have faced and opportunities that exist, which they can utilize, and even the Commission can also utilize to enhance judicial contribution to implementation of the Commission's decisions. So Article 1 of the African Charter provides that state parties to the Charter shall recognize the rights and duties within the Charter and shall also undertake to adopt legislative or other measures to give effect to those rights. By other measures, a lot of things are contemplated. Contributions from various arms of government, both state and non-state actors can contribute to the implementation of state obligations under the Charter. And one of the other measures contemplated under the Charter is domestic implementation of the decisions of the African Commission. And an important arm of government that can contribute to that is the judiciary. So where the executive, as we have learned from presentations from previous presenters starting yesterday, where the executive sets out to implement the Commission's decisions, and there is a clear structural framework for that implementation, then implementation can be as easy as making administrative decisions and ensuring that the decisions of the Commission are implemented locally. But where that is absent, where it could be that there is no political goodwill or there are no clear structures domestically to ensure the implementation of these decisions, and Parliament is also weak in terms of oversight over the executive, or if oversight is there, then it's inadequate, the judiciary can be the arm of government that gives meaning to the Commission's decisions. And how can the judiciary do that? One, while the Commission's rules of procedure do not contemplate the enforcement of the Commission's decisions by national courts, that can nevertheless be done through adjudication of human rights disputes before those national courts. So it may not be the particular, if in the cases of individual communications, it may not be the particular individual communication that was before the African Commission that is then now brought back to a national court, but it could be a case that is filed locally, adjudicated locally, but reflects the decisions of the African Commission. So one way through which courts can implement these decisions is by placing reliance in those decisions and therefore adding jurisprudential value to the decisions. And that's particularly important for clarifying continental human rights standards and ensuring that those standards are reflected in national practice. So apart from adding jurisprudential value to the decisions of the African Commission, where courts place heavy reliance on those decisions, national courts' enforcement mechanisms can kick in to implement the decisions, maybe not in respect of a particular complainant in a specific individual communication, but in respect to the public generally, where similar rights issues were raised. And yesterday, I think it was clarified that when we talk about decisions, we do not only mean the outputs from individual communications, but several mechanisms that the African Commission has in place to set human rights standards in the continent. And that includes resolutions, concluding observations, soft law instruments, for instance, clarifying state obligations with respect to certain rights. In terms of the approaches that Kenyan courts have used, in our paper, we discuss two approaches. One is the harmonization approach, where some courts incorporate the Commission's decisions when adjudicating disputes and place great reliance on them, sometimes stating that they are fully guided by the Commission's decisions. An example of such a case is the case of Jacqueline Okuta and another versus the Attorney General, which was before the High Court in Kenya. And it involved a contestation of the constitutionality of criminal defamation laws. So the Penal Code in Kenya has provisions that provide for criminal defamation. And the argument the petitioners in that case presented was that such laws were unconstitutional in the sense that they were a breach or they provided potential for infringement of the right to freedom of expression. And Um,
1 more minute.
sorry,
You have just a minute.
really? Oh, I thought I started at 2:40. Okay. Right. So, okay. So, what was I talking about? Jacqueline Okuta. Yes. So, about criminal defamation laws. And in that case, the court relied on the Commission's Resolution 169 on repealing criminal defamation laws in Africa, and stated that the move continentally had been towards decriminalizing, repealing criminal laws that provide for criminal defamation. And in that regard, the court declared those provisions of the Penal Code unconstitutional. As much as the Penal Code has not been repealed, those particular provisions are yet to be repealed, the fact that there is a decision of a superior court that declared them unconstitutional means that even if someone is arrested on those charges, they can contest their prosecution on the basis of an existing decision of a superior court. Another key case was the case of Satros Ayuma and 11 others versus registered trustees of the Kenya Railways, where the issue of forced evictions was raised. And in that case, the High Court placed a lot of reliance on the Committee on Economic, Social and Cultural Rights, UN Basic Principles and Guidelines on Development-Based Evictions, as well as the African Commission's Principles and Guidelines on the implementation of economic, social and cultural rights within the African Charter. And the court also talked about the guidelines that were developed in the Serak versus Nigeria case and stated that it was fully guided by that decision and that that was the African position on evictions. So while recognizing that Kenya did not have adequate laws that guide forced voluntary, both voluntary and involuntary evictions, there were guidelines at the continental level to do that and directed the state to develop guidelines that reflect those international and continental standards. Lastly, in terms of the harmonization approach, the court in Federation of Women Lawyers, Kenya versus the Attorney General, stated that the African Commission, when it was discussing the issue before the court, was on the right of access to information and the freedom of expression, and the court, citing the African Commission's Declaration of Principles on Freedom of Expression in Africa, stated that the Commission had gave an authoritative statement on the scope of Article 9 of the African Charter, and the court fully adopted the Commission's view on the right of access to information and found that there had been a violation. So those illustrations point to how, when courts adopt decisions of the Commission, when courts make use of jurisprudence or developments at the continental level, then human rights practice, even nationally, is improved. In terms of the avoidance approach, as the name suggests, courts sometimes simply fail to incorporate those decisions, even if lawyers litigating before them cite them. And one example I can give is the case of the Nubian Rights Forum and two others versus the Attorney General, where issues, a number of issues were raised, including the issue of registration of the Nubians. And one of the things that was sought by the petitioners was that the court, they wanted the court to declare that the state, the government of Kenya, needed to implement the decision of the Commission fully, not just the Commission, but also the African Committee on the Rights and Welfare of the Child. Unfortunately, the court addressed every other aspect of their prayers except that one aspect where they sought implementation of that decision. It was silent on it. And the perception I get is that they probably didn't want to be controversial, or they may have felt like that would have been stepping on the toes of the government a little too much, which could have exposed them to political backlash. Right. Some of the challenges of implementation in terms of what approaches courts adopt when dealing with these decisions. One of them is that sometimes there are conflicting decisions by various courts of equal status. So you may have a high court that gives a lot of or attaches a lot of importance to the decisions of the commission. And then at the same time, you have another high court stating that they fall below in the hierarchy of laws, anything from international human rights system or the regional human rights system fall below the constitution, statutory laws, and even decisions of Kenyan courts. So when there's that conflicting understanding of the value of these decisions, then you may find situations where implementation is entrenched through decisions of the national courts, and you may also find situations where they're completely ignored. The political environment can also be a challenge sometimes, and that may see courts shy away from adopting decisions of the commission. And then sometimes also there is inadequate awareness of those decisions. It is not always that courts would be aware of what is happening at the continental level. And because of limited efforts to disseminate the decisions of the commission, courts may not sometimes be aware. So what are the things that we can do to ensure that courts contribute a lot more to the implementation of these decisions? One of the things that we suggest is that there is need for constructive and structural engagement between the commission and judiciaries at the national level, especially for greater awareness amongst judicial actors on what is going on at the continental level and ways in which they can enhance the value that these African human rights systems add to human rights protection at the national level. Then it would also help to have thematic digests developed and disseminated on what the African Commission is doing with respect to certain cases. For instance, if there has been a lot of development on, say, the right of peaceful assembly, as there have, how about a digest that consolidates those developments and disseminating that digest in a way that it reaches most of the judiciaries across the continent? And lastly, there is also need for better coordination with other actors and a system of tracking developments in the African human rights system being developed so that it makes it easier for courts to adopt them in cases before them, especially by relying on them. I am sorry, I have gone beyond by about 5 minutes, but that is it.
Sorry, I made a mistake earlier. That's why I didn't stop you. So
okay, okay, but I am done. Thank you.
Thank you. Thank you so much for your presentation. And the next presenter is Mr. Pacharu Kaira, who holds a master's degree in international human rights law. And he has since 2001 been with the Deputy Permanent Representative of Malawi to the United Nations and other international organizations in Geneva, Switzerland. Prior to this, he has worked in the Ministry of Justice, firstly as a prosecutor and then as head of the Human Rights Section since 2013. You can go ahead, Mr. Pacharu. You have 15 minutes.
All right, thank you so much. And right at the outset, I want to make a disclaimer that I'm not an alumnus of the center. Yeah, it seems it's in fashion around here to be an alumnus of this. So I should probably do the needful also and join the center one way or the other. So our presentation has been named the role of other actors in implementing the decisions of the African Commission. The case of Malawi, from indifference to engagement. Essentially, I'll be telling you a story of how Malawi moved from being totally disengaged with the Commission to the current situation, which we think we are properly engaged with the Commission. In terms of the presentation, because of time, I'll talk a few things. Firstly, I'll introduce the paper. Then, as I've said that previously, we were never engaged with the Commission. Then I'll talk a little about what changed. And then I'll give a few practical examples of how the change helped us to engage with the Commission, essentially in terms of the impact of the decisions of the Commission, as well as implementation of the decisions of the Commission. And then finally, I'll share a few thoughts. So in terms of introduction, I'm saying that the main thrust of this presentation is that domestic implementation of the decisions of the Commission, or indeed any other human rights body, does not occur in a vacuum. That is straightforward, and I think that's what we've been hearing since we started with the presentations, to say that there's need for something more on the ground to help the implementation of the decisions of the Commission. So I've identified 4 things which I think have also been talked about quite a lot here. Number 1, a conducive legal environment. Number 2, an effective national coordination framework, or you can call it an implementation infrastructure. The much talked about political will, as well as the continuous capacity building of key actors. I'll talk more about the second, an effective national coordination framework, because for us, that's what made a difference for us to improve our engagement with the Commission. So I'm saying ultimately, it requires a coalition of willing and able actors who are aware of their critical roles in the human rights implementation architecture, namely members of the executive, the judiciary, the national human rights institutions, CSOs, as well as academia. Emphasis requires a coalition of willing and able actors. They have to know what their role is. They have to know what their place is. They have to know what they have to do to ensure that the decisions of the Commission are implemented and that they have an impact domestically. So from indifference to engagement, as I've already said, I'm sharing of how Malawi progressed from almost no engagement whatsoever with the Commission to active and consistent engagement the way we are today. So we ratified the Charter in 1989, and you'll see here that we only submitted our initial report in 2013. That's a lot of time. During that period, there was very little engagement with the Commission. The Commission was there, but it was largely ignored. There was minimal civil society engagement. I'm giving an example that during that time, there was only one NGO called Malawi KR, which had observer status with the Commission. And Malawi KR was founded by a commissioner, Dr. Vera Chirwa. Dr. Vera Chirwa, a Malawian who was a commissioner in the early years, is the one who founded this NGO. So you can see that at least she knew about the Commission, and that's why she helped the organization she founded to be an observer member of the Commission. And then non-attendance of public sessions of the Commission. Now for states, the main avenue in which we interface with the Commission is through the public sessions, where we make statements, we respond to issues in the plenary. So Malawi was not attending any of those at all until 2013, when we started engaging with the Commission consistently. So what changed? You remember I said that the first point is that there is need for a conducive legal environment. Malawi adopted a human rights friendly constitution in 1994. So 1994 to 2013, when there was zero engagement with the Commission, the legal environment was conducive, all right, but a conducive legal environment is not enough for implementation of the decisions of the Commission, or for the decision of the Commission to have an impact. That's why I'm zeroing in on the need to have an implementation infrastructure. So here I'm saying that this did not immediately translate to engagement with the treaty bodies, because if you talked about submission of state party reports, if you talked about responding to issues coming from UN treaty bodies, the question was, who is responsible? You go to foreign affairs would say it's Minister of Justice. You go to Minister of Justice, they say it's foreign affairs. So until a decision was made to establish the human rights section in the Ministry of Justice, that's what changed everything. Because this human rights section is a version of Malawi's national mechanism on reporting and follow-up. And it's fully dedicated to a full cycle of state party reporting and implementation of decisions. It's a focal not only as far as the commission is concerned, but also the committee, his committee, as well as the African Court. So we have the commission, court, and committee. The human rights section is a focal for all these institutions. Now, let me give a few practical examples of how establishing this section in the Ministry of Justice as a focal has helped us to implement some of the decisions of the commission, or the committee, and the court. ACHPR versus Malawi, which was mentioned yesterday. I'm not going to the facts because of time, but this was a case before the committee where Malawi was taken to the committee essentially so that we should raise the definition of the age of the child from 16 to 18. So when we went before the committee, we amicably settled this matter, but we are required to submit reports every 3 months. And this is where the human rights section in the Ministry of Justice came in very handy and very usefully, because the section worked together with the line ministry, the minister responsible for children affairs, to submit this report. And I think you heard him yesterday when he mentioned that we were able to submit those reports, 7 reports. But most importantly, we were able to meet the main term of the agreement. That is to amend the constitution by December 2017. This agreement was made in 2016. So we were able to amend the constitution. I've said here on the 14th of February 2017, and we call it the Valentine's Day Amendment. And we were able to amend the constitution, and the age of the child is now defined to at 18. Now, constitution amendment, I'm sure you testify in your various jurisdictions, is never easy. It's never easy. It requires a lot of advocacy. It requires a lot of getting all the people involved. So it means that we had to engage cabinet, we had to engage members of parliament, we had to engage civil society, traditional leaders. We are talking about the age of the child here from 16 to 18. It looks simple, but we had to engage traditional leaders because there are people who believe that when a child is 16, they are old enough. So we had to go to these people and explain to them to say, no, our international obligations require us to raise the child to 18. So it was quite an engaging experience, but key to it is that the main role, the coordinating role, was played by the focal in the Ministry of Justice. I'm also saying here that the human rights section also coordinates a full cycle engagement with the commission, the committee, and the court, meaning that the human rights section, when they wake up and go to work, their work is human rights. Their work is state party reporting. Their work is waiting for communication from the African Commission, any communication from the court, or any communication from the committee. That's their job 100%, or even from the UN bodies. So it means in terms of drafting state party reports, for example, they're involved from minute 1, data correction, coordination of drafting of the report, submission of the report, defense of the report, dissemination of the concluding observations, implementation of the concluding observations. So it's a full cycle of engagement with the commission and the court. That's what I'm highlighting here. I've also highlighted that they are also responsible for dissemination of other soft law issues, such as model laws from the commission, general comments, the many guidelines which are coming from the commission. It's also the responsibility of this focal point. And what it has done is it has made it like a one-stop shop. As far as, I can't see how many minutes. 5. Okay. And I'm saying that this is done through various national task forces comprising relevant ministries, departments, agencies, governing bodies such as the Malawi Human Rights Commission, the Ombudsman, the Legal Aid Bureau, the Prison Inspectorate, and of course, CSOs. And I've given the example here of the National Task Force on the African Charter on Human and People's Rights. We have a national task force which coordinates the drafting of reports under the Charter. It also coordinates any communication that comes from the Commission. It means if the Commission has developed model law, for example, on access to information, that information is brought to the Council for implementation. That's how it works. Now, in my remaining 4 minutes or so, maybe if I go to the final thoughts, let me just talk a bit about the enhanced role of civil society organizations which are members of the task force. I said that most of the task forces have members of the civil society organizations. So I'm saying what we have seen is that those members which are, those CSOs, which are members of the many task forces that we have, for example, the task force on the African Charter, have through strategic litigation and obtaining observer status with the Commission enhanced the role of CSOs in Malawi. And I've given an example of this CSO called CREA, which is a member of the National Task Force on the African Charter, that has been very instrumental in domestic implementation of decriminalization of petty offenses guidelines. There's a full presentation by Esther on this, but I just want to highlight that this civil society organization, if you've been to Banjul and you've been attending the sessions of the Commission, they are very active there. Not only in Banjul, they are also a member of the National Task Force on the Charter, and that has enhanced their engagement with the Commission as well as bringing issues that are brought from the Commission. If I go to the final thoughts, I just want to talk a little about how do we deal with resistant or uncooperative sectors or institutions. I'm sure for those who have worked with government institutions before, you know about the institutional cultures. You know about how certain sectors of government resist any change. And that is even more difficult when it comes to human rights issues, because the entrenched beliefs and ways of doing things. And I've given an example of the police. The police are usually said to be very resistant to human rights issues. So how have we dealt with them in terms of implementing decisions of the Commission? I've said we involve them in every layer of the cycle, including attendance of the sessions of the Commission. And I've given 2 examples that in 2015, we took the deputy head of the police to the Gambia for one of the sessions for him to see where all these things we take back home about the police have to do this, the police have to do. We took him there and said, okay, can you come and see where these things are coming from? Observe the public sessions, see what actually happens. So he went to the Gambia and observed himself, and his attitude towards the Commission changed. And then he also took the head of the training, the police training school, to the police policing guidelines, so that he should see where these things are coming from. So in conclusion, my final thoughts are that no country has a perfect implementation scheme. Context matters when deciding what model to use. And for states, work with what is available and continuously evolve, and also take into account the dynamics, the domestic dynamics. For Malawi, the human rights section evolved. It started as a human rights desk. So there was just one officer who was responsible for human rights issues. With the passage of time, it became a human rights unit, then a human rights section. So you start with where you can start. But what is key is to have a focal point on these issues. And then we have talked about political will at various levels. I'm emphasizing political will as far as the technical heads of ministries are concerned. Because usually when we talk of political will, we are thinking of the president, we are thinking of the prime minister, we are thinking of the minister of justice. But the technocrats who head these institutions, the principal secretaries, the attorney general, they too need to be in the right frame of human rights observance. So I'm highlighting that. And then also, while the mode of communication remains diplomatic routes, we need to amplify the use of networks and people you know in various institutions. And I go back to the point of a coalition. We always communicate through the diplomatic channels, but I can assure you, if you send a letter to Minister of Foreign Affairs, they are busy with so many things. It will take 2-3 weeks before it gets to the relevant person. So if there's a focal and you know someone in the Ministry of Justice, just send, while you are using the diplomatic routes, also use the informal route as well. Continuous capacity building, sharing of best practices, importing UPR successes to what we are doing. Universal periodic review, most countries, actually, I don't know of any country which has not gone through a UPR process. Countries happily go through UPR. Countries do mid-term reports on UPR. The question is, why don't we as states take the same zeal and energy from UPR and apply it to the African human rights architecture? I think I can stop there. We'll engage if there are more questions, but this is just a snippet of what the full paper presents. Thank you so much.
Thank you, Mr. Pacharo. We have all heard the enlightening and eloquently presented papers by the 4 panelists. I'll now invite Mr. Pedro for his comments, for his response.
Merci beaucoup, Madame la modérateur. Bon après-midi à tout le monde. Je disais, je remercie à Madame la modérateur. Bon après-midi aux collègues. D'abord, il faut féliciter les différents intervenants pour la qualité de leur présentation et l'importante contribution qu'ils ont proposée pour l'amélioration du processus de suivi de la mise en œuvre des décisions de la Commission. Je dois souligner que la littérature spécialisée et la réalité nous montrent que la question de mise en œuvre est un sujet de préoccupation que pour 3 raisons principales. Le manque de volonté politique qui a été souligné déjà par tout le monde, les difficultés de mise en œuvre inhérentes à la complexité des décisions, du dossier, et dernièrement, le manque de clarté de la décision, l'impossibilité objective de la mise en œuvre de certaines décisions. Les interventions d'hier ont été centrées essentiellement sur la première raison, la question de volonté politique. On n'a pas trop parlé de la question de complexité des décisions, de complexité des dossiers, et de la question dans certains cas d'impossibilité même objective d'appliquer les décisions qui sont prises. Hier, Dr. Serge a mentionné ça, il a mentionné la question de la nécessité de précision, de clarté des décisions quand on a discuté le sujet pendant le moment de débat. Et aujourd'hui, la professeure Rachel a mentionné spécifiquement la nécessité d'avoir des précisions au niveau des décisions. Et ma collègue Eunice nous a sauvé la situation. Elle nous a amené d'une certaine façon la perspective des États en partageant avec nous l'expérience quand elle a travaillé par le gouvernement. Je pense que cette conférence aussi doit être l'occasion pour nous de discuter non seulement le manque de volonté politique, mais aussi les défis qui sont posés par les décisions même de nos organes. Il ne faut pas présumer que les décisions des organes sont parfaites. Donc, c'est l'occasion aussi pour les gens qui ont l'expérience, qui ont connu des situations où les décisions prises par nos organes ne sont pas facile à exécuter, à mettre en œuvre, à mener cette expérience, qu'elle soit discutée. La commission aura tout le plaisir de prendre note de ça et pour améliorer la qualité de ces décisions. Maintenant, je vais faire donner mes commentaires sur les 4 présentations d'aujourd'hui. Mon approche sera surtout centrée dans le sens d'obtenir des éclaircissements et des contributions pour l'amélioration du travail de la commission. Donc, je vais chercher de poser des questions aux intervenants et répondre pour donner une certaine notre vision de la commission sur certaines propositions. Je vais commencer d'abord par la présentation de Madame Deborah Nyokabi. Je pense que j'ai bien prononcé le nom. Elle a parlé sur la nécessité de catalyser le rôle des INDH africaines dans la mise en œuvre des décisions de la Commission africaine. Madame Deborah nous a présenté un cadre institutionnel et juridique sur la collaboration entre les INDH et la Commission dans le suivi de la mise en œuvre des observations de la Commission, la participation des INDH en tant qu'amicus curiae dans la procédure de communication. Elle nous a fait part de certaines bonnes pratiques dans le domaine de suivi. Elle a toutefois souligné qu'il faut une collaboration efficace entre la Commission et les INDH en termes de participation au processus d'élaboration des rapports, le suivi des mises en œuvre des observations générales et finales, et ainsi la procédure de communication en tant qu'amicus curiae. Pour noter qu'en théorie, la collaboration entre les INDH et la Commission peut faciliter le suivi de la mise en œuvre des décisions et recommandations de la Commission. Cependant, le défi peut se poser quand il s'agit d'une INDH qui n'a pas de réelle indépendance par rapport à l'exécutif de son pays. Dans ce cas, Mme Deborah semble proposer l'application des sanctions. Oui, les sanctions peuvent être appliquées en dernier ressort, mais il faut la flexibilité pour éviter des situations où un INDH est sanctionné doublement. D'abord par son gouvernement, ne donne pas l'indépendance nécessaire pour mener son mandat, et aussi par la Commission qui le sanctionne pour avoir perdu, disons, les qualités nécessaires pour maintenir le statut d'affilié. Donc, je pense que la flexibilité est nécessaire de façon à ne pas, au lieu de engager des INDH qui traversent des périodes de troubles, la Commission peut les éloigner même et ça peut ne pas être une bonne approche pour la promotion et la protection des droits de l'homme. Ensuite, il y a eu l'intervention de Mme Patricia, qui est centrée sur la contribution de la société civile à la mise en œuvre des décisions de la Commission africaine. Elle a présenté un cadre juridique théorique sur la mise en œuvre des décisions et son intervention a été axée sur la participation de la société civile à la mise en œuvre des décisions de la Commission, que selon elle peut consister à fournir des informations à la Commission sur les efforts déployés par le gouvernement pour mettre en œuvre les décisions de la Commission, ainsi que le soutien de la société civile aux victimes dans leur interaction avec le gouvernement dans le contexte de la mise en œuvre des décisions de la Commission, soit au niveau des communications individuelles, soit au niveau des recommandations des rapports périodiques. Elle a mentionné la possibilité de mobilisation de fonds. Et ça, c'est très intéressant, ce point, parce que il y a des États qui ne sont pas suffisamment crédibles pour mobiliser certains fonds devant des partenaires. Donc, la société civile peut être un outil pour supprimer le gap et obtenir des fonds et utiliser ces fonds pour aider l'État à implémenter, à mettre en œuvre des décisions de la Commission. Il faut noter qu'en ce qui concerne la société civile, le cadre juridique est clair quand il s'agit de saisine, la saisine de la commission, surtout dans le contexte des communications, article 55 de la charte. Mais la situation est un peu différente quand il s'agit de suivi de l'exécution. Surtout quand la commission conduit les audiences publiques pour discuter avec les parties prenantes les mécanismes ou les mesures qui ont été prises pour mettre en œuvre ces décisions. Parce que dans ce contexte, la commission est guidée par le principe de la confidentialité et la société civile peut ne pas être au courant des discussions qui sont en cours. Il faut noter que la société civile, elle peut être utile dans la mise en œuvre de certains types de décisions ou de recommandations que la commission prend, surtout au niveau de communication individuelle. Par exemple, quand la commission ordonne des mesures de non-répétition. Si la commission ordonne des mesures de non-répétition, la société civile peut travailler avec les autorités nationales dans le sens que la décision prise par la commission ne soit pas une décision qui va s'appliquer seulement aux parties devant la commission dans un affaire précis. Donc, la non-répétition peut aussi être mieux utilisée pour s'appliquer dans le changement de la politique de l'État, de façon à ce que les violations qui ont été constatées ne se reproduisent pas. Donc, la société civile peut être extrêmement utile dans ce sens. Une autre mesure dans laquelle la société civile peut être utile, c'est la publication des décisions de la commission. Des fois, la commission ordonne l'État défendeur à publier ces décisions dans leur portail, dans leur bulletin officiel de leur pays. Il s'agit d'une question de dissémination de la décision de la commission. Donc, la société civile peut le faire même si la commission ne l'a pas ordonné. Il y a des ONG qui ont des radios privées, qui ont leur propre site web et d'autres mécanismes de communication qu'ils peuvent utiliser pour disséminer la décision de la commission. Madame Patricia a présenté quelques défis, dont le défi qu'elle appelle l'opacité du processus ou de la procédure devant la communication, ce qui entrave l'accès à l'information. Oui, ça c'est vrai. Le principe de la confidentialité veut que l'accès à l'information disponible dans le dossier ne soit possible qu'aux parties. Mais quand la décision est prise et le rapport de la commission est adopté par les organes politiques de l'Union africaine et la publication des décisions qui sont contenues dans ce rapport est autorisée, naturellement, la question de l'accès aux informations ne se pose plus. Mais en tout état de cause, s'il y a des difficultés à partir de ce niveau d'accéder à l'information, je pense que la société civile peut s'adresser à la commission et obtenir des informations qui sont nécessaires. Ensuite, il y a l'intervention de Madame Beryl, M. Paul, qui est le rôle de judiciaire kenyan dans la mise en œuvre des décisions de la commission. C'est une très intéressante présentation qui nous a démontré comment démontrer le niveau de contribution du judiciaire du Kenya dans l'utilisation des dispositions du droit international, soit pour compléter le droit interne, soit pour intégrer les lacunes existantes au niveau du droit interne. Et le judiciaire du Kenya le fait aussi également en utilisant la jurisprudence de la commission. Ce que je n'ai pas pu capté, disons, de la présentation de deux collègues, c'est la situation dans laquelle le judiciaire du Kenya a pu prendre une décision pour obliger le gouvernement du Kenya à mettre en œuvre une décision de la commission. Le judiciaire, la présentation montre l'utilisation du droit international des droits de l'homme, la jurisprudence du droit international des droits de l'homme et des jurisprudences de la commission, mais j'attendais que les collègues nous donnent des cas où le judiciaire du Kenya a pu être utile pour l'exécution de la décision de la commission. Nous savons que des fois, la commission renvoie au droit interne, notamment la détermination du montant des réparations pour les victimes. La commission constate la violation, mais elle ne détermine pas le montant des réparations. Elle renvoie au droit interne. Et quand elle renvoie au droit interne, la détermination du montant des réparations peut être faite par les organes politiques et aussi par le judiciaire lui-même. Est-ce qu'au Kenya, il y a eu des situations où le judiciaire a déterminé le montant des réparations? Dans le cas, par exemple, de Honduras, la commission a ordonné que le montant des réparations soit déterminé au niveau national. Est-ce qu'il est possible au Kenya que le judiciaire puisse déterminer ce montant? Dans le cas, si le gouvernement ne l'a pas fait, mais apparemment le gouvernement ne l'a pas fait jusqu'à aujourd'hui, est-ce qu'il est possible de saisir au Kenya les juridictions nationales pour faire déterminer le montant des réparations aux victimes dans le cas, par exemple, de Honduras? Je sais que dans le cas d'Ogiek, la Cour a déterminé le montant, mais dans le cas d'Honduras, ça n'a pas été le cas. Donc, c'est une question que je pose aux deux collègues qui ont présenté ce papier. Ensuite, il y a le dernier intervenant, c'est M. Pacharo, qui nous a mis au courant de changements d'orientation ou de politique de Malawi, de l'indifférence à l'engagement. Il est intéressant de constater ou de savoir l'expérience d'intégrer un agent de la police dans la délégation qui participe aux sessions de la commission. C'est une très bonne pratique, peut être répliquée dans d'autres pays. Il a aussi mentionné le fait que la diplomatie, des fois, n'est pas efficace. Nous tous, nous sommes des Africains, nous savons que des lettres, on veut envoyer des lettres, n'est pas un mécanisme efficace pour résoudre des problèmes. Des fois, il faut parler, il faut aller voir les gens. Donc, quand on envoie des lettres au ministère des Affaires étrangères, si on peut parler à quelqu'un qui est là-bas, ça peut être un mécanisme pour faciliter et accélérer le processus de prise de conscience de la décision de la commission et faciliter sa mise en œuvre. Ce que je voulais, la dernière question que je voulais poser à nos collègues est de savoir qui a contribué, quels sont les facteurs qui ont contribué au changement d'orientation du Malawi. Et si la commission, les missions de promotion de la commission a eu un impact dans ce sens. En plus, je vais faire certains commentaires généraux. Le premier commentaire, c'est que il ne faut aucun doute que la participation des différents acteurs au processus de mise en œuvre des décisions de la Commission dépend du type, de la nature de la décision, ainsi que des mécanismes internes de chaque pays. Et ça a été souligné par le professeur Rachel et d'autres intervenants. il faut noter que les pays de common law, ou les pays de civil law, ont tendance à être un peu plus restrictifs en raison de l'application du principe d'intérêt à agir, contrairement aux pays de common law qui sont plus ouverts à l'intervention de la société civile. Ça veut dire que la société civile dans le pays, le système de common law, a plus de marge de manœuvre au niveau de participation dans le processus de mise en œuvre des décisions, y compris la possibilité d'accéder à la justice pour faire exécuter les décisions de la Commission. En tout état de cause, la société civile et les INDH doivent toujours pouvoir profiter des ouvertures existantes dans leurs pays respectifs. Chaque pays a ses propres mécanismes. Il y a des pays qui sont plus dotés des instruments et de cadre légal institutionnel pour faciliter la mise en œuvre. Il y a d'autres pays qui n'ont pas ces conditions, mais il faut toujours profiter de l'ouverture existante. Des fois, le simple fait de s'approcher aux autorités et de leur dire voilà une décision qui a été prise par la Commission, qui jusqu'aujourd'hui, elle n'a pas été exécutée. Le simple rappel peut suffire à la mise en œuvre d'une décision. Je donne l'expérience de mon pays. Oui, ce n'est pas vraiment un cas d'exécution, mais c'est un cas qui illustre que le simple rappel peut être suffisant pour obtenir des résultats envisagés. En 2017, la Cour africaine, une délégation de la Cour africaine a visité la Guinée-Bissau, mon pays. Pendant l'audience avec le vice-président du Parlement, le vice-président du Parlement nous a dit clairement la Guinée-Bissau n'a pas ratifié le protocole portant création de la Cour parce qu'on a oublié. C'est simple, on a oublié. Il n'y a pas de raison politique, on a juste oublié. Après quelques temps, non seulement ils ont ratifié le protocole, mais ils ont aussi déposé la déclaration qui donne l'accès direct aux individus et aux ONG. Donc, c'est juste un rappel. Et des fois, il faut profiter de l'opportunité pour le faire. Il y a des changements permanents de gouvernement. Un nouveau ministre peut ouvrir l'opportunité pour faire exécuter une décision de la Commission. La société civile, les INDH qui sont dans le terrain, ils sont plus en mesure de réagir rapidement aux changements dans le pays, y compris dans les situations de changement anticonstitutionnel. Il ne faut pas oublier que la vocation des institutions des droits de l'homme, elle est aussi humanitaire. Même s'il y a des changements anticonstitutionnels, si c'est le gouvernement de ce contexte-là qui va faire exécuter une décision, il faut profiter. Donc, si ça dépend de la Commission a tendance à réagir un peu lent. Mais la société civile qui est sur place, les INDH qui sont sur place, ils peuvent facilement réagir et faire exécuter une décision de la Commission, même sans l'intervention de la Commission. Donc, il faut aussi une certaine autonomie de la part de la société civile pour faire avancer le processus d'exécution des décisions sans dépendre de la Commission. Donc, je pense que des fois, comme dernier commentaire, nous donnons plus d'importance, ou nous exagérons au niveau du cadre institutionnel, des lignes directrices, alors que la réalité, elle est trop dynamique. La réalité africaine, elle est flexible. Ouais, je vais terminer. La réalité africaine, elle est très flexible. Il faut adopter une approche pragmatique. Tu peux passer pour parler. Tu peux passer pour utiliser des voies informelles. Parce que des fois, quand vous écrivez, c'est là où vous compliquez la situation au lieu d'aider. Donc, il faut africaniser un peu notre mécanisme d'exécution des décisions de la Commission, notre organe des droits de l'homme de l'Union africaine. Merci beaucoup.
Thank you so much, Mr. Pedro, for the interventions from the Commission. Now, the floor is open. Mr. Pedro has already asked some questions. So before then, for participants joining online, I think somebody wanted to ask a question. Can we start with such participant?
I audible, Madam Chair?
Yes, you are. Go ahead.
Thank you. Yes, I'm Franz Verloon, and I just want to say that I'm usually there. I would have been there at the center, and I'm the one missing out. So many of you may know that I am actually here in Montreal on my sabbatical. And I'm happy to be here, but sad not to be with colleagues and friends. And from what I can learn, very interesting discussions. The time zones are a bit against me, so I miss what is usually the morning session. But I would like to just make two brief comments, if I may. First, to Beryl, whose paper I could hear. I'm reiterating gladly, Beryl, the point you made about a case digest, a discussion of the case law of the Commission as a vehicle to give the state of the law, as it were, and to disseminate those widely. But I want to amplify or maybe redirect. I think it's actually an opportunity for the Commission also to work with the other two African human rights bodies, the court and the committee, because I think from the consumer, from the user's point of view, one would be interested in the case law of the African human rights system with the commission, the court, and the committee. So it is actually, I think, a wonderful opportunity, perhaps for the three bodies to work together to develop such case law guides, if you like, maybe draw on the common approach. This will also lead to greater coordination, perhaps between the bodies, and broad dissemination. I think one can take a leaf from what the Council of Europe or the European Convention has been able to achieve, the European Court through the interpretations and the guides that they bring out on the European Convention. So I think that's an interesting and important about how that can disseminate back to the national judiciaries and more broadly than that, obviously. And then just briefly to my friend and colleague Pachero, maybe not of the center, but certainly a supporter of the center. I found your remarks very interesting. And you mentioned Commissioner Vera Chirwa. You may know that the center also has a prize for our alumni, mentioning her in name. The prize of the Vera Chirwa Award is for someone who keeps the human rights light shining, as it were. And I thought maybe this is a time for Malawi also to think of nominating someone in this new epoch of human rights commitment from the country to also serve maybe as a member of the commission, which would be very interesting. And Pachero, I just want to throw back to you the question you posed. You asked, why does it so happen that the African states are more likely to take seriously and work with the UPR than, for example, with the African Commission? Maybe you can offer also some suggestions and ways out of that conundrum. Thank you so much, and good luck to everyone. And thanks and congratulations to Fulusho and the team, and also to the Commission, the chair, the members there, the secretariat who are working with us on this. We really feel honored and privileged to work with you. Thank you.
Prof. Murray, can you hear us? Can you please make your intervention?
Yeah, I can hear you. Can you hear me?
Yes, we can.
Yeah, thank you. And thank you for the fantastic presentations. I just had a couple of points. Firstly, just to follow up on Deborah's presentation, it was a question for the Commission and the extent to which the Commission reaches out to national human rights institutions for information on the implementation of specific cases. So whether it proactively asks the NHRI for information on what is being done to implement the decisions. And just picking up on Patricia's final point about sort of visibility, I think one of the challenges here is a sort of, although, and Pedro noted this, the issue around confidentiality when decisions are pending and have yet to be concluded and adopted by the Commission. I think that element of confidentiality, and I know that this is something that the litigants group will pick up on, sort of bleeds into post-decision visibility of the decision. And I think it's just it doesn't need to be complicated in terms of information that the Commission publishes on what the state has done to implement the decision. It doesn't even need to be complete, but I think making that information visible on the decisions, the information that it has, is a really important first step. And my last comment was a question to Beryl around enforcement of Commission's decisions in domestic courts as a foreign judgment. I know this came up as a discussion in Zanzibar, I think, at the seminar that the Commission organised, but the extent to which the Commission's decisions can be seen as a foreign judgment and therefore implemented in domestic courts. And I know there are some questions around this, but I think it's a useful thing to explore. So I'd be just interested in her views on that. Thank you very much.
Tawanga, can you just make your intervention, then we'll return to the room after you. Thank you.
Thank you so much for the opportunity, and thank you to all presenters for amazing work. I just have a few quick questions. For Deborah and the second presenter, I noticed the role that maybe the human rights institutions are playing and the CSOs are playing, but what I didn't get much was on the issue to do with what then can the African Commission do to intensify its work to support the efforts that are being made. For the second presenter, there was also even a best practice, but it was a once-off thing. So I was more interested in what could be done more. And for the third presenter, I think I found that quite interesting because my research is around that area. I noticed the challenges that are there in terms of taking the African Commission's jurisprudence and then using it in African courts. I know Kenya is very progressive than my country, Malawi, but what I wanted to understand is what could be done more in terms of harmonizing, in terms of the judicial officers harmonizing that and leveraging on that. I noticed you noted that as a challenge, but my suggestion would be maybe to have some kind of guidelines. I'm saying that because the research I'm talking about, I'm doing two research papers, one with the Center and one with Lilongwe Investor for Agriculture. I'm doing an MSc in Gender and Development. So I've been interviewing judicial officers, such as magistrates and high court judges, on how the SADC model law could be implemented in Malawi. What I noticed was the very same thing, that judicial officers or the high court judges and the magistrates can have international instruments. And they also have different beliefs because of their different biases. Is there any way of coming up with guidelines to guide them so that those disparities are not there? From Pacharo, I just wanted to understand what the progress has been in the implementation of the recommendations from the African Commission for the country. And I would also just like to also comment on what Professor Franz said as my final comment on the issue of case law. I feel like this is a great opportunity for the African Commission to leverage on this as a best practice, even though there's been an issue of autonomy or maybe sovereignty of the state. But maybe this question is also for the African Commission. What lessons can we then draw from this in terms of abiding, where we need to abide by human rights, but also we have countries, African countries, that have disparities in terms of maybe African essentialism when it comes to human rights, and yet we have human rights violations on that. Again, my last comment for the African Commission is the inconsistencies that we have from the African Commission. My research with the center is looking at jurisprudential efficacy of the African Commission on certain decisions, like on minority rights. What I notice is that sometimes you can have the resolution 275 on minority rights, and then the same African Commission will be talking about African values and then essentialism and making controversial decisions. So probably my suggestion would be, since we draw a lot of inspiration from the EU human rights system, maybe we need to strike a balance about what we believe as African essentialism and what is supposed to be the best practice at global level, if that makes sense. Thank you so much.
Thank you. Any questions, comments, observations? Okay, let's start this from you.
Thank you, Chair. My question is directed to all the panelists. I understand that the issue of political will seems to be a very important issue when we talk of dialogue and interventions. So can political will be forged? Is there a way that, you know, we can identify political will as a specific discipline, study it, find out ways to counter it, and find out ways to leverage it to our advantage? I say this because I see the other side, quote unquote, is doing this really well. For instance, when you look at the situation in South Sudan, you have the government bringing a lobby group to prevent the establishment of the hybrid court. It's financed, it has a specific mandate. So can countermeasures be put in place that we want to do something that is actually positive, and we are financing, we are bringing in experts to help us understand the political situation and so forth. So yeah, thank you very much.
Thank you very much, Chair. It was really nice to hear from the warm heart of Africa on the good practices. I just wanted to ask perhaps maybe the Commission whether there is a possibility to have a platform where good practices can be shared by states, you know, maybe on the sidelines of the Commission session, such good practices, so that, you know, other states can emulate things that are working to enhance, you know, the decisions of the African Commission. Thank you so much.
It seems those are the questions so far. So I'll call on Ms. Deborah Nyokabi.
Yeah, thank you, and thank you to the plenary for the important questions. I think I'll begin with Pedro's reflection on what is cited as a challenge of independence of NHRIs, which could be maybe a real challenge, but also we can strengthen that independence as stakeholders in this room, as civil society organizations and the African Commission, by participating in the accreditation process, since there's room for submission of comments on the reality on the ground, and that could really strengthen the independence and eliminate those fears. I think the second question has been asked by Professor Murray, and that is with regard to the African Commission reaching out directly to NHRIs. So probably the Commission can reflect on that, and in relation as well as the requirements by the Commission's rule of procedure to directly transmit concluding observations, decisions and activity reports to NHRIs, if that is happening, and if not, what could be the challenge there? I think that question was on how the African Commission itself can intensify efforts that are already put in place by NHRIs and CSOs. And one of them is, of course, the direct dissemination that I have referenced, but also making the studying agenda item on the relationship between the Commission and NHRIs and NGOs very interactive. I think currently it's limited to taking decisions on affiliate or observer status, but there can be an interactive dialogue on some of the alternative or activity reports submitted, and that could really strengthen the dialogue between the Commission, NHRIs, and CSOs. And the last question that was asked was with regard to political will. I do think NHRIs are key actors in bridging political will at the national level, as well as at the regional level, and that's why I've proposed engagement of the EU policy organs and having reflections on implementation during the annual policy dialogue, where members of the permanent representative committees are usually present. And in conclusion, there's a very potential and effective role for NHRIs to play, and that calls on maybe standardization, development of guidelines and templates on submission of alternative reports, activity reports, and annual reports to ensure that the status of implementation of decisions is a standing item in those reports, as well as clarifying the role of national human rights institutions in NMRFs, as well as creating implementation units at the Secretariat of the African Commission with a specific unit dedicated to NHRIs and CSOs. I submit. Thank you very much.
Thank you so much. Ms. Patricia. Yes.
Thank you, Chair. I think I got one question on what can be done by the Commission, what more can be done by the Commission and the CSO together. So what I would say is maybe organize joint meetings, for example, where these meetings can definitely generate a larger audience and give rise to better recommendations. They can make connections of joint advocacy, like the one that was done for the Eritrean situation, which led to the suggestion that the Eritrean dire situation be submitted to the AU in 2013. So I think it is on a case-to-case basis on what is the best way to address or work together. Thank you.
Thank you so much. Please, your response to the questions, Ms. Barrow.
Thank you, Chair, and thank you, colleagues, for the questions, which were quite a number. I hope I got all of them. So first, Mr. Pedro asked about the role of the Kenyan judiciary, whether the Kenyan judiciary can enforce decisions from the African Commission, for instance, award compensation in or determine what compensation to award where the Commission has already made a decision. If a case is referred to the Kenyan courts for purposes of determining what compensation to award, then yes, the Kenyan courts can entertain such a case, and domestic laws will apply in determining what compensation to award to what particular person, or the nature of the remedy that a person is entitled to, depending on the right that is in question. So yes, that can happen. Then there was also the question by Professor Murray on foreign judgments, enforcement by Kenyan courts or foreign of judgments of foreign courts. So Kenya does have a law, the Foreign Judgments Reciprocal Enforcement Act, which permits Kenyan courts to enforce decisions from foreign court, but specifically where those decisions relate to are monetary in nature and not any other. Now, the challenge that I think the Commission would have to contend with is the one that comes to my mind immediately is, would a Kenyan court consider the Commission to be a court as per the definition of what a court means in the Act, in the Foreign Judgments Reciprocal Enforcement Act? And I say no, as per that Act, the African Commission is not a court, because what is the courts that are contemplated under the Act are courts of foreign countries, or courts, domestic courts in other countries, and not international forums. Then there was also a question on what can be done in terms of harmonizing, or whether guidelines for use of decisions by the African Commission can be developed so that there are minimal disparities in terms of how domestic courts make decisions. I think that can happen. It would be helpful to have such guidelines, and that is why we propose, other than guidelines, we propose that it's important to have those case digests where people who, or forums that want to utilize these decisions, have an easy way of referencing what the general practice is, because even the African Commission itself, it's not like all their decisions in respect to certain cases are uniform. Sometimes the Commission decides differently with respect to the same issues that are brought before it. But when you consolidate their practice in one place, it is easy for someone to establish a pattern. What is the direction that the African Commission has taken with respect to a certain case? But another counter argument that someone may come up with, and I would imagine that would happen with any judiciary, is that judicial officers should be independent in terms of how they make their decisions and why they make those decisions. And there should be nothing wrong with a judicial officer deciding not to be guided by the decisions of the African Commission. So having a guideline, again, can be contested in terms of, are you directing courts on how to make decisions with respect to certain cases? But I think it's a good suggestion. Then on political will, I think that has been addressed by Deborah, but I would also just like to emphasize what my colleague Pacharo said about what this thing called political will means. It doesn't just refer to the topmost leaders in any given country. It also refers to what people, even heads of national human rights institutions, or even the officers working in those national human rights institutions, what do they perceive their role to be in terms of contributing towards implementation of these decisions of the African Commission? So it's good for that understanding to permeate all levels of government, all actors that contribute to the implementation of these decisions. Yes, I think, I hope I haven't left any question out.
Thank you so much. And we move on to Mr. Pachero for his comments. Thank you.
All right, thank you so much. First question from Pedro was, what contributed to the policy change of the government of Malawi, essentially to establish the human rights section as a focal point? As I said, that political will has to be looked at two layers: the political will in the political strict sense, as well as you're saying, at the technical level. So for us, the change was largely at the technical level. We simply had more progressive people in the Ministry of Justice who discerned the need for the Ministry of Justice to be a focal point as far as human rights issues are concerned. So that was the main driving force. We had human rights minded people in the Ministry of Justice who were very progressive, and they simply said, okay, can we establish, as I said, firstly, a desk which grew into a unit and then a section. So that process started way before the formalization. You know, in government processes, for you to establish a department or a section, you go through several layers. It was established informally first, started its work, then it was established formally later on. So that's how I'd answer that one. In terms of whether the commission had a role, I would say that the commission has had a role in terms of the growth of the focal point, in the sense that when we started engaging with the commission, we noticed that the more we engage with the commission, the more we are given a platform in the activities of the commission for us to share our experiences. So you go to the public sessions in the Gambia, you would find that because we are engaging with the commission, they gave us more room to be on panels. They gave us more room to showcase good practices in Malawi. So that has helped the section to grow in terms of capacity. But I would also want to mention the role which the Center for Human Rights has played. because all members of the human rights section in the Ministry of Justice have in one way or the other been trained at the Center for Human Rights. So the Center for Human Rights runs short courses, rights of women, policing, and whatever. So we have made sure that progressively, any officer who is a member of the Human Rights section in the Ministry of Justice should attend those courses as a way of giving capacity to the section. There was also a question from France on firstly, why do states take the UPR more seriously than the African system? Well, for starters, the UPR is a peer review mechanism. So it's states reviewing other states. So states seem, in my view, in my estimation, they seem to be more comfortable to be reviewed by fellow states as opposed to treaty bodies. And then the other thing is that with UPR, the recommendations are, you can reject some recommendations. So if they tell you something which you don't want to do, you simply say, I don't want to hear that. But with treaty bodies, you have a whole range of recommendations, and you don't share the pig to say, we like this, we like this, we like, or we don't like that, but they come as a whole. So I found that states are pretty comfortable with the UPR because it's a peer review mechanism. However, as I said, I think it's something which can be used. The energy, which is the information which we use to compile reports under UPR, it's essentially the same which we can use to compile reports under the African Charter. So I think it just needs a mindset change. For us, for example, in Malawi, we have continuously used the information which we use for UPR to submit our reports under the Charter. So it's largely a mindset change. And then there was a question, not a question, but really a comment on Vera Chila, who was the only Malawian to be a member of the commission so far, and the suggestion that maybe it's time for Malawi to nominate another person to be on the commission. We were discussing the same thing over the lovely gala dinner yesterday. I think Lloyd raised it, and Japheth too, to say, shouldn't Malawi nominate someone? I think it's something which we should consider seriously. Of course, I can whisper to you that they were suggesting that I should consider joining the commission. So I said, no, I need more gray hairs like the prof over there before I join the commission. Yeah, so that's something which we will consider seriously. Tawonga asked a question. Actually, Tawonga, if you notice, the name is Tawonga Kaira. She's actually my sister, and she decided to ask me a question. Yeah, she was asking the progress which we have made in terms of implementation of recommendations of the African Commission. Now, the progress is, as the word says, progress. It's progressive. So there are certain areas we have really made good progress. I can refer to the model law of the Commission, which we used literally almost word for word to come up with the Access to Information Act. The model law on access to information of the Commission, we used it almost word for word to come up with the Malawi's Access to Information Act. I can also mention the guidelines on policing, the decriminalization on petty offenses, although that one has come more largely because of the progressive, I'll not use the word activist judiciary. I think I would say progressive judiciary. In that area, we have also made quite a lot of progress. So broadly, I would say, in terms of recommendations, it takes time, it needs patience, it needs a lot of coordination. So we have made progress in some areas, but there are certain areas which we really still need to work on. I think I've answered everything.
Thank you so much, Mr. Pachero. I think there are some questions directed at Mr. Rosa. Please.
Merci, Madame la modératrice. Le premier commentaire que je voulais faire, c'est relatif à la nature juridique des décisions de la Commission devant la juridiction nationale. Le commentaire qui a été fait par la professeure Rachaud. C'est une question très technique. Notre collègue de Kenya l'a soulevé aussi. Les décisions de la Commission ne sont pas contraignantes, au moins si elles sont comparées avec la décision de la Cour, n'étant pas contraignantes, quand elles sont présentées devant la juridiction nationale, la première question qui se pose, elle est de savoir, est-ce qu'une juridiction nationale peut transformer une décision qui n'est pas contraignante en une décision contraignante? Et si la juridiction nationale le fait, elle le fera sur la base de quelle disposition? S'il y a une disposition de droit interne dans ce sens, la question sera plus facile. Je pense que l'un des intervenants a mentionné le cas de Maurice, là où la Constitution dit clairement que les décisions des organisations internationales doivent être appliquées. Mais dans l'absence d'une disposition de droit interne qui indique que les juridictions internes doivent appliquer les décisions des organisations internationales, notamment des organes de sauvegarde des instruments de droits de l'homme, ça sera plus, c'est une question qui dépendra de la capacité de judiciaire de chaque pays d'adopter une approche progressive. Je me souviens qu'au Portugal, bon, je mentionne le Portugal parce que c'est là où j'ai étudié, je connais un peu leur système. Le Portugal a dû adopter une législation interne pour dire que les décisions de la Cour européenne des droits de l'homme sont exécutoires. Ce sont un titre exécutoire. Au même titre que les décisions des juridictions internes. Ça veut dire qu'avant cette législation, la procédure pour faire exécuter ces décisions, c'était une procédure d'exécution des décisions des juridictions internes, alors que la décision de la Cour européenne n'est pas vraiment une décision de juridiction externe au sens classique du terme. Donc, je pense que c'est une question ouverte aux discussions. La participation, la contribution des organisations de la société civile, de tous les partenaires, des acteurs du système africain des droits de l'homme devront contribuer à une approche progressiste, dans le sens que les judiciaires de nos pays acceptent les décisions de la Commission et des autres organes de sauvegarde des droits de l'homme de l'Union africaine comme étant des titres exécutoires. Sur la question de plateforme de partage des bonnes pratiques, d'abord, les sessions de la Commission, c'est un moment où les États, quand ils font leurs interventions, ils partagent les bonnes pratiques. Les différentes activités qui sont organisées par la Commission sont aussi des plateformes de partage des bonnes expériences. Formellement, il n'y a pas un mécanisme, disons, de partage, mécanisme là où on peut placer les informations de bonnes pratiques. Donc, c'est un système un peu flexible qui dépend de l'opportunité que la Commission, que des États membres ont pour faire passer leur message. Par exemple, ce que le Malawi a fait aujourd'hui, c'est l'un des exemples où on peut profiter de l'occasion de cette conférence pour faire partager des bonnes pratiques. Et finalement, la question de political will, volonté politique. Je vais juste partager une expérience.
Sorry, I don't want to interject, but it's like I've just been informed that we have exceeded our time.
OK. Je laisse ça pour la discussion du corridor. Merci.
Thank you so much. Please, can you give another round of applause for all of us, for the panelists? in as much as we have just eaten lunch, but because of the presentations, we're quite interesting. I've not seen anybody sleeping. So I thank you so much and for the opportunity to chair this session. Unfortunately, I've not recapped what everybody has said because most of you, almost all of you here are experts on the field. Thank you so much once again.
Thank you very much, panelists. That was really engaging, and I think we can all agree that there are many perspectives that cannot be explored to their depth. But we thank you for those perspectives, and also to ourselves for keeping awake. Thankfully, we have a time for a break, so we can break off for 6 minutes for coffee, tea, and to stretch our legs so that we can energize ourselves for the next session. And I'll seek your indulgence in terms of your attention and your energy, as well as your full engagement in the next session. Let me just announce that we have the last session, which will be chaired by Dr. Victor Ayeni, and the panelists are Sydney Tambisa and Dr. Esther Gumbo. I hope I've pronounced the names properly once again. But may I just ask that after the tea break, the panelists and the chair may take their seats so that I don't have to come back here and we don't have to eat into time. I have 2 announcements before we break off for the tea. One is the reminder that for those that have not signed the register, please do sign. And the last and very important is that the drinks tray is still very full. We may want to visit it and empty it before we go. So thank you very much. Enjoy the break and let us get back within 6 minutes.
That was the
May we please get settled and start the session for the afternoon? Zinab, could you please ask everyone to get in so that we could start for the afternoon?
Good afternoon, everyone. This is going to be the last session for the day, and I believe we are going to be very brief because the day is well spent. Before starting, I just want to make a comment that as we are well aware that 3 frameworks have been used to assess the works of human rights bodies. We discussed one of them very well yesterday, implementation and impact. I think today we have discussed so much the second framework, which is impact. And the third one that many scholars have been talking about is effectiveness. And how they got there is they realized that compliance is too narrow. It's actually too simplistic. In fact, some people say it is reductionist in the sense that it doesn't capture the full weight of the effect and impact of decisions of the commission. So we quite acknowledge that. So from today, I think till tomorrow, now we'll be talking more about impact at the domestic level. So that's what the discussion today is going to be about. So we have just 2 presenters for the presentation. The first person is Mr. Sydney Tambasi. Mr. Sydney is the lead editor for Africa, Afronomics Law Academic Forum. He's also a pupil at ANN Kenya. He's a legal practitioner from Kenya. The second presenter, I believe, is Dr. Esther Gumbo. Dr. Esther is a senior lecturer at the Nelson Mandela University. She teaches international criminal law. And I believe when you look at the topic she's taking, she's very well positioned to enlighten us on the topic. So without wasting so much time, please allow me to ask Mr. Sydney Tambasi Ooh, okay. Thank you. Thank you very much. So each presenter is going to speak for 15 minutes, like the other presenters have done. The African Commission's respondent for the session is going to be Ms. Abiola Idowu-Ojo, who has been responding on behalf of the Commission since yesterday. And also, of course, Ms. Eunice has also been responding. So, but for the session is going to be Ms. Abiola. So the presenter, you have 15 minutes. Please keep to time. Thank you.
Thank you, Victor, so much for the introduction. So at the end of my presentation, I hope that when you think about everything I've said, what should be very clear should be that of all the interactions, of all the efforts or push for justice and for the recognition of the rights of ethnic minorities, at least in Kenya, I think the most robust or the tipping point for me has been what I call the interaction with the African human rights system. That at the point at which the state was called into question and asked to answer for its fulfillment and right to respect the rights of ethnic minorities, that is when we started to see tangible, measurable steps towards this direction. But Chair, esteemed members, allow me to begin from the very start. Of course, my name is Sydney Tambasi, and the topic of my presentation is highlighted. At least that was the conceptualization of it when I thought about it. But two things have pushed me to a slightly different direction. One was very pragmatic, because as I sat down and listened to experts after experts speak about different areas, I kept deleting sections of my presentation. By the time I got here, my whole presentation was gone. So I did not want to come and, say what has already been spoken. The second was more personal. It was an inspiration of my own curiosity, because as I kept reading the two decisions, as you can see, my presentation is focused on the case of the Nubians. And we know that two decisions have been rendered at the committee and one at the commission. I was fascinated by what I read in terms of the judgment and the pronouncements and the decisions, as well as the literature around it. But what I didn't seem to see was why, the why question, which is where I begin from. That when I try to interrogate the situation of Kenya, I don't really understand why Kenya is really struggling with the question of ethnic minorities. When you look at the cases against Kenya, at the commission, at the committee and the court, 4 decisions, all of them involve ethnic minorities, Ogiek, the Nubians, the Endorois. And so I kept wondering, why is this the case? And the direction of my research veered more towards that direction than any other direction. And the main question I ask, as projected, is why does Kenya struggle with inclusion and respecting and fulfilling the rights of minority communities in Kenya? It's sort of contradictory in terms of when you look at the policy of Kenyan governments. We've had 4 changes in government now. When you look at the clamor for independence from the British imperialists, the major point that Kenya used to galvanize the people was questions of land rights and inclusion. Yet when it takes government, it does the same exact thing that the imperialists did. In my search for an answer, I came across Mahmoud Mamdani and Mazrui and a few other of my mentors that I will mention here. And they present this paradox, which is the native question. I'm sure by now all Africans have heard about it. How does a foreign minority rule over an indigenous majority group? And they had 2 mandates: to facilitate the colonial empire within the domestic jurisdiction that they occupied, in this case, Kenya, as well as to send resources back to the metropoles. London, Lisbon, wherever it is. And I also came across this question by Mazrui. He observes that the colonial epoch was very short, was a very short period of time. Now, to put it into context, he uses the case of Jomo Kenyatta, who was the first president of Kenya. When Jomo Kenyatta was born, the Kenya had not yet become a crown empire by the time Jomo Kenyatta was born. At the time when Kenya was gaining independence in 1963, the colonialists had gone, and Jomo Kenyatta outlived the colonial empire by 15 years as president of Kenya. So within the lifetime of one person, the imperialists were in and were out. Yet up to today, we still struggle with the question of the impact that they left in our country. My teacher, Humphrey Sipala, asks the other native question. At the point of independence, you would imagine the logical thing to do was that the political class was supposed to rectify all the historical injustices that had taken place. That was the logical thing to do. But this does not happen. So which brings us the concept of the other native question, which is now how can an indigenous majority rule over, control and dominate indigenous minorities. So these are the questions the politicians ask themselves. At least that is what we imagine, based on what history has shown us up to today. And the answer to this paradox is, again, what Mamdani and my teacher, Mwalimu Sipala, call the finesse of late colonialism. That by the time the British came to Kenya, they had mastered the art of colonialism, and it was no longer a question of trial and error. It was exact, precise execution. So a wealth of colonial experience from Latin America, from Asia, they'd done this for centuries, and they knew exactly what worked and what did not work. So, and you have to understand that the tool of the colonialists was always marginalization, and marginalization at very many respects. You know, persons with disabilities, women, children, and even ethnic minorities. But I will mostly concentrate on ethnic minorities because that is the subject of my conversation. To further try to understand this phenomenon that I grappled with as I kept researching, I encountered three paradigms, which I call the three critical junctures for which ethnic minorities at any one point in Kenya could have attained justice. In this sense, their rights would have been fulfilled by the state. In this sense, the state would have respected their rights. But I think the first two were missed, and which brings me to where I began, that the encounter with the African human rights system for me was the tipping point at which we see tangible progress at a certain degree towards the respect and fulfillment of the rights of ethnic minorities. So the first critical juncture was at independence. The rulers missed this opportunity. They did not put in place policies that would protect ethnic minorities, but they regurgitated, and as another author mentioned, they even did it better than their mentors in terms of marginalizing the already marginalized communities. The second critical juncture was the 2010 Constitution. A lot of noise has been made about this, a very incredible political power document. But even when you look at the cases, we have most of the cases, actually all the cases are decided after 2010. That is the cases against Kenya in the African Commission. When you read the facts and you read the encounter with, with the domestic systems, it seems that the Constitution did not immediately offer a solution. Now it does have very robust procedures, very robust provisions in the protection of at least marginalized groups. But the general understanding, at least by scholars of constitutional law and politics, is that it might take much, much more time, and it would not result in an immediate impact. So this brings us to the reason why I'm here, which is the encounter with the African human rights system. So the difference here, I would like to draw a difference between this third critical juncture and the first. In both instances, we have the state dealing with an external actor. At the beginning, at independence, the state was pushing away, or the government was pushing away the British imperialists, whose tool was marginalization, violence, and so forth. In the third critical juncture, the state is dealing with an external actor here. But this is the, the committee, the commission, the court. You could add the UN human rights system, but I am guided by the theme of the conference. And the difference between this third external party with the first is that this second external party is more interested in dialogue, is more interested in mutual assistance, is more interested in justice, and is not interested in violence. But there's a problem. When the cases are brought before the African Commission or the African Human Rights System, I also notice that there is not much of in-depth analysis of history to understand why, or the origin, the birth of these conflicts, the birth of these confrontations. In the case of minorities, first with the colonial government, second with the independence government. And so the African human rights system is put at a sort of a disadvantage because you are dealing with a conflict that has matured, a conflict that has been decades in the making. Yet you are called to answer the question and provide a sort of a one-stop solution immediately. And I think, based on what I have seen, is that a deeper understanding, a deeper appreciation of history would be welcome in terms of trying to find the solutions to some of these problems we are facing. So especially with ethnic minorities, in my case, that if we fail to really take account of history, to really try to dig deep and understand how did we get here, where did we come from, then we start to give a prescription of an answer that has not appreciated all the problems or all the ailments, as it were. So I will conclude by what was initially going to be the substance of my entire presentation and paper, which is what is the attitude, what is the conversation post the decisions. And when you read the decisions, when you read the literature on the decision of the African Commission, as well as the Committee of Experts on the Nubian community, you see there has been some progress. They have been given land, not conclusively, but there is some effort. They were recognized in the 2019 national census. The initial bureaucracies in terms of issuing identity cards to them have been cut down. They've been included in public service. I think they even have a special seat in the Nairobi County Assembly, which is their home resident, because Kibera is in Nairobi City County. There is registration of their children and issuance of birth certificates at birth. These were the main issues that were canvassed at the at the African Commission and the committee. But to conclude, my appreciation of the fact that history does not seem to play a central role in our understanding, in our dissection, in our appreciation of these issues, gave me a bit of problems. Like I mentioned initially, if you are dealing with a conflict that has matured over decades of making, then you need an equal understanding of all the paradigms, all the dimensions, everything that has brought us to this point, in order for us to prescribe the right medication if we were doctors. But I've seen so many doctors of law here, so I suppose we are still in the right room. So my conclusion would be that we need to confront history, and this confrontation is not a violent or a physical confrontation, but it has to be a very rigorous, a very intentional effort to try to understand where we are coming from, what are the dimensions, what are the variables, what keeps changing, and so forth and so on. And this way, the solutions that we will be able to produce or to, to end up with will not just be rooted in human rights, because human rights as a tool or human rights as a language in and of itself, and it has been acknowledged in this conference, is part of a wider conversation, is part of a wider political reality. So what are the social dynamics? What are the political dimensions that have an influence on the issues we are dealing with today? And I think for me, this would be the starting point to really go deep into history. And scholars like Walter Rodney have already given us tools in which, or in, tools that we can use to make this excavation. So thank you very much. And I'll hand over to the chair.
Sydney, for that very rich and informative presentation. Just by way of recap, Mr. Sydney has just challenged us on the need to place history where it belongs in the work of the Commission. He observed that in the 3 cases relating to Kenya, history did not seem to play it played some roles, but it did not play the type of role it is supposed to play. And he's arguing that if history has been properly placed well, probably it will have assisted implementation of the decision. So he traced the history of the problem of minority marginalization in Kenya to the colonial period. And he argued that not much analysis was done by the Commission with regards, or presented to the Commission, with regards to the history. So he also discussed some of the progress that have been made in the case. I think this presentation, just like the several other before it, has given us this multidisciplinary aspect that I think the prof that spoke in the afternoon talked about the need to touch on psychology and several other aspects that relate to the work of the Commission. So I think this is a very useful one. Thank you very much, Mr. Sydney. We'll quickly go to the second presentation now, and that is going to be by Dr. Esther Gumbo. She's going to tell us something about stagnancy amidst judicial activism, the implementation of the 2017 principles on the declassification and decriminalization of petty offenses in Malawi. Dr. Gumbo, you have the floor. 15 minutes.
Thank you, Chair. So my presentation is mainly on the progress that has been made in Malawi on decriminalizing or declassifying petty offenses. So within the theme of this conference, I try to bring that into the impact that the decisions of the African Commission have had in terms of that process. So I'm sure most of us would not have any issues when the police arrest someone who's killed another, or someone who has burnt down another's house deliberately and things like that. Would actually applaud them because they're actually trying to prevent crime and minimize harm and all that. But I'm sure many of us would actually frown if the police go about arresting the poor who are out on the street begging for a living, those who are unemployed and are trying to make a living in ways that may seem to be uncomfortable to those who are doing better. So that is really the gist of the decriminalization principles that the Commission adopted in 2018, which try to urge states to move away from those kinds of laws. So at the very beginning, I just want to say a bit about what petty offenses are. I remember during the drafting of these principles, it was decided deliberately not to define petty offenses exhaustively because it's not possible. So the definition veers around the fact that these are non-serious offenses. They may be called different things in different countries. Others may call them minor offenses or summary offenses, but they are mainly characterized by lenient or relatively lenient punishment. So I'll put the lenient there in quotation marks because if the sentence is 3 months imprisonment, it's not lenient at all for someone who's been convicted for begging in a public place. So there are so many examples, being a rogue and vagabond like we have back home, being an idle and disorderly person, loitering, and so many others that most countries have. So these petty offenses are generally undesirable. They strike right at the intersection between poverty, justice, and human rights. So in essence, they do not criminalize conduct which is objectively offensive or objectively harmful. So the main criticism is that these offenses actually criminalize status. They criminalize the homeless. They criminalize poverty. They criminalize employment, unemployment, as seen in those offenses which, for example, would penalize those who do not have any subsistent form of income. And this brings it within a lot of human rights violations which are inherent in the way that these offenses are actually enacted. So most of these offenses would infringe the right to liberty, the right to dignity, and a host of other rights. So the decriminalization principles call for states to decriminalize or declassify these offenses. So declassification will be where the offense might just be downgraded, for instance, from being an arrestable offense to one which is more minor in terms of enforcement. That is where it is seen that the offense itself actually does serve a public good. The principles also call for alternatives to arrest. They call on states to address the root causes of poverty. They encourage states to provide legal representation for all and also for further training of the police. So getting back to Malawi, we've got a host of these offenses. So we've got rogues and vagabonds, which I'll deal with, idle and disorderly persons, loitering, begging, and a lot of other offenses. So I'll focus on section 184 of the Penal Code because the two cases which I want to look at actually dealt with that section. So the first is a section which actually criminalizes every suspected person or a reputed thief who has no visible means of subsistence and cannot give a good account of himself. The other offense under that section criminalizes any person who is found in generally a public place and the time or the circumstances in which they are found at that place actually gives rise to a reasonable suspicion that they intend to commit a crime or they are there for a disorderly purpose. We've got more offenses in section 180, but I'm going to skip those because they are not really part of the cases. So just to stress that although the presentation is within the framework of the decriminalization principles, in reality, the Malawian courts have actually frowned upon these offenses for a long time. So outside of the African Commission's work or recent campaigns. So they've mainly pointed out failures at both the judiciary and policing level, evidential concerns where the police simply arrest the poor. You're found out in the streets at night, regardless of how you explain your presence there, there is still an issue. There are also procedural concerns regarding how arrests are made, how guilty pleas at times are coerced, and how the trials for these offenses are often where you have maybe at times 50 accused persons in your courtroom. So you've got one case citing 50 accused persons. So these are just examples of where the courts have actually expressed their displeasure with these offenses. For instance, saying that it is not really an offense to be poor and to be out in the street at night. So that's just an example of another case where the court was pointing out that the way in which the lower court had actually dealt with the case was not in line with procedure. So the lower courts, where the bulk of these offenses are actually tried, are unable to rectify the problems that have occurred at policing. So in a way, they actually legitimize the illegalities themselves. So I'll skip this. It's just another example of that. So coming to the two cases which I want to look at, the first is that of Gwanda versus the state, which was a constitutional challenge. So that is Gwanda there in purple. And as you can see, he's actually, or at least at the time, he was a street vendor selling plastic. And he was actually arrested on his way to his place of business in the early morning. And he was charged in terms of section 184(1)(c), where the police alleged that the circumstances in which he was found were actually raising a suspicion that he was there for an unlawful purpose. That is actually regardless of what he had explained. So this constitutional challenge was supported by civil society, and it led to the court actually declaring that section unconstitutional, and that was quite a blow to the policing, from a policing perspective, for those who are still in favor of these offenses, because it is actually one of the most common vagrancy laws in Malawi. So although we have a lot of them, this seemed to be the one which the police could easily apply. In terms of relying on the African Commission decisions, there wasn't much in this first case. So this was before the decriminalization principles, but the court was able to draw on the Rwanda guidelines and a few other cases from the African Commission. However, the relief sought was a bit narrow. So the applicant only sought to actually declare the offense unconstitutional. It did not touch on the policing mechanisms like mass arrests and sweeping exercises that also bring with them a host of other offenses, a lot of other violations. So it left those policing mechanisms intact, and that actually meant that the police were still able to utilize the same offensive tactics to implement the other offenses. So in 2022, another case was brought before the High Court, this time dealing with section 184(1)(b) of the Penal Code. This now, because we don't have 184(1)(c), the favorite, so this now had a broader range of relief. And the section itself, as I said earlier, tries to criminalizes every suspected person or reputed thief who has no visible means of subsistence and cannot give a good account of themselves. So this actually came as a judicial review matter. The constitutional aspect of it, I'm told, is still pending for certification. So in this case as well, which was now post the principles themselves, the court drew on a lot of decisions of the African Commission. As you can see from there, the court also drew from the Palu opinion, the advisory opinion, which was brought before the African Court. And the court actually stressed that these decisions actually reflect local laws and jurisprudence. So in other words, the African Commission decisions were not seen as posing a challenge in terms of applicability, because in the context of Malawi's own international, regional, and constitutional obligations, and even our own jurisprudence, there is support for that. So the court found in favor of the applicant in all of those issues. It said that sweeping arrests were actually unlawful and unconstitutional. Guilty pleas cannot be coerced. These seem really to be obvious things, which one should wonder why the police are actually unable to comply with. A compensation order was also made, and the police were also ordered to develop proper guidelines for sweeping exercises. The court also ventured on its own additional orders. So here the court requested the executive through various ministries to review the entire section 184. So section 184, I think it's got about 5, if not 6 offenses, petty offenses. And it also asked them to work on any gaps that there might be in the law within 24 months. The court was also reminded the executive and the legislature to comply with the earlier decision in Gwanda regarding reforms that had to be made. and it required a review of the training of police. So when I look at the jurisprudence itself, it has been held as being progressive, that it entrenches the protection of human rights and protects the poor and the vulnerable. But there are a few aspects of the decisions themselves which I find to be a bit unsettling. There's a general criticisms with High Court and also Supreme Court decisions in Malawi that they're a bit too quick to import foreign law. So foreign law can be used, but only as an interpretative aid in the decisions of the courts. So while the court draws on all of these decisions, one can actually see by reading how the court uses them that it's like a lot of them are just thrown in there. So the court is actually eager, especially in the case of Banda, the court was very eager to incorporate a lot of African Commission decisions. And I think that sort of renders it open to criticism and doesn't develop our own local jurisprudence in the way that it should be. So although the court says that these decisions of the African Commission actually reflect our own local laws, there is not much that the court does in terms of cross-referencing the two. There's also a problem, again, as well, I think, with the courts being eager to see these petty offenses gone after saying this for so long, that the judgments seem to be, especially the Banda judgment, seem to be a bit defective. So the court at times makes findings without substantiating how it gets to that finding, or the court may, for instance, when it makes a compensation order, it makes the compensation order, then in the next paragraph tries to justify that order. And so that leaves some of the findings against the state unsubstantiated. There are also other ultra-vires findings, especially in the Banda case. So you may recall here when I said that, let me just get to the Banda case. For instance, here where the court was making these additional orders, you can see that the orders are quite broad, and they're not really things that were before the court. This was a judicial review matter, so, but the court went on quoting a lot of African Commission decisions and others to render the entire section 184 subject to review for unconstitutionality. So that also seems to be quite a problem. So in terms of obstacles to implementation, I incorporated this after a talk from one of the commissioners. I only see it as maybe being one which falls within the political will arena, because in terms of the legal, the courts seem to see these decisions as already being in line with our own laws and jurisprudence. In terms of structure, it would actually save the state a lot if these offenses are done away with. They play very little in terms of crime prevention, although others hold a different view. So for strategies on implementation, obviously civil society still sits at the top. Both of these cases were supported by the Southern Africa Litigation Center and CREA in the background, and maybe a few others, but we need to have more actors. The legislature, I think that's actually the first prize, getting these offenses actually repealed, because the piecemeal fashion which seems to be playing out is not sustainable, is expensive, and takes a lot of time. On the judiciary's part, the judiciary may be frustrated, but that's actually the upper courts, the superior courts. The lower courts keep on making these problems. And I was asking myself, why are the lower courts still legitimizing these violations that occur at policing? And I thought about my own experience as a magistrate. Magistrates are just overwhelmed. So you're overwhelmed, you've got too many cases, you've got 50 accused persons brought to you, they are standing in rows in the dock, some even outside the dock. To even think of bringing out of that 50 different cases on your own roll is unthinkable. And also, for that, then the Superior Court should actually do something about that. And also just sharing the decisions that are there. Access to case law, even for magistrates, is still an issue. So while the Superior Courts might be saying that the lower courts keep making these mistakes, it's a different question to ask, to say, do the lower courts actually know about all these decisions? In terms of the executive, I think there is mainly proactivity. They need to be more proactive instead of waiting to be told what I think at times is just the most obvious. Okay, thank you.
Thank you, Dr. Esther Gumbo, for that very informative presentation. This is a very good aspect and perspective to the work of the Commission. We have often said that in the work of understanding the impact of the decisions of the Commission, there are various aspects to look at. For example, we talk about the direct impact of the decisions, the indirect impact, the immediate impact, and the eventual impact. These are various dimensions. For example, what she has just discussed has been found to be applicable in several African countries where national judiciaries rely on decisions of the African Commission in order to make, to argue or to support the claims of an applicant. And I think that is a very useful and powerful contribution from the African Commission. I can say this very well in relation to Nigeria. So I would say that, of course, it might be unfair criticism if all we look at is the rate of compliance and implementation. In the area of impact, the African Commission is a superb human rights organization in Africa. It has done so well. In fact, we have cases in relation to amicable settlement, for example, where just because a communication has been submitted before the date for hearing, the government will quickly go and remedy the complaint. So these are various dimensions, and Dr. Gumbo, thank you for this perspective that you have brought in. So she has talked to us about decriminalization of petty offenses in Malawi. Initially, I was asking what is the relationship with the Commission, but we have seen clearly that in those cases, the courts have relied on decisions of the Commission in Pruitt and the Gambia and several other decisions, Horilos and Nigeria and several other decisions of the African Commission. I won't say much, but just to add that this is also in line with transnational judicial communication. The idea that national judiciary will want to have a communication or conversation with the African Commission, and it is a form of spillover effect or knock-on effect, like a ripple effect, an unanticipated effect of the decision of the African Commission. So I shouldn't say too much about this because we have the respected and distinguished Executive Secretary of the African Commission, Ms. Abiola Idowu-Ojo, who is to make a response to the two presentations. So I call on Ms. Abiola. Please, you have 10 minutes.
Thank you so much to the two presenters, Mr. Sidney Tambasi, as well as Dr. Esther Gumbo. Mr. Sidney Tambasi, I was particularly moved by your presentation, which underscored the need to have a multidisciplinary approach to the question of human rights. It underscored the fact that human rights is not just a legal question. There are multi dimensions to the human rights issues. And I would like to highlight that while this might not have played out in many cases before the Commission, that the cases that you cited, and particularly those related to the rights of indigenous persons, the Endorois case, the Nubian case, indigenous and minority groups, as well as the Ogiek matter that was eventually then filed by the Commission before the court, were all cases that spoke to histories of injustices meted out to these various groups. Particularly in the Oge case, as was submitted before the court, there was a thorough mapping out of the history of displacements that was suffered by the Ogiek people. And I think this is one thing that distinguishes these cases. And in particular, I believe that one of the points that the Commission has also underscored when it comes to historical injustices is the fact that the Charter does not only apply to situations that occur only after a state has adopted the African Charter, or has ratified the African Charter rather, but applies to historical injustices that continue, that started before and that continue even after a state has ratified the African Charter. So it's a recognition of the fact that continuing violations are considered by the Commission as being as giving it the jurisdiction to look into those matters, and that the Commission gives attention to history of injustices to victims that are brought before it. So I really appreciate this perspective. And for me, it was refreshing because you focused a lot more on the context than the legal questions and the actual findings of the Commission. So it was really a very, I found it very reflective. And I think you've put a lot on, with what you've said, you've actually requested the Commission to give more attention to this comprehensive and multidisciplinary perspective. And I think that there are opportunities for the Commission to do so, particularly given the fact that it has special mechanisms that look at some of these thematic matters. We have the chairperson of the Working Group on Indigenous Persons and Minorities here. And one of the things that the Commission is also mindful of is that it doesn't necessarily have a mastery of everything. And so when there are thematic issues that are coming before it, where it feels that it needs to further understand the context, the history, and the factual issues, okay. The first thing that it does is to conduct a study to try and understand those thematic issues itself. And this is where the Commission started with respect to the rights of Indigenous persons. And right now, it's looking into the issue of minorities. It has now extended the mandate of that working group to look at the issue of minorities. So another opportunity that the Commission has to be able to have this multidisciplinary approach is provided for in its rules of procedure, particularly rules 101, 103, and 104 of the 2020 rules. These rules allow the Commission to hear experts that enable the Commission to better understand either technical issues or factual matters. So the Commission does not limit itself to legal issues. It also, can invite people that can elaborate the factual matters, historical issues, underpinning matters that are before the African Commission. So thank you for drawing our attention to this matter, and we will give further focus to this issue, and perhaps at the level of a secretariat. Perhaps this is one of the things that we need to flesh out more, because we're looking at some of our procedures that we've not really been making use of, like amicus curiae. Now it's better elaborated in the 2020 rules. Now we're working on practice directives for utilizing that procedure. We're looking at amicable settlement, which we need to use more. So I believe that this is also an area that you pointed us in the direction of. So we appreciate that. And then just to say specifically with respect to the Nubian case that you mentioned, as well as the Android case, again, you reminded us of what was also said by a couple of presenters earlier today, and I believe even yesterday, that implementation is not a one-off process necessarily in many contexts, especially if you're dealing with human rights violations of a continuing nature. And in this context, you've pointed out some of the changes that have been experienced by the Nubian community in Kenya. And I think most of these cases that you mentioned, the Nubian case was filed in 2006. The Android case, I think, was filed in 2000 and Those cases were between 2006, OGEC was 2008. They were all, well, I think it was only the Endores case that had been concluded by 2010. And all of these cases were all before the 2010 constitutional review by Kenya. And we all know how that constitution in the list recognized indigenous people as a vulnerable population and also gave a certain protection, recognized community land rights and things like that, which were not in existence before then. So we believe that this case and many other micro activisms that were taking place around these cases and even around some related matters must have motivated the changes that then happened with respect to the 2010 constitution. And this is where the roles of the diverse actors that work with the African human rights system then comes in that even while the case is pending before the commission, there can be a lot of activism around the case that is pending before the commission to move the legislative and policy frameworks in place at national level. Another point that I think I would like to also speak to in the context of what you addressed is the fact that even when there are legislative changes that happen while the case is before the commission still goes ahead to make its pronouncements so that it can put its mark on the matters that have been brought before it, and also to be able to pronounce international best practices and standards on those matters. And this was why even in the OGEC case, when the commission was filing the case before the court, the commission in this case was the applicant before the African court. The government of Kenya had argued that, but we've made changes to the constitution, but some of these things have been addressed, and the commission reminded the court of its decision in the Sarah case, the Socioeconomic Rights Action Center case against Nigeria, that matters are determined based on the facts as were presented as at the time that the violations occurred. And this was also the position that the commission took in the Sarah case. Otherwise, the government, by then we had the new government in Nigeria that had put some measures in place, the Niger Delta Development Commission and all of that, but the commission still made its pronouncements. And that's why we have the jurisprudence that we have up until today. So that's another approach that the commission has taken in respect of matters that come before it, even when legislative changes or institutional changes happen while the case is before the African Commission. So thank you so much for this perspective. I also like to thank Dr. Gumbo for again giving us hope that indeed the work that the Commission is doing is affecting the landscape at the national system in different ways. We've heard about how courts, cite some of the decisions of the Commission. We've heard about how it has influenced, constitutional reviews and so many other contexts that have been described. And this is quite, it gives hope that what the Commission is doing, especially in the elaboration of soft law instruments that go a long way to unpack and clarify the provisions of the African Commission, that they are indeed useful and relevant and that they're making a difference in the national context. So I want to thank you for drawing our attention to the Kenyan experience in this particular matter. Thank you so much. Thank you.
Thank you so much, Madam Abiola, for your very rich contribution. So at this point, we'd like to throw the floor open for questions, comments, reflections. Maybe you have something to say on the Malawian situation or the presentation in relation to Kenya. So please, let's direct the questions to the presenters. Comments?
Apologies, I meant Malawian experience, not Kenyan. Please, apologies. There was a lot of Kenya from...
okay. Honorable Commissioner.
Thank you very much for the floor. I am taking the floor because I see a linkage between the two presentations. I think the first presenter presented a colonial mindset. A colonial mindset in the way the law is being applied. by our member states. And sure enough, all our law is based on common law, Roman, and all that. And now I understand from Dr. Esther's presentation why a petty thief is given such a harsh judgment by our courts. And you wonder why a petty thief is being asked or being loaded with such a huge fine and a huge thief. And we are talking about former, well-organized crime and criminals are almost set free with a small bail. And so if you look at the first presentation and you take the big thief to be the colonial minority, the big thief, and the small thief to be the African, the indigenous, the majority, then you can see we are literally applying law with the wrong mindset. So mine is just to say that I hope this is enough reason for us to just interrogate that alone, because our courts are busy doing petty stuff when huge thieves are running away with all the big crimes and all this. So I think we need to balance this hammer business. I think we are hammering the wrong people, and these are now the Africans who are free. They are, the population is high. I mean, I had the word vagabond in boarding school 40-something years ago from a white nun. And now I'm hearing it again. It's in court, and this is how we think, and this is how we are passing judgment. I think we have work to do on this area so that we shift the mindset, so that we make sure the law catches the right people. I thank you.
Thank you, Honorable Dr. Litha, for that intervention. Just we have the opportunity for only one question. So we have one here. Thank you. Okay. Oh, okay. Yes. So we'll take one more online. Thank you. You have.
Yeah. Hi. Thank you for the opportunity. I don't know if you can hear me. Hello?
Yes, we can hear you. Please go ahead.
All right. Thank you for the two great presentations. I have some quick questions. On Dr. Gumbo, I'm doing a research for my Master of Science in Gender and Development with Luana. And one of the things I'm assessing is the issue of the role of judiciary. And two key issues that came out from the research is the issue of access to case law by the lower courts and the issue of backlog of work. I don't know if you can clarify for me whether the issue of access to case law by the lower courts, the whole issue of the role of the African Commission and then the jurisprudence that is coming from the African Commission, don't you think that's widening the gap between the lower courts and the lower courts and the high court? By the way, I'm assessing, my research assesses neutrality of law on sexual and gender-based violence in Malawi feminist jurisprudence. The second one on the backlog of work. So when this one had to do with, I was assessing the disparities of the judiciary on the issue of the corroboration rule when it came to issues of SGBV, especially rape and defilement. So they used backlog of work as a reason why the lower courts would not abide by higher court's declaration of outlawing the corroboration rule. I think this was the judgment, Fiona Mwale's judgment on Kaliati v. the Republic case. So I just wanted to know as well if this backlog of work, if is not used as an excuse, and also worsening how they can then adopt a jurisprudence that is also coming from the African court. I'm glad the convener mentioned something about transnational judicial communication and its ripple effect. I don't think that would work in such a situation in Malawi, but I just wanted your thoughts on that. And on the first presenter, I think that was also a great presentation on the historical background, but maybe from the Commission, I would like to understand why the Commission hasn't utilized the historical legal approach and the scholarship that is coming from the University of Pretoria that has gone into the history and then found out that there were anthropological maybe oversights when it comes to issues of minority rights, and that the epistemology that is currently being promoted now that says homosexuality is an African and it's against African values contravenes the new scholarship that has a new epistemology that refutes all that. So I wanted to know how exactly the African Commission is really taking in the advice that is coming up. I think that's also from my second research. That comes from my second research with the center, because I'm doing a Master of Philosophy in Sexual and Reproductive Rights, and I'm assessing jurisprudence.
Thank you for your question. Please let's take the second question quickly so the presenters can respond at once. Thank you.
Yeah, many thanks to the presenters. To Sydney, I think it's been a very powerful presentation, changing the dynamics from which most of us view implementation. And it's very good to delve into the colonial question in a settler colony, in a settler colony like Kenya. But maybe the insights I would like you to clarify is how do you think then we can apply a decolonial framework towards effective implementation of the Nubian, Ogiek, and Edres decisions? So to Dr. Dr. Gumbo, I had to confirm the name instead of using the wrong name. I think it's also a very insightful presentation. We are at the Network of African National Human Rights Institutions. We are collaborating with the African Policing Civilian Oversight Forum to develop a scorecard that is measuring the extent to which member states have domesticated the principles on decriminalization of petty offenses. And we are looking at the executive, the legislature, and the judiciary. And I think the case study you've presented is very important and insightful in relation to the judiciary. But two questions. One, I think you've mentioned something very important about over-reliance on the decisions of the Commission. I think as implementation scholars would like to see more reliance on the decisions of the Commission by national judiciaries. So when you talk of over-reliance, maybe you can clarify what you mean by that. And secondly is why, despite all these progressive judicial reforms, why we are not seeing them translate into legislative reforms and seeing all these laws being repealed by the legislature, and seeing enactment of more progressive regimes that do not criminalize petty offenses. Thank you.
Thank you very much for the question. So let's start from Dr. Esther Gumbo. Please respond to the questions.
Thank you. On the question of whether backlog, the backlog argument is just an excuse, I don't think it's a lame excuse. I think backlog is a real issue. I may not know much about the context within which you're carrying out your study, but contextualizing this within the paper on vagrancy offenses and how they are policed, as I mentioned, the issue of misjoinder of accused person there is one of the biggest ones. So where you actually have 40 accused persons, all of them attending court at the same time, that is really an issue, because it's not an issue of the judicial officers not really knowing how to handle guilty pleas or how to verify them, because the same judicial officers actually do the correct things in different cases. So why is it that in these particular cases, then they seem to get the procedure wrong? So I think the backlog issue does play a role. And I think that in that case, the judiciary can also be more proactive where backlog issues are being brought up. So for instance, in the context of my paper, again, just having the registry not register cases where you've got so many accused persons. I think those cases have to be sent back for proper charging by the state. And then I think your second question touched on, okay, I don't think that was second question, but a related point to that I wanted to raise was on the issue of backlog and not deciding cases correctly. I think there the link is not as straightforward. So I think also an issue of judicial accountability. You cannot really cite backlog as an issue there. Then coming to the question on APCOF, the over-reliance on foreign laws there, what I meant was that it seems that in some cases the courts cite solely African Commission decisions or maybe South African decisions and then proceed to make a finding. Generally, scholars there agree that that is incorrect. Firstly, that is not our primary source of law. It is there to act as an interpretative aid. So if you already have local jurisprudence already touching on that point, you need to start there or at least draw a proper link on that, on how that foreign law actually becomes helpful in that context. You are then also developing jurisprudence that is already available. So the decisions may sneak in, but not as a primary thing without further interrogation or contextualization. Lastly, on why these offenses still remain, maybe Pacharo can say more on that in terms of what they have done in terms of engagement. I know there've been some campaigns on decriminalization, but from the case law, it seems that nothing much is being done. So maybe I think it's political will. I was actually surprised to hear that the head of the training school or some top police persons actually have a change of mind or heart when it comes to these kinds of things, because I don't think that is actually translating into action. There seems to be no censure for police indiscretions with regard to sweeping arrests and things like that. So I think that is a more complex question. Thanks.
Thank you, Dr. Esther. Mr. Sidney, please, 30 seconds to respond to the second.
Thank you, Victor. In response to the question by Deborah on how we can apply a decolonial mindset when handling the question of implementation of decisions, I will go back to where I finished. That is Walter Rodney. He gives us a framework and says that whenever you're faced with a problem, the first thing and one of the most robust tools you do is you historicize. Now, when you historicize, there's always a complication that, and all of us in research know about law and effect. You move a few steps back and you find something that you think is the cause of your problem. But in essence, when you move even further, you discover that that thing that you thought was the cause was an effect in and of itself. And so for me, the idea is to properly historicize. You have to really go back, to use the words of Suzanne Marx, go to the root cause of the problem. And then Dr. Litha has mentioned our problem with hammering. So you can imagine the predicament when you meet an effect which you think is the cause, and then you hammer it with a solution. You're not treating the problem. So I think it calls for a lot of patience, but the idea is to really, really go back and use the proper tools to really understand what the origin of a problem is. And you could discover that sometimes the solution was not perhaps as overly complicated as you would have otherwise prescribed. Thank you very much.
Thank you, Mr. Sidney. I believe the African Commission Secretary has some comments. Please, you can go ahead.
Thank you so much. I'll try to be brief. I just want to address the question or the comment that was made about why the Commission has not been adopting a historical approach, or should I say, as my commissioner has just said, a contextual and comprehensive approach to the issues that are presented before it. I'd like to say that in at least the cases cited by Mr. Sidney, this was the approach that the Commission took. In the Nubian case, the Commission had to make a determination on whether they had rights over the Kibera settlement, and it had to trace back, go back in history. And the Commission subsequently took a decision that their tenure, the security of tenure in relation to the Kibera settlement should be guaranteed by the government. Also in the Ogiek matter, in the case that was submitted before the court, the Commission mapped out the history of dispersions and displacement and evictions of the Ogiek people. And among other things, the Commission requested for a full apology for what had happened over the years, requested for a public monument, in addition to asking for their legal and political recognition. But I would like to say in conclusion that don't forget that the Commission deals with cases based on the facts that are presented before it. So the primary responsibility is for the complainants going before the Commission to give this dimensional perspective to the Commission. But what we are taking away from this conversation, and which is critical for us as a Commission, is that there is that recognition. It might have, played out in our jurisprudence without us being fully conscious of it. But this is an awakening, a reawakening that indeed human rights are not just a legal question, but they could be multidisciplinary and multidimensional in nature. And so that's one. And then secondly, for the Commission to be more alive to the processes that it has by which it can then, educate itself on contextual and historical matters as they pertain to the cases that are brought before it. But primarily, this would be the obligation of the parties bringing cases before the Commission, even for cases that are going to be referred to the court, because one of the questions I've been asking at the Commission is, what is the role of the original complainant, even in these cases? Because the Commission does not have on-ground presence in member states. And as such, it relies largely on facts that are brought before it, which it tries through its various working methods to verify and to establish. Thank you.
Oh, thank you, Madam Abiola. I think this is the right place to draw the curtain for the discussion today. But one important takeaway, like Madam Abiola said, is that human rights are not just legal questions. And I want to say that implementation of decisions of the African Commission too are not just legal questions. In fact, research have shown that social mobilization is the most important factor that engenders or triggers impact of decision. So the decisions are tools which we can take to our various countries and mobilize around them. So I want to encourage each and every one of us to continue to mobilize around decisions of the African Commission. I want to thank the two presenters, Dr. Esther and then Mr. Sidney. I also want to thank Madam Abiola for the contribution. Thank you, everyone. Thank you. I hand over to the moderator.
I think for persevering through the afternoon, we can also give ourselves a round of applause. There are no special announcements, and I think this marks the end of the day. Tomorrow we start again at the same time. We start arriving at 8:30 so that we can kick off at 9 hours. I'm being reminded that there are still drinks that can be taken to the rooms as we leave. So thank you very much. I hope you have a good rest and that we can come back tomorrow and fully engage. Enjoy the rest of the evening and dinner.